Behind every crime lies a story waiting to be uncovered, from chilling mysteries to untold truth. This is where the darkness comes to light.
Courtroom buzz lights up the air, faces tense as stories tear, truth and lies like a tangled dance. Justice here takes no chance. Gavel strikes, hearts beat fast. Witness takes stand, shadows cast. Whispers loud like wildfire spread. In this game, none's ahead.
Hello, good morning, everybody. Hi, it's DCA here. It's Wednesday. Happy Hump Day. We made through half of the week. Yes, it is a beautiful, wonderful, hot day in the UK today. I need to see exactly how much it is right now because I am absolutely boiling and I don't do well in heat. I mean, I think London it's worse than I am right now. So the temperature right now where I live is 71 degrees in this obviously Fahrenheit, and down in London it's 76, which for UK, and let me tell you, for UK this is summer temperatures. This is like temperature that we have during the summer, when like the highest point in the summer. So just for comparison, in Houston at 8 o'clock in the morning, well, it's a couple of minutes to 8 o'clock in the morning, it's already 76. If I'm complaining about this and it's already here 2 o'clock in the afternoon, I'm complaining that it's this temperature, and I'm already complaining. If I would live in Houston, in Texas, definitely I would not be in this bounds of this earth. 70, yeah. Well, see, I agree. Well, that is called Philoas in Florida. Like, so this for us is literally very very warm. Um, to be fair, I don't know if it is unseasonably warm or not. I don't know. I don't watch the news, so got no clue. Hey, Iowa backyard. Good morning, my friends. Oh my days, I did not say did the good morning, everyone. Good morning, Iowa. Good morning, Lois. Hi, Benny. Good morning, Haseo, my dear friend. You are here. Hi, hello, Paula. Good morning. Good morning, Zizzy. Out in the bounds of South Carolina. Sorry, nearly put my feet. I hope everyone is doing good. We are about to start day 3 on which is hotter, Portugal or UK. Definitely Portugal. With no bounds of leaps. So I hope everyone is doing all right. So in Portugal right now, it is not that warm. Actually, it's warmer here in the UK than actually in Portugal, in Lisbon, where I'm from. But in Lisbon it's 65 right now, which for them it's the average, but it's gonna get hotter. But finally they have power back. Yes, they did. Literally, I couldn't get in touch with my mom. I couldn't get in touch with no one of my family because everyone did not had internet, did not had no power to charge phones, no nothing. They had no cellular network. They had nothing. It was a crazy 15 hours. Oh, my days. Thank you very much. Hey, Batgirl got it. Nice. Well done. Thank you very much, Flowers. Oh, my days. You are so amazing. I really, really appreciate you. You are. Thank you for the support. We miss you. Oh, you were shooting at Iowa. I think Iowa moved a little bit to the central, but well, that girl is still awesome. She's been on regularly lately. But that's really awesome. Thank you very much for the support. I have to say apologies in advance for the no camera today. If you were not here yesterday at the end of the day, I was not feeling very well because when it gets really hot and really warm, I don't do well, and my blood pressure sometimes has the tendency to go really low, and I suffer with that. I've suffered with this for most of all my life. So I got very very dizzy at the end, and Garden Bot had to take over. I'm feeling fine now. I am feeling better, but I'm a little bit sluggish and I'm a little bit not feeling great. So, and you know, that's how I am. I am a perfectionist, so I was not going to take the day off because it's not a tired thing. It's just one of those things. So of course I'm still here. I'm gonna be doing this, and we're gonna be following this trial. So, which, talking about the trial, it hasn't started, don't worry. I have the feed in there, but it's still during the recap from yesterday, which, yes, we can listen, but I know you like hearing me talk with no avail. uh and I just thought to talk a little bit with you all and say where we are in terms of this case and what's next and what's happening. I mean, because yesterday, right, we are going to be doing we saw the first part of the Jennifer McCabe testimony in the Karen Reid trial, and that was very good, and we want to watch the rest, and we will. We're not going to carry on. I think I was thinking of like catching up on the trial, on the Karen Reid trial, and we might do that if there's nothing else to cover. If I absolutely cannot find any other trial that I cannot find for the next week or so, we might watch some spiciness of the Karen Reid trial. We are not going to do all of it. We're not going to be following all of it, but we just might just watch as in terms of when we have a downtime trial, but not the full entirety. But that definitely the spiciness of the Jennifer McCabe, especially the cross. Of that trial, we are going to be looking, and we are going to be watching either today after court or maybe tomorrow or something. So don't worry, we're going to be looking into that, because I know yesterday we really enjoyed doing that. But today we carry on with the coverage of the Christopher Schurr trial. So is standing trial for the murder of Patrick Lyoya, and today's day 3. I'm going to say something that I said yesterday, and Zio did not agree with me. But I was reading on a news article this morning, and I found out that witness that is currently on the stand, right, is going to be the last witness for the prosecution. So prosecution is going to rest today, and then defense starts their case in chief. They do say have the witnesses to come. I don't know if Christopher is going to testify. I'm going to make a poll when court starts and when things get to move on. I'm going to make a poll or to see what you guys think, if if he's going to testify or not. But definitely want your guys' opinion to know that. Sorry, just looking at something. So we're gonna have the final witness for the prosecution. This case, we might even be on verdict watch tomorrow. I don't know. What do you guys think? I mean, it's gonna be a short trial. They did say it was gonna be like a week trial, not even that. We're on day 3, and the prosecution is already gonna arrest. It's not gonna even be a full day for the prosecution. It's gonna be like half of a day for them. So we'll see what happens. But yeah, I mean, I like short and sweet trials. It's the kind of trials I really like to cover is trials that they get there open, because my attention span, it sometimes is not the best, and it doesn't stay on the same place for long. So yeah, we definitely need a good speedy case, and it's good because then we can catch up on other things, because Donna Adelson has a hearing today. I think it's at 4 p.m. Eastern time, Florida time, because she's in Florida. So which is going to be about like 9 p.m. for me. So if we don't, because if Jennifer doesn't get finished today, oh, actually, I just had an idea, because I don't know how long it's going to be, her testimony. What we could do is we could do Jennifer McCabe while we are on verdict watch for this trial, because I think by tomorrow we're going to be in verdict watch. I think we're going to be very, very soon in verdict watch with this trial. So during that trial, do that verdict watch, we always struggle to, what to watch and what to do and everything. And we are in that middle ground where we cannot really start the trial sometimes, and so we are waiting for this to finish. And Jennifer McCabe is going to be a very long testimony. We all know that. She's going to probably spend most of the day, if not the whole day there today. And the cross is going to get spiciness. So I was thinking maybe we could watch her testimony definitely tomorrow. Well, I'm assuming it's tomorrow. I'm not seeing the defense having um a big defense on it. I think it's going to be more Christopher testifying than or anything else. But yeah, that is my opinion. What do you guys think? Um, in terms of updates, there is no, court is on a half an hour delay, so obviously we are going to be waiting for court to start. Court feed is going to go live before then. Maybe in a bit we'll hear a little bit of the we're gonna hear a little bit of a recap of the day yesterday, like our feed is very nicely doing it for us. Maybe we're gonna listen that for a bit before court starts, and then yeah. Okay, fair enough, and I can see your side, Benny. Thank you very much for that. State has put some evidence towards it. It has been a lot of technical yesterday. I did miss somewhat of the first day, but I respect that opinion, and I really really appreciate that opinion. And we'll see what the jury is going to have to do it. So I still need to create the verdict form for this case, because this morning I just took the morning easy morning this morning, and I was just chilling. I did a video actually with Zio on a very other spicy case that is going on in Tennessee. We check that out. Sadly, is another police involved trial. That trial we decided not to cover because this one showed up first, and what showed up first we covered. So that's why we are in year one. If the other one wouldn't have showed up first, who knows? We probably would be covering that one. It's just one of those things. So like I said, we're just gonna hear for a little bit the recap of yesterday and what the opinion of the 13 on your side has on this case, which I am very intrigued about, and because also they are doing a recap for us for this trial, because we know we missed a bit of the testimony yesterday because it was very boring. Let's be honest. And then yeah. Oh no, that's okay. It's absolutely fine. No worries, Paula. We'll keep you informed of anything, and you can pop in and out. But I appreciate you being here today. I hope your day goes quick today, and I hope everyone is safe around your area, because I know that you had very bad storms, tornadoes, and everything in your side of neck of the woods. So let's start watching. No, they are showing this gentleman. Let's see what he has to say about it. Let me.
I was
Here you go.
deeply troubled by the fact that this was allowed. I spoke with a number of my fellow colleagues last night about their take on it, and their take was the same as mine, that this is a criminal case in the state of Michigan. There's nothing in the jury instructions that's going to talk anything about officer created jeopardy, or that you got to follow the standards, or you got to issue a warning. I mean, imagine having to issue a warning if somebody's stabbing you. You say, "Stop stabbing me, or I'm going to shoot." That it just, to me, is I'm just stunned that this was allowed. I thought the defense did a very good job trying to counter it, even though it was allowed. I presume they've got experts that are going to testify that just how ridiculous that requirement is, because it would be more appropriate in a civil case when it's about money damages, but not in a criminal case when it's about whether or not Officer Schurr acted with justification or not. And that brings me to why. So there's a specific rule of evidence that applies to this, and the rule says that experts are not allowed to testify to the ultimate issue. The ultimate issue being, is this with or without with justification? And what was allowed to happen was that the expert was allowed to testify that in his expert opinion, because he didn't think that Officer Schurr followed through the police requirements or the police standards that was what made it without justification, and it was narrowed to that. But that's, again, that's confusing for a jury. That's two different things. And so I was just kind of stunned by it. You know, this whole thing is like, if a taser isn't deadly, then why are these guys fighting so hard over it? Why are they so hard to control it? That doesn't even make sense. I mean, the Childs testified. He's the guy. He's literally the guy from Axon, and he testified that that specific taser, like how deadly it still was. And we've got this guy who's never inspected the taser coming in and saying, "Well, tasers aren't deadly." So, well, then why is it still a felony in Michigan to possess one? You know, so I was kind of stunned by the whole thing. That's my honest, my gut reaction.
Right, sorry, just pausing there. I did not know that was illegal in Michigan to possess a taser. So, huh? That is a bit of something new that I did not know, that it was illegal. You know, to possess a taser in the state of Michigan. That's rather interesting.
Be narrow to what they're qualified to testify about, and so in this particular case, because it's simply a question of whether or not somebody is justified, to have them come in and testify to all the police stuff. The officer created jeopardy, I think, is what they said it was, or what he said it was. There's no law in Michigan about that. This is a straight up question of whether or not an individual is justified or not justified, and it doesn't really matter whether or not you're a police officer or you're not a police officer, because there's no distinction in Michigan law about whether or not you're a police officer or not a police officer. The same standard applies.
Well, Andrew, I'm curious, you know, when we see these different trials, not just this one, but sometimes you hear people say you can find an expert to testify to anything. And so I'm wondering, can you shed some light on what is that process and what are the qualifications in order for the prosecution or defense to get someone approved to testify as an expert?
Well, so to be qualified as an expert, it has to be your relevant training experience. You don't necessarily have to have like a degree in something. It's like Mr. Childs. He said that, I recall from his testimony, that his background wasn't so much in education, it was hands-on. I mean, this guy just worked with these things for so long that he is qualified as an expert to testify in those. And so it's based on your training and experience. I mean, a high school physics teacher could testify to a lot of stuff in court as an expert, just like on accidents, like how fast a car's going, like you can calculate something. And so you don't have to be necessarily hold yourself out as a quote unquote paid expert in order to be an expert. And generally speaking, you can find experts for a lot of different things. And it's the court that's supposed to be the gatekeeper. And that goes back to why the defense team was fighting so hard to have this expert come in and testify to some of his conclusions. And it's simply because from their perspective, it's not appropriate in this trial, and the judge allowed it. So that's the world we're living in.
I have a question just about the industry standards that Stoughton was able to testify on yesterday. And I'm assuming you just talked about it right there. I'm going to assume that you're going to kind of go along the same lines as you did your previous answer there. But when he was testifying about the GRPD policy requiring a directive or not a specific warning here, you know, would that be your same opinion, that he should never have been allowed to testify about the national practices versus the GRPD policy at the time?
Yeah, because this case isn't the trial's not about what policies are to be followed. I mean, that's where it would go in a civil case, and quite frankly, in a civil case, it would. My opinion is that it would be more appropriate to have him testify. But in a criminal case, that's not the issue. The issue is whether or not Officer Schurr feared for his life or for the life of others. I think it's just his life, or having great bodily harm, and so. To have this person come in and talk about, well, he should have stopped the chase when he's running around the car. Well, the chase didn't stop when he's running around the car. It seems to me that would be an officer discretion type issue. And the officer decided that he was going to keep going. He did issue commands. I mean, he issued a lot of commands. I think it was 27.
So It was just saying. So then that means that just anybody can be an expert. That is just great. Oh, see you later. Have a good day at KR. I am jealous. You know what? I'm gonna say something, and earlier I said this to Hio, and I'm gonna be honest with you guys. The guy is just talking about the day yesterday, but I want to be honest and I'll put it in front. I kind of regret. I don't know. It's not regretting in a way because I only want to watch the spicy parts of the case. I don't want to follow the whole case, but I kind of regret not following KR. Karen Reed, this is. But I only want to see the spicy parts, which right now in that case is the whole freaking thing because that whole case is a spicy pot of land. But um, we are not going to be called. We are going to be following, like we're going to do, like I said, the final part of the whole part of the Jennifer McCabe testimony, and maybe other bits and pieces. But we're not going to catch up. I mean, if we have to watch a couple of bits for the next couple of days until probably Monday until another trial starts, we will probably watch something else. But I don't know. Oh yeah, definitely. It was like we're gonna be watch the spicy and then swap and watch something else. Yeah. Good morning, by the way, Zizzy. Hello. Good morning, my friend. I hope you're okay. I am okay. Do not worry about me. I I'm fine. I will be okay today. I have my fan on with me at all times. I actually do. Oof, I do need to put my fan charging because it's already needs charging, but it will be okay. In the background is just like the recap of yesterday playing, but I just wanted to talk a little bit and break up a little bit so we don't get in trouble. But right, it is charging now. And I have cold water. I have water, cold water, and I have got I can go grab it some ice lollies just to cool me down and keep me cool and not to the heat to affect me too much. So I do have things in places to help me. Yes, I do have it. Um so yeah, so today I was gonna actually say, I don't know if you heard or not, but today is gonna be the last witness for the state to testify. This state is expected to rest today after this last witness that is already on the stand. So the guy that was yesterday on the stand when we finished the day is the last witness, and we are gonna finish him off today. Then the defense state my start and do their case in chief, which might only happen after lunch or after a break because normally they do like to have breaks in between. They rests between parts of the case, and my fan is not staying up, so I need to find another place for her. Yeah. Oh, good morning, bud girl. Good to see you. Welcome in. Enjoy your membership. You can have a little bit of behind the scenes of, well, a life in the UK. Some random stuff that I do for our members, and just like some of that stuff. So yeah, I hope you enjoy it, your membership. And yes, thank you, Lois, for that indeed. um yes, Paula, we need to trade places, but I only trade places with you if you take the tornadoes away with you, because I don't want tornadoes or that whole situation. No, thank you, ma'am. I don't want it. You can keep it, you can have it. I will gladly give it to you. So yeah, that's great, Lizzie. So we can trade places. I don't like the heat. I was born, and I keep saying this, and I say to everyone, I was born in the wrong country. I was not born to be in here in this one. So absolutely was not. I was born in the wrong country. um I can move there. I can deal with the cold. I can deal with the cold I can deal with, but I don't want this. Especially that my now, like, my eczema has been actually calming down because I think I found what was making it worse and what was making trigger it. Right. I'd rather have tornadoes than hurricanes. Iowa. I have learned the difference between them. And to be fair, between those two, ugh, You can come and pick it because I don't know which one. Well, hurricanes sound much worse, definitely, than tornadoes. That absolutely, but yeah, both of them do not sound good. And good morning, William. Sorry, I just got a notification. Hang on. Ooh, so um. So good morning, William Santiago. Buenos dias, my friend. How are you doing? Hello, I'm waving at you behind the screen, behind the camera. I hope you are doing okay. So I don't know. I don't know. I think probably some of you weren't here in the channel yet, but back in October time last year, right? We covered a case of the Timothy Harrington Jr., who was accused of murdering Ole Miss, a Jimmy J. Lee in um where was this? Oh my days. Um Hang on, let me see because I forgot where was man. I forgot which state was this. Because we did cover it. Um Mississippi, that's it. Thank you very much, Zizi. Thank you. So we covered that case last year here in the channel, and the jury deliberated for like 14 hours plus. It was one of the very few cases that I streamed. There was no commentary, no nothing. So don't go back and listen because you won't listen to my craziness. But um oh yeah, bye girl, how you feeling? Sorry, how are you doing, my friend? I hope you are definitely better, and thank you, William, for a reminder of that. Thank you very much. You are so kind, my friend. um yeah, you have warnings with the hurricanes. Well, tornadoes do pop up, but I pop up out of nowhere sometimes. But anyway, but the new retrial of that case that I was talking about is only in October. If we are not in the middle of a trial, we might revisit that one again because that would be funny. Um, well, having Kara says that having lived through both, they are both terrible. Oh, I can't read, and scary. But which one would you choose, Kara? Tornadoes or hurricanes? I think I don't have experience of neither. But by Paula's comment, right, that one about the warning, I think I would still prefer tornadoes. Because tornadoes, okay, see, we are in the same wavelength. Because I think, yeah, hurricanes, you can do so much to prepare and everything, but then is tornadoes can just pop out and can pop in and pop out anytime, right? I don't know. I don't have any experience with in either of them, so we are just discussing the tornadoes and hurricanes, which is very interesting thing to talk about before court. Maybe not, but I don't know. But yeah, so there's a possible new trial for the end of the year. Talking about the Timothy, that one was kind of good. Courtroom wasn't bad in terms of audio, but now that I am a little bit slightly better in terms of doing streams, probably we can enhance the the sound and everything. But it's a 2.0 retrial, and it was a long trial. It was a lengthy trial, I think. But I don't know. We'll see what happens. I think he's been in custody all this time, which is not great. Um, oh wow, Ian lasted 10 hours, and Milton, we had to worry about your house flooding, and when we are 5+ miles from the water, we had 15 storm surge warning all night. Oh wow, that sounds crazy. That sounds no good. Yeah, so sorry about that. Hopefully you did not suffer that much damage from Milton. I do remember that was just last year, last October ish, if I remember correctly. I'm so sorry about that, Kara. I really hope that you are that you kind of recovered and did not suffer a lot of damages from that thingy itself. Yes, it's a hump day for sure. We've made through the week. Absolutely. We only have, well, for Paula today is Friday, so happy Friday, Paula. Hope you enjoy it. But yeah, so what do you guys think about this case? Is Christopher guilty, not guilty? They haven't proved it yet, but consider that the state only has this last witness on the stand. Let me know what you think. And I know the poll is ongoing, but there's also a poll ongoing that shows to see if Christopher is going to testify or not, because he is saying it was not self-defense, but it was necessary force. So, oh, is it okay? Well, it's just you don't know what direction they may go. Hard to no, I think I can kind of understand from that side, from what you are explaining, Iowa, and I appreciate it. But I think I prefer indeed tornadoes than hurricanes. They sound a lot better. So in one of the feeds actually from the court, they showing. Hang on, I need to move my fan to another place because now it's in front of something else. Hopefully you don't hear that the wind in the microphone. So I'm gonna do this one just so you guys see the movements that there is in court. We can still carry on talking. We still have half an hour. Like this happened almost half an hour ago. They are getting ready for the day. The court, like now we are just watching the judge, but court is getting movement. We are supposed to start in about 4 minutes. We start and testimony will carry on. But we'll might move to the other feed in a bit. But so I just want you guys to see a little bit of the movement that there is in court. Let me turn off my fan for a little bit. I'm not gonna suffer too much without it. But yeah, in terms of the tornado hurricane thing, definitely tornadoes. I think I prefer. But if I really had to choose, um, yeah, I wouldn't have choose nothing. I would choose nothing. Neither. No tornadoes or no hurricanes. Nothing. No natural disasters, no nothing. So it's just yeah. Neither of them are nice and neither of them are good. Sorry, I'm just typing the person that is gonna be on the England. Nicholas England, the person that is on stand, because we know it's gonna be the same one that left last night. So I'm just finding his name. Bloomfield. No, that's not how you spell fields. I think that's how you spell. It's the expert, as an expert witness. He carries on his testimony. So there we go. It's still just for later when we get back start on court. So we're still waiting for them to start. It's a half an hour delayed, as we know. But yeah, so it's gonna be definitely the third day of the trial. He's out on bond, by the way. Christopher's been out on bond because he just said on the news article that said he arrived on trial. So it does feel like a hump day. I'm struggling. I need to stand back on. I turned it off for a second and I need it on. I need it on. I'm sorry, but um this is absolutely necessary. It's a fun day. It's my only fun today. It's my fun because no, I'm joking. It's just I'm struggling without it. It's not gonna definitely be an easy day. So they are still talking about it. About oh, sorry, about the whatever happened. Yeah. Oh, you don't hear a fan. Ah, awesome. That's good. But I have it on. I promise. I do promise. Let's just hear now this guy's talking, and then we'll get back to court. I'll be back in a second.
He said it probably won't,
But there's a possibility.
There's a possibility, and now that'll be interesting to see how that plays out if that does happen.
Yeah, I mean, it's so tough, right? Because he says this all really comes down to how Christopher Schurr felt, in terms of if he truly felt that his life was in danger. So that really just sort of changes the perspective for me and the tough job that this jury has to work their way through all of this information that they've been given. And what stood out to me about that directed verdict that he mentioned is, he's saying that the judge has to take into account all of the information in favor of the prosecution. I'm just even more confused now.
It almost makes you think that, if they do move for that and then it's denied, the prosecution, after they've rested their case, how much work does the defense have to do here to make their side of the story heard, to kind of, ensure that they can get a win on their side. But again, it is interesting, right? Because it's just one of those things that we did not expect to hear, but it could be a possibility today.
And you're really gambling on a lot. I mean, Schurr has not said anything. He hasn't been able to take the stand. And, I think a lot of people would probably want to hear from him. And if the jury decides to go in a way that's not in favor of that, I think it would leave a lot of people confused.
Well, that was interesting to hear from Rodenhouse too, that he essentially feels like he has to take the stand. He needs to take the stand, which, as I said, most times you hear from defense attorneys anyway, they are totally discouraging their client from talking. So to hear him say, we really kind of need to hear from him, I'm so curious if Christopher Schurr will end up taking the stand.
In that same vein, he's saying, with this professor's testimony that was allowed, he was vehemently against that professor being allowed to testify here. And again, one of the reasons being that they're just not experts in Grand Rapids policing.
Right.
But of course, he was allowed to testify. It was interesting to see his take on that, as maybe that could be a reason why we see Schurr take the stand, to get his own thoughts and opinions about what happened that day and see the story through his eyes. But again, I was also very, very intrigued by his reaction on that one major objection that we heard as the Professor Stoughton, take the stand, as we heard that. And again, that goes back to that contentious battle. And now we see a better picture of why the defense really did not want Professor Stoughton to take the stand there.
And I think also too, something that he brings up is that these people were not from Grand Rapids. If we do hear from people who train people with our police, even Chief Winstrom, is that a connection that the jurors have? These are people that work in my community, that know the policy that's for my city. Does that change how the jurors connect to the experts? Now, do they look at Stoughton and say, well, he's an expert from South Carolina. Here's someone who works in my community. I might lean on them a little bit more to say yes or no in this case.
Well, I also thought it was interesting, Andrew's reaction to the back and forth and the objections versus ours. We're like, oh, whoa, things are really kind of heating up here. And he's like, no, this is standard for a homicide trial. But also really important to note that he was saying sometimes these objections are sometimes sort of just part of the show, right? Part of the defense or prosecution just wanting to make their argument clear. We talked about the defense objecting to these witnesses that had already been approved to testify, and Andrew saying that, well, that could be part of either side just wanting the jury to have a clear understanding of how they felt about that. Hey, this has been approved, but we want you to be sure or clear that this was not something we supported and we do object to this.
Maybe something we should have asked Andrew, and if Andrew's listening, maybe we can talk about this the next time that we speak with him, is that, we've had these three expert witnesses after, at the very end of the prosecution's case here. We're talking about Brian Childs, Seth Stoughton, and Nicholas Bloomfield were the two that created the most controversy between the two sides here. I'm curious if, we hear from these witnesses on the second and third witness that we heard from, and we're hearing from Bloomfield right now. But I'm curious is if the defense will have to quickly feel like they have to make their case, with their most bombshell witnesses and things like that. So I think that is something interesting that we'll see as the prosecution rests and the defense picks things up.
Most definitely. We just got word that on our stream, the judge has just walked in. Let's drop into those proceedings now.
We were, I don't know about in the middle, but taking testimony of Mr. Bloomfield. But before I have him retake the stand, is there anything we need to address before the jurors come out for the people?
Nothing, Your Honor.
And defense?
Yes, Your Honor. We're wondering if the court is going to give a written version of the jury instructions soon so we can with that. I know we talked about it in the chamber, but we're hoping to hit sort of the final set. Just with the special instructions, not all the instructions, obviously, just the ones we've been discussing.
Really, it's just one, right?
It really is just one.
Okay. Okay. So I will have my law clerk work on that while we're in here this morning. But I have it, I have it, I wrote on it, but probably can't read my writing. So what I'll do is have them amend it and then we'll distribute it.
Okay.
Anything else before we come in?
No, thank you.
All right, and so I'm gonna ask the witness to retake the stand, please, that you see him in the courtroom. If anyone like him re-sworn for the day, I can just remind you.
I have no need for re-swearing, Your Honor. Whatever the court wants to do, Your Honor.
Sir, I'll remind you that you are still under oath from yesterday,
Yes, Your Honor.
and you may have a seat.
Thank you.
For now, until the jury comes back in, and we'll have them brought in. Welcome back. I see everyone made it back to court safely. You may be seated. Mr. Becker, you may continue with your report.
Thank you, Your Honor. I'm gonna start the morning off, and you dim the lights, and then you're gonna review, please. Okay, Mr. Bloomfield, you had an opportunity to look at the video and the still frames of the video, correct?
That is correct.
For the record, this is the People's Exhibit 7, starting at frame 5592. Now, again, we left off, I just wanted to make sure we're on the same page. Your issue is with the taser. You didn't have a problem with the taser being used, but it was how it was at the time it was deployed. Is that a fair assessment?
And that's a fair assessment, yes.
I'm going to show you here, kind of walking through this. Now, can you go over a little bit again? Why was this bad tactics, if you will?
So 2 reasons. Number 1 is the effectiveness of the taser. In order for the taser in these situations when there's a probe deployment that is being attempted by an officer, the greatest likelihood that neuromuscular incapacitation is going to occur is when the probes have a far enough spread apart in large muscle mass areas of the body. And what TASER has also recommended through their training to officers is what they term splitting the hemispheres, where if, again, you use the waistline or the belt line, separating the upper from the lower hemisphere, getting a probe in the upper half and a probe in the lower half of the body, again, give officers the greatest likelihood that neuromuscular incapacitation is going to be achieved. In order for that to happen, you need to have some standoff distance so that as the probes leave the cartridge, they can have time to essentially spread apart in order to achieve that.
I'm going to show you right now. I'm down to now 5631. I think there's a laser pointer there too. Can you give them the jury what they're looking at here in terms of where you talk about the spread and where the taser's aimed at, if you will?
So right here, you can see 2 laser pointers, which are affixed to the taser device. This is to assist officers in being able to visually see where the probes are likely to impact. The green laser dot is the upper probe or the top probe, and then the red dot is the lower probe. Again, and they're different colors so that officers are best able to distinguish between the two. And again, so that's a visual indicator. So right here, you can see that both of the probes, based upon the laser sighting, are above Mr. Lyoya's belt line. And so that would indicate to an officer that both of those darts are likely to go just in the upper hemisphere.
What was the other issue then that you had in terms of with this opponent? It's not just the taser distance, but it was something else related to weapon retention?
Correct. So it's generally accepted in policing all across the country. The principle of what we refer to as weapon retention, where officers are taught tactics to retain their weapons, essentially to keep other persons from grabbing and getting a hold of their weapons and potentially using those weapons against either the officer or other bystanders. So this is a heavy part primarily of defensive tactics training that officers go through. Both the basic training as well as they go through refresher trainings throughout their career. And so extending a tool in close proximity to an individual, especially one that is facing you in this manner, creates a high likelihood that your weapon is likely to be grabbed, or your tool is likely to be grabbed in this particular instance. What we see a lot of times, and again, this is not just related to tasers, this could be firearms, batons, OC spray, is that when it's in close proximity, you will have subjects who will reach out and attempt to either deflect or disarm officers just because the opportunity is there. Even if prior to that, there was no indication that an individual was attempting to close distance and disarm an officer, it's more opportunistic in a lot of these cases.
And so that's what essentially happened here, because you continue on. The weapon is grabbed right around 56, 58. 5670, you clearly see the taser in the hand of Patrick, correct?
That is correct.
Now, you didn't just look at this frame by frame, you looked at all the videos, correct?
All the videos were provided to me, yes.
This is going to exhibit 1, the cell phone video.
Okay, why you got?
For the record, it's about 50 seconds into exhibit 1, Your Honor. What did you hear there?
So what I heard there was what I would recognize as being consistent with the sound that a taser makes during a probe deployment. So you initially hear a pop, which is essentially when the cartridges, or when the probes are leaving the cartridge of the taser, you'll get that distinct popping sound that you hear, followed by the cycling of the taser, which is consistent with kind of like consider kind of an electrical sound or an electrical cycle.
Continue on.
Okay, why you gotta do all that, bro? He good, man. Let's call it taser. Let's call it taser. No, he good.
So did you hear anything there?
Again, at this point, I heard another popping sound that I recognize as being consistent with a probe deployment.
And just for the record, that's about 113 exhibit 1, Your Honor.
You can talk to him, bro. Ah! Yeah, damn. But he good, bro. Like, can you talk to him like good? Like, can you, stop grabbing him like that. Now he good at it for yo, you heal him too. He's that shit. Now he ain't brought no taser. I see that.
Drop taser! I'm going to stop right there. Now, in terms of, did you ever hear any additional taser deployments other than the two you just mentioned?
No, I only heard the two. The other thing that I wanted to mention, just because you asked me about sounds, is with each taser deployment, you'll also hear kind of a chirping or a beeping coming from the taser. These tasers, specifically this model, has built into its software to where it will cycle for 5 seconds automatically, then it has an automatic shut off. And so that chirping is notifying the officer that, hey, the cycle is coming to an end. And in both probe deployments, or what I recognize to be the sound of probe deployments, as was asked, you also hear the follow-up chirping notifying the officer that, hey, this 5 second cycle that is active is about to come to an end.
And that was kind of my next question. Did you ever hear that chirping at any point in time after that? Other than the two deployments, did you ever hear it, at this point in time or just before the shooting?
No.
So obviously you took a look, you saw the shooting now, you've seen this whole incident in your analysis of this case, correct?
Yes.
Could you tell the jury what your opinion is when a reasonable officer in the same circumstances made the decision to fire, as we just saw?
So with the taser, there's a theory that's commonly held within the policing industry with regard to an officer being disarmed with a taser. The theory essentially posits that an officer may be justified in using deadly force if they were disarmed of their taser because of a threat that they may have the taser used against them, specifically being incapacitated by the taser. In order for that to be a valid claim, the taser would have to be in a condition to where it could cause neuromuscular incapacitation. The greatest likelihood of neuromuscular incapacitation being achieved, as I've mentioned here on the stand multiple times, is through a probe deployment. The Taser 7 is equipped with two cartridges, and those cartridges are there because, again, over the years, the original tasers only had one cartridge. Then Taser started coming out, Axon started coming out with multi-cartridge models because, again, a lot of things have to go right in order for to have a good probe deployment and have neuromuscular incapacitation achieved. And so Taser started again coming out with multi-cartridge models to give officers follow-up opportunities in the event that they were unable or unsuccessful. And so there's only two cartridges available. Beyond that, when it comes to drive stun mode, even with the expanded cartridges, we're now in a situation where the taser can still be used in follow-up or drive stun mode, but that operates off the principle of pain compliance, so it does not achieve incapacitation. And so in this particular circumstance, you have a situation where a taser is no longer in a condition to where neuromuscular incapacitation is likely to be achieved, either against the suspect or against the officer in this particular case. And so based upon that, a reasonable officer in this position to elect to use deadly force, knowing that is the condition of the taser, that would be unreasonable, excessive, and contrary to generally accepted police practices.
I have no further questions, Your Honor. Thank you.
Morning, Mr. Bloomfield.
Good morning.
Okay. I'd like to ask you a couple of questions about your background.
Yes.
I think you said you work for a hospital system or a hospital chain?
I do now, yes.
And what do you do there?
I'm the regulatory manager.
Okay. What do you do as the regulatory manager?
So I'm responsible for making sure that the organization which I'm employed with is in compliance with federal and state regulations. Primarily, the regulatory body in healthcare is CMS, Center for Medicare and Medicaid Services, and so they set standards the hospitals must comply with in order to qualify for those monies.
Do you ever review situations to determine whether or not a particular situation individuals comply with regulations or rules?
Yes, I do.
Okay. All right. And I'd like to talk about, really, you gave focus really on two opinions. One was yesterday, and you had a little bit of that today. And then you had another opinion, the one you just ended with, and I'm going to talk about those in order.
Okay.
Okay. So now you did team up with Professor Stoughton in this case, correct?
Yes, I did.
And so you guys have a joint report.
Yes, we do.
All right. How do you know Professor Stoughton?
So Professor Stoughton now is a colleague of mine. When I was conducting research for our organization, when I was employed with the Farmington Police Department in reference to contagious fire phenomenon, he was one of the academics that I reached out to, and we began a rapport from there, and then that turned into some professional teaming up and working in this field.
Okay. All right. Thank you. So yesterday you talked about OC spray.
I did.
Can you tell us if OC stands for something?
It does. It stands for oleoresin capsicum.
Now we know why they call it OC spray.
That's correct.
Okay. What is the purpose? Is it something that a police officer might have on his or her belt?
Generally speaking, yes. And so OC spray is a common force option that officers are provided. That is very common throughout the industry.
You wouldn't classify it as a deadly force?
No, I would not.
Okay. Now you were talking about it, but is anything in your opinions, or is it your opinion that because Officer Schurr didn't use OC spray, he acted unreasonably?
No, not in this particular case. Part of the use of force calculus is what reasonable options did an officer have. That clearly could have been an option that would have been reasonable based upon the level of resistance that a reasonable officer in this situation would have observed. But it didn't. It wasn't selected as an option in this case.
Okay. All right. And if we could switch over to the defense. And 5400, RFN 5400 from Defense Exhibit A. So I'm going to play you the part about the taser and before the final use of deadly force. And it's not very long. Oh, we have a spot. I'm sorry, we have a spot over there. The plug is going to be connected.
There it goes green now.
And so this is in regard to the opinion that you finished up today, the taser deployment, the first one. If we could just play that in normal speed. And this is RFN 5400.
Like all the tables.
Yeah, that's good. Okay. And so when you're talking about Officer Schurr's use of the taser, you're talking about those seconds in that video.
Yes.
And so you would agree that this happened over the course of reaching for the taser was a matter of seconds?
I would agree with that.
Okay. And it's your opinion that using the taser in that situation is fine, but it's the manner in which you used it was not fine.
That is correct. The taser is a force option. was reasonable. However, the manner in which it was deployed was tactically unsound.
And part of that is because of the distance, and because you didn't believe that there was the ability for NMI at that distance, correct?
Not the ability, but the likelihood based off manufacturer recommendations that NMI could be achieved was significantly diminished.
Okay, and I think you said yesterday that the preferred range is 7 yards. Did you mean feet?
No, feet.
Okay.
Yeah, sorry.
I didn't think you meant 21 feet, but
no.
We did make you testify right after getting on
Yes.
off the plane. So, all right, so 7 yards you believe is the preferred range, so you get 12 inches or 7 feet. Did I just say
7
yards?
feet. You
I'm
did.
sorry.
I was going to correct you, but you're fine. So, yeah. No,
Please
you're
correct
good.
me if I do something.
No,
like
you're good.
Okay. So 7 feet would allow you to get 12 inches of NMI.
Generally, of spread, generally speaking, but in addition to that, TASER recommends that those probes split the hemisphere. So you have, yes, one probe, just as you're demonstrating, one above the waistline, one below the waistline.
And it's your opinion that this isn't close enough to split the waistline? And it seems like he's pretty close. He's just above the belt buckle, right?
Again, I'm speaking, it's close, but however, I'm speaking to TASER's recommendations. So.
Okay. And with regard to those recommendations, with the TASER 7, the actual recommendation to get the 12-inch spread is 4 feet, right?
Is what?
4 feet?
4 feet?
Yes.
Could be.
Okay. So
Yeah.
it's not
Yeah.
7.
I don't recall specific. 4 to 7. Somewhere in that range. There's not. Yes. I'll leave it at that. So I don't have the materials directly in front of me.
Well, and in your report, you say 7 feet as well.
Yes.
And you're basing that on the trainings that you reference in your report, right?
Yes. So TASER does provide trainings to departments. Anytime officers undergo TASER training, they actually do not. They may have their additional curriculum, but TASER actually provides a curriculum for officers that they recognize as the curriculum that officers essentially would need to go through for the manufacturer to recognize them as a valid operator with their device. And again, they put that out. And so certified TASER instructors have that. All the information that I referenced in the report. So if it was 7 feet in the report, that would come directly from TASER.
Okay. And you're referring to particular trainings on the TASER 2, right? In your report?
I don't recall specifically. Does it stay in the report?
Have you ever worked at Axon?
No, I have not.
Okay. Okay. Now, in a close proximity situation, let's say you don't get the full 12 inches.
Mhm.
Are there any departments that train that you can use the drive stun to complete a circuit of more than 12 inches?
Yes.
So if one probe goes in and another one misses, right? And sometimes that happens, right?
Yes.
You can just make a
More
third
often than
point.
not.
What's that?
Say more often than not.
And because you have two darts basically going on, and they're designed to actually spread distance, right?
Correct.
So you can make the third point and cause NMI.
Yes, you could.
Okay. Okay, and then I think you testified that in this situation, he should have created more distance, preferably 7 feet, according to you, right?
At least enough distance in order to get a reasonable spread that would split the hemispheres.
Okay. But there are some situations where officers really can't create distance, right?
That is correct.
And one is if you're in a confined space,
Correct.
there's nothing you can do. You can't go through a wall.
Correct.
But that's not the case here.
No.
They're outside. And also when a suspect is closing in on the officer, right?
Yes.
Okay. And is it your opinion that Mr. Lyoya wasn't closing in on Officer Schurr at all?
Correct. In the video that we reviewed, the one that's been shown here today, you can see that Mr. Lyoya's posture is always trying to create distance from the officer, and the officer in this case is the one who is closing the distance.
How about when Mr. Lyoya grabs the taser? That's not closing the distance?
At that moment, Mr. Lyoya, at that moment in time when the taser was presented, reaching forward, I wouldn't necessarily constitute is closing the distance. He's reaching forward to grab the taser. I would agree with that. But the whole reason why that opportunity even occurred was because the officer in this case is the one who closed the distance on Lyoya, who was trying to create distance from the officer.
He didn't give him the taser though, right, the officer?
No.
Okay. Mr. Lyoya grabs the taser.
Correct.
Is reaching out to grab something off an officer an act of aggression?
It could be. It's also consistent again where individuals are simply trying to defend themselves from being, in this case, having a taser used against them, being shot. There's a number of reasons, and I don't know the mind of Mr. Lyoya.
Well, just based on the video,
Mm-hmm.
You agree that it could be an act of aggression for someone to grab a taser from a police
Correct.
officer.
It could also be an act of defense. Yes.
Okay, and an act of defense like deflecting something, right?
Yes.
Okay, how about disarming a police officer? Is that an act of aggression, in your opinion?
Yes.
Okay. Now, you and Professor Stoughton had some opinions about things that happened more than a minute and a half before deadly force was used, like chasing Mr. Lyoya around the car.
Yes.
And you talked a little bit about it yesterday, and Professor Stoughton talked a lot about it. Is the fact that, in your opinion, Officer Schurr shouldn't have, it was unreasonable for him to chase Mr. Lyoya. Does that mean that he no longer can use deadly force at a later time?
No.
Okay, so he's still, if he's reasonably in fear of great bodily harm or death, he can, or if someone's going to attack him, if he's reasonably fair, he can still use deadly force, right?
So I'm going to clarify just a little bit. In order for an officer to be justified in the application of deadly force, they must be able to articulate why they have a reasonable belief that they themselves or another individual is under immediate threat of receiving great bodily harm, great bodily injury, and or death.
That's generally accepted police practices, right?
And that is the language the Supreme Court uses, which is what was adopted by the policing industry and has now become generally accepted police practice.
And to be clear, you're talking about the U.S. Supreme Court.
That is correct.
Not the Michigan Supreme Court.
That is correct.
Okay, because you're not familiar with Michigan law.
I'm not.
Okay. All right, and then you talked about Officer Schurr's use of deadly force. You say it's unreasonable and contrary to generally accepted police practices. And I understand that the basis for your opinion is that the taser wasn't in a condition to incapacitate him.
That is part of the reasoning, yes.
All right. And I think you testified about it. You can hear the pop, right?
Yes.
Okay. And you know that there's two probes, right?
Yes.
Okay. Now in, I believe you testified about, it's generally accepted that in the absence of physical ability to incapacitate the officer or otherwise render him unable to protect himself, no reasonable officer, not one, could have concluded that Mr. Lyoya presented a threat of death or great bodily harm. That's what your opinion is?
Under these, this specific case, a specific fact pattern, yes.
Okay. And the reason you're forming this opinion is because you know that if an officer is incapacitated, He's lost the ability to protect himself, right?
That is the theory, yes.
Okay. And we're talking about what he reasonably believed in that situation, right?
Not what he reasonably believed, what a reasonable officer would have concluded.
Okay, so you're just talking about objectively reasonable officer standard.
That is the standard, the only standard in the review of all cases that's accepted in the industry.
Okay, generally accepted.
Yes.
Not talking about Michigan law now, right?
Not talking about Michigan law.
Okay. So you don't consider whether or not the arresting officer, in this case, Officer Schurr, knew that the second probe.
So when we review cases, we do take into account the subjective statements, opinions of officers, as far as to fill in what a reasonable officer in that officer's situation would have known at the time.
Did you review Officer Schurr's statement in this case?
We did.
Okay. And in there it said that he.
This is hearsay. You can get it in. I can get it in if I want to. It's the same against party opponent. He can't get it in.
I believe the expert relied on it in his opinion, so I'd like to ask him about that.
Well, you can't. Doesn't make hearsay admissible. So.
Well, there's a lot of what hearsay that he's talking
That's
about.
what he based it on, but you can't say my client said whatever he said, that it would be hearsay. So I'll sustain the objection on that basis.
Mr. Bloomfield, you relied on a lot of materials, including trading materials, right?
We did rely on some of the trading materials that were provided, yes.
And you said you considered the statement as well when forming your opinion?
Yes, we did.
Okay. So I believe you testified yesterday about incidents where if an officer is incapacitated, loses his firearm, he can be shot or killed, right?
I don't recall getting into that yesterday. I did touch on that briefly today.
Okay. Are you aware of situations where an officer is incapacitated and then loses his firearm and is shot and or killed?
So I need a little clarification there. When you say incapacitated, are you talking incapacitated with a taser specifically or incapacitated by other means?
Well, let's talk about both.
Okay.
Okay. Incapacitated by any means. Are you aware of any situation where an officer has been killed after being incapacitated?
Yes, there are situations where I would personally classify that an officer has been incapacitated. Maybe that would mean being knocked out, being injured to a point where they're no longer able to successfully defend against somebody disarming them. I am aware of incidents like that.
Okay. And here the concern is with a taser, you can be incapacitated if an MI occurs, right?
Yes.
Okay. Are you aware of incidents where an officer has been tased and has been shot?
Where an officer has been tased and then shot. It's a very specific circumstance. Right now, I'm not aware of anything. Myself and my colleague, Professor Stoughton, him specifically, conducted extensive research on officers killed in the line of duty. And we are not aware of any case or instance where an officer had a taser that was used against them where they were incapacitated, and also within that same set of circumstances, it resulted in an officer's death where they were disarmed. In addition to that, I do not know of any case, not including deadly force, where officers have been disarmed of their tasers, where an officer has been successfully incapacitated by a suspect.
You're not aware of that, right?
I'm not aware of that, and nor in any of the research that we conducted in preparation for this did we ever find anything that would essentially change my opinion. If I was aware of at least an instance, I would let you know.
Okay. I'm just asking you about what you're aware of and what you relied upon. Now, your opinion states that it's unreasonable for Officer Schurr to believe he could be incapacitated, right?
For an officer, yes, in his circumstances.
Right. Because the available evidence establishes that any reasonable officer in Officer Schurr's position would have been aware that Mr. Lyoya did not have the ability to incapacitate Officer Schurr because both of the cartridges in Officer's taser have been discharged. Is that right?
Yes.
Okay. So it's unreasonable for Officer Schurr not to have known that the second cartridge had been discharged?
I believe what we state in our opinion is that an officer in these circumstances would have known that both cartridges had been discharged from the taser.
Okay. And because you assume he would have known, he is therefore unreasonably believing he can be incapacitated by the taser.
Correct.
You also have stated that in stressful environments, human decision-making suffers. Officers may experience distorted sensory perceptions, including visual distortions, like tunnel vision, auditory distortions, which is auditory blunting, and temporal distortions, perceiving events as occurring more quickly or more slowly than they actually are. Is that
Yes.
a fair statement?
Yes, it is.
In fact, you said it, right?
Mhm.
Yes?
Yes.
Okay, so what, you talked about auditory distortions there, for example, auditory blunting. What's auditory blunting?
So again, it is a term that is known in the industry. Auditory blunting or auditory exclusion is what they're most commonly referred to. So essentially that is a phenomenon, physiological, psychological phenomenon, where under stress, when officers have discharged their weapons, they report that essentially the signature of the weapon being fired, the sound, is reduced. And that has led officers to believe that in some cases that something is wrong with their weapon as a result of that. And so again, this is a pretty well-known phenomenon. Most officers receive education that if they are involved in a deadly force encounter and they discharge their weapon, that a lot of these physiological and psychological phenomenon may be experienced. Auditory exclusion happens to be one of the most commonly reported phenomenon that is experienced along with tunnel vision.
And what's tunnel vision?
Tunnel vision is essentially where officers, and again, this doesn't just have to be officers, could be soldiers, but in deadly force encounters, they become hyper-focused. Essentially, their vision, they report what could be termed as superhuman vision, where they're able to hyper-focus, mostly on weapons. At far distances, officers have reported being able to see amazing things. Also time distortion, where generally speaking, among most officers in deadly force encounters, they report time as if it's slowed down for them. Rarely do we hear any reports of time speeding up, some, but mostly time is slowed down.
Okay, and these phenomena occur in stressful environments.
They can. Their most common reference is in when officers are actually under the threat of receiving great bodily harm, great bodily injury, and or death, and responding to that threat, primarily with deadly force. And so it's just not all stressful situations. In general, officers encounter stressful situations all the time. The majority of the literature and the research is specifically around deadly force encounters, specifically when officers are under the threat again of great bodily harm, great bodily injury, and or death, and are responding to that threat to defend themselves.
Is the video that you just saw one of those types of stressful situations where auditory blunting could occur?
Generally, the situation is pretty common in policing in terms of the events that transpired. As far as now, when you said that statement, and correct me if I'm wrong, is it possible? If you're saying is it possible, well, I'd have to concede that anything is possible. Is it plausible? know. And the reason why I say that is because there's nothing in this situation that I would term that an officer in these circumstances would have a reasonable belief that they were under immediate threat of receiving great bodily harm, great bodily injury, and or death.
Well, we just talked about the fact that you had formed an opinion.
Yes.
That if Officer Schurr had been incapacitated, he could be harmed or die.
Yes.
And then you gave us your opinion that he wasn't in the situation because he didn't hear the second probe, right?
State that one more time.
Well, let me ask this a different way. Are you an expert in auditory exclusion?
I am not.
Okay. All right, so we talked about incapacitation. What you don't talk about is whether or not do you have an opinion on whether or not the drive stun can cause bodily harm in a situation where a person has taken an officer's taser, as in within a foot or two of the officer?
So when you say bodily harm, can you give me a reference by what you mean with bodily harm?
Like being blinded or getting hit in the throat and the trachea collapses.
I would assume that those things could be possible with that taser and drive stun.
Okay, so in a situation such as this, where the taser is close to the officer, is it reasonable for him to fear that he could be harmed in those ways, given the situation?
Again, it's possible, but anything is possible. I didn't see anything in the facts of this particular case that would lead me to believe that a reasonable officer would have felt that that was an immediate threat at the time deadly force was applied.
Well, Mr. Lyoya in this case had switched the taser from his left to his right hand. You're aware of that, right?
Yes.
Okay. And he had it in exclusive control over it in his right hand, right?
When you say, again, exclusive control, I don't know what you mean by that. His hand was on the taser. He never had his hand in what I would term as fire control, or in the way that an individual would commonly hold it to activate it to cause either drive stun in this case with the condition the taser was in.
Would that make a difference to you if Mr. Lyoya was holding it like a gun? Would that change your opinion?
It would influence my opinion. I've had cases where that has been the circumstances.
A moment here. Nothing further, thank you, Your Honor.
You kind of like one opinion. You said one of his questions was that, well, your opinion is based on the taser is not in the condition to incapacitate him. And you said, well, that's part of my opinion why the use of force is not appropriate here. What's the other part, I guess? What is missing out of that opinion? It's not just the taser. What else is there?
So when we talk about any application of force within policing, it's based upon a number of factors. One is proportionality to the resistance or threat that an officer perceives. During this entire instance, while I talked about the other applications of force that a reasonable officer would have used throughout this situation as it unfolded, the primary form of resistance that was demonstrated by Patrick Lyoya would be classified as resistance. And so resistance in the form of physical resistance, attempting to get away, attempting being taken into custody, creating distance. Not at any time in any of the evidence that we reviewed did we ever see Patrick Lyoya attempt to harm the officer in this particular instance. As noted, Patrick Lyoya did grab a hold of the officer's taser, and there was a struggle over the taser in this instance. But again, in this circumstance, it is that there was nothing that we termed to be aggressiveness or combativeness on the part of Mr. Lyoya towards the officer in this case, coupled with the fact that the taser is not in a condition where neuromuscular incapacitation could be achieved, in addition to the fact that a reasonable officer would have known that that was the condition of the taser. And so all of those things together would lead a reasonable officer to conclude that they do not have grounds to reasonably articulate that they were under an immediate threat of receiving great bodily harm, great bodily injury, and or death. Therefore, that classifies the application of deadly force in this instance as unreasonable and excessive.
Thank you. I don't think further. You guys have some more questions on that?
Mr. Bluefield, does an officer have to wait to be harmed before he acts?
They do not.
Okay. And it's your opinion that you never saw any act of aggression by Mr. Lyoya on those videos?
No.
That's not your opinion, or you didn't see any?
My opinion is that we did not see any actions by Mr. Lyoya that we would constitute as act of aggression attempting to harm the officer.
Okay.
Yes.
Yes.
I have nothing further.
I can see one hand raised on the jury, so I'll have my clerk grab that question. Please. I'm going to pass the question back because there's one word that I'm trying to make it out. I just can't. So I'm going to ask if you could just rewrite it, and I just know which word it was. And then I'll have you coach.
So we're just waiting on jury questions right now. They are going to go over it. But after this jury questions, if the defense and the state or even the judge doesn't have any questions, guess what? State my arrest. We are like within like half an hour of court and state my arrest. So we might have a bit of a break between state resting and the defense with the first defense witnessing coming up, but we'll see.
On the other's choices of force or lack thereof.
I don't know if I'm fully or can grasp what the question is that the jury needs assistance with. Can you read it one more time, Your Honor, and I'll.
When investigating cases, do you usually find errors on the other's choices of force or lack thereof?
So when investigating these types of cases, I think if I'm understanding the question correctly, the question is do we often see errors on the part of officers in their decision making in the levels of force that they choose to employ? The answer would be yes and no. In a number of cases that myself and my colleague in this case, Professor Stoen, we basically review hundreds of cases, and in cases, we find where the actions of the officers are completely reasonable and consistent with generally accepted police practice. In other cases, we find the opposite, where none of the actions of the officer were reasonable and consistent, and then we find a mix, where sometimes some of the actions of the officers were reasonable and other actions were not reasonable. In this particular case, we rendered a number of opinions on the actions of a reasonable officer in these circumstances that we found to be reasonable. Most of that was leading up to the deployment of the taser. We said, hey, we recognize that the majority of these decisions by a reasonable officer in this case were reasonable decisions and were consistent with generally accepted practice. And so I hope that answers the question.
I have no follow-up, Your Honor. No, Your Honor.
I don't see any other hands raised on the jury. May this witness be excused?
Me, Your Honor. Yes, Your Honor.
Thank you very much.
Thank you, Your Honor.
Your Honor, I show we've admitted 35 of these exhibits. They're all admitted at this point in time.
Exhibits 1 through 35 for the people, yes.
So, all right, with that, we have no additional witnesses and we rest our case.
Who are you ready to put on your case at this time? Or would you like a break?
We would like a break, Your Honor. We have a matter for the court.
And so what we'll do is we'll take a break for 15 minutes right now. And so that means we'll come back at 10 after. So meanwhile, just because people have rested doesn't mean it's time to deliberate. So you're still instructed to not discuss the case with each other or with anyone else. Same restrictions with respect to access to news reports. Also, please leave your notes upside down in your chairs and they'll be there to you. Thank you. All right, so jury, please.
And we're back with breaking news. Christopher Schurr's defense team has just filed a motion for skewed the perception of the jury too far with experts the defense team disagrees with. Now, we want to remind you that we are on a 30-minute delay, so you have not heard this argument yet. We are working to bring you that as soon as we can during this break. Schurr's team has also filed a directed verdict. That's something we heard from our expert Andrew Rodenhouse this morning. It's a motion where the defense is trying to direct the judge to order Schurr's acquittal in the case, as they believe the evidence presented by the prosecution should be discredited and is not accurate. And we are just slowly learning details as to the judge's response to that. My producers tell me in my ear that the judge has not ruled in favor of a mistrial. She's still going through the directed verdict. This is something that Andrew Rodenhouse just talked about with us a couple moments ago, saying that this was a possibility that we could see this happen today. And if this had ruled in favor of the defense, the trial could have ended today. But as we know right now, and I just got word in my ear that she has also ruled against the directed verdict, meaning that this trial is going to continue. Again, this is developing and it's happening in real time. We're on a 30-minute delay, so you have not seen that motion filed yet. You also have not seen the judge talk about that. In about 30 minutes, you'll be able to see what we're talking about. But again, for those who are just joining us, the defense has filed a motion for a mistrial and directed verdict. Some of their complaints saying that the defense team, their experts that the prosecution brought on, they disagreed with them, bringing on prejudice to the case for the jurors. Also, with the directed verdict, asking for the acquittal of Schurr, and the judge has denied both of those. This is breaking news. We are still, as you can see, still learning some details as to what this means. You know, we'll be bringing in Andrew Rodenhouse later on to kind of talk about these things. Earlier when we were talking about the directive verdict, he said that this could help the defense in their appeal case. It shows that they are able to make progress in the case and could help them. It'll be interesting to see how they are able to use the decision made by the judge as to these motions. Soon, Tanner and Emily are going to be joining me to kind of talk about this further. But again, breaking news, I believe that after the decision has been made that the court has gone back into a break. And so, okay, so now we're getting more word that the defense is now taking the stand. We're going to have Emily and Tanner join me right now. Again, that's 30 minutes away from us, but we have learned that the defense has taken the stand with their first witness. Guys, breaking news. Andrew told us this was a possibility that this could happen.
Yeah, certainly a possibility that I think was in the realm of the situation today, especially with how he was characterizing the witnesses, those two expert witnesses at the very end of the prosecution.
Right. I want to talk about it a little bit. So, direct verdicts. That's it. That's that. I forgot about it, man. My brain is like a smush. So, obviously, after normal state resting, there's the JOA, there is the direct verdict, there is all those motions that a normal defense files afterwards. They like saying like it's a breaking news. It is breaking news, but it's a normal thing on a trial. Every trial happens this. So it was a direct verdict. The judge ruled against it, and then the defense now is saying the stance. So the case is going to go forward. The defense is going to present their case in chief. They're going to be able to show their side of things. I think they're going to bring their own experts, and they're going to bring their witnesses. Probably more likely, it's going to be as well Christopher testifying. So I don't know. I think Christopher has to testify because it was only him and Patrick there. Sadly, Patrick is not here anymore. So we're gonna have to hear probably from him because everything else it's gonna be I call it, and it's my opinion, I can say it's speculation of what happened, especially that the fact, sorry, someone at the at the camera, especially for the fact that this last detective, he was saying he was speculating what is within the norms of the policies, but the policies you can't expect a policy to go directly to exactly what has happened word by word because things don't happen in life according to what the policy says. It happens according to what life says. And yes, there's policies and there's things that you can go accord to, scenarios accord to, but not always is like this. So and I was like, I don't know if they are gonna get the case today. I think it's still a little bit impossible, but yeah. Oh no! Is it weird? It's listening in the car. Let's drive down the road. So it's just I think that last detective, he created some reasonable doubt, but not too much in my opinion. I don't think, yeah. So the judge denied the direct verdict because there was sufficient evidence for a reasonable jury to potentially convict Christopher Schurr of a second degree murder. Pretty much, yes. Um, pretty much there is, but you know how juries can be unpredictable. We know that. We saw that with several cases that we've been following in this channel and following not and outside of the channel. There's cases that are absolutely crazy. That you think they're going to be guilty and they get found not guilty, and extra, extra crazy. I don't know what I was going to say that, but anyway. Um, Yeah, exactly. So that's why, because the jury, I think there is a lot of there, and I think was Bad Girl. She was saying that um this witnesses, this detective, I think and I said this yesterday as well, that I think they helped more the defense than the prosecution, and the defense attorney was able to create a little bit of a reasonable doubt. So, and that's exactly what you need to. You only need to create a little bit of reasonable doubt for the case to be found not guilty. That's all you need. You don't need like a lot. And the burden, as always, is on the side. So yeah. Well, we stood where we were. So sorry. It's just still they're still talking, and yeah. Um, they play the tape all over the tassel, and as I walk back to the car, I can absolutely hear it, and all was staring at my car like what. My associates were in the car saying this is normal. Yes, it is normal. Like, and talking about as well about that, when I say I cover murder trials and living trials and everything, people look at me like I'm a weirdo. Well, yes, I know I'm a weirdo. Let's not go there. But I like this type of things, and it's just, and when I have like on speaker, and when I'm out and about, people just look at me like, oh, talking um about that. And when I talk about courts and everything, it's just the stigma. It's like, oh, you're going to court, it's a bad thing. No, you don't need to, like, done something bad to go to court. Be and a true crime enthusiastic like we are, and we are in court every week, every day, even though it's virtually. But you know what I mean. Sometimes I still want to go back to court in here, in the area I live on, because there's a couple cases that are actually quite interesting. But I need more time, and that's one thing that I don't have is time. But we'll see. So yeah, so we're just now waiting on a court to get back from. Well, we're gonna listen to the motions again. When we definitely get back in court, and then we're gonna carry on with the day. I I don't see them resting today, especially with experts and experts. You guys know that are take along, but I feel like that the defense, it's gonna be more of a less boring case than the prosecution case, because in my opinion the prosecution case was a boring fest, snooze fest. They took, well, 2 days and an hour, so 2.5 days, 2 and 1.5 days of testimony. They had 11 witnesses. I'm just writing that down for our spreadsheet. And that was the witnesses case. What am I even saying? Ugh. That was the prosecution's case. Now, the defense, I don't think they're gonna be too long, but yet I don't think they are gonna finish today. I think tomorrow possibly, because they might still have to hash out the jury instructions, all of that, and then we still have closings and all of that. Um, so it drove me nuts to hear the news guy say they didn't even need that boring guy. Well, they probably did not need the boring guy, but sometimes prosecutions they need to, in a way, justify why they brought this case even to trial. um so it's just probably that, to fill up space, because otherwise, without it, I think the judge there might have granted. Oh, sorry, 1 second, give me 1 minute. Sorry, just something that fell. So they the judge wouldn't have granted, in my opinion, they are the direct verdict there. Definitely. Hours of that guy absolutely punked. I think that was the snooze fest of 2025. Absolutely agree. And I think it was, oh, let me turn off my fan for a little bit so you can um charge, and it's cooling down a bit here, so it doesn't need to be on at all times. So I think I think the defense has a good case here. And I don't think before I said, when we started Linda's term, she was guilty. Well, I started saying she was not guilty, and then I changed my mind to guilty, and then she was found not guilty. But I think my opinion on this case, I don't think so. I don't think it did on. It's not that he did on purpose, because it was not a premeditated. It's a second degree charge that we are talking about here. But I don't think he did with intention of, like, it was a self defense. It was him are the guy. So he had sadly, and I want to emphasize that sadly, he had to do what he did in a way. So it's crazy. It is. It should not have happened. No, Patrick shouldn't been out at 8 o'clock in the morning, drunk and driving and matching with license plates that doesn't match the car that he was driving or anything. So, um, it's just crazy and it's sad. It is a sad case. Yes, I'm not gonna lie. It is a very sad case and it's hurtful that we have to be in this position and that families are hurting and everything is happening, but it's yeah. So it is very 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 hard. So we should be back soon. Let's just check on what they are saying right now because that might be a bit of an interest and then we can comment on that too.
Telling you what's happening minute by minute if you're wanting to catch up on what's happened so far this morning on day 3 of the Christopher Schurr trial. So again, those motions, both the mistrial and the directed verdict, denied by the judge, and therefore that means this trial is moving forward as expected. The prosecution has rested and the defense has started calling their witnesses. We know that they have some 40 that they can call. We don't know if they'll call all of them, but there were some, mentions at the beginning of this that this could be a week-long trial. I think all of us thinking that is not going to be the case at this point.
Yeah. And I think also too, something that we talked to an expert yesterday, another legal expert about keeping the jury engaged. Okay, so now you drop this bombshell on them. And again, these are people who don't spend time in the courtroom every single day. This is not their profession. How do you, as the defense, a question I have for the defense now is, how do you drop that bomb, don't receive that bomb correctly, and then keep going?
Yeah.
I imagine for myself, I might be a little confused as a juror, like, okay, where do I go from here? And I understand the defense will probably give them a way to follow their process. But I mean, I got to imagine keeping them engaged. It's tough.
Yeah. I mean, hearing that bombshell, fail ultimately, as a juror, how do you move forward with that? Especially given the 10 people that we've already heard of, 4 hours of testimony from just one individual yesterday. I mean, it's got to be hard to follow. And when you throw in words like directed verdict and, obviously I think we all know what a mistrial is, but directed verdict, again, it goes back to your both of your points. This is legal jargon that we're not necessarily familiar with. And I don't want to get us too tied up on that because I think that's splitting hairs in some.
One thing that I don't agree that they are saying about the verdict, the direct verdict, and then the thing, oh no, it's fine. The jury doesn't listen to that. The jury is not present for the motions of direct verdict and judgment. That's it. Judgmental of acquittal. So, I will see you very soon, Maria. Sorry. Okay, see you soon as well, Lizzie. But yeah, I get it. I wanted to highlight this one, but see you very soon. I hope you have a good day. I'll see you very soon. It's gonna be as quick as working our fingers that you are going to be back. Have a wonderful day. Yeah, and you hurry back to no, I'm joking. So the thing is, that's one thing that I don't agree with what you was just saying, that the jury, it's dismotivated. The jury doesn't listen to the JOI. The jury's not present for the judgment of acquittal. They were not there in the presence of the jury, correct? Am I wrong? No, I don't think I am wrong, but correct me if I am, because um yeah, I don't think they are not there. So the jury is not there. So then it's not going to impact nothing on jury. And hang on.
The prejudice of the defendant to the extent that the fundamental goals of accuracy and fairness are threatened by allowing Mr. Stoughton and Mr. Bloomfield to opine on standards that are not applicable under Michigan law. As they both admitted, they don't know what Michigan law is, and that are not within the knowledge and in the situation of the arresting officer, based on tactical considerations that are not ultimately at issue in this case. including everything that led up to the ultimate issue here, which is whether Officer Schurr had an honest and reasonable belief to be in fear of death or great serious bodily injury at the moment that he made the decision to use deadly force. We also, based on their testimony, it's clear that they have not relied on proper training. They were relying on outdated policies. They were testifying about a taser model, an old taser model. They were not qualified as taser experts, and they gave several opinions about the taser. And at this point, we believe that we're too far along with the jury to simply strike the testimony, because they have heard testimony from two of the people's experts now that do not accurately and are not nowhere near based on what the law is in Michigan and what should be considered in whether or not Officer Schurr was justified in using deadly force. And so at this time, we would move for a mistrial on that issue. And if the court is not inclined to grant mistrial, then we would be asking that their testimony is struck from the record. Although we don't think that would be enough, because they've heard too much now based on the tactical considerations. And under Supreme Court precedent, San Francisco v. Sheehan, the 2015 case, even under the Fourth Amendment, that it says, even if the officers misjudge the situation, the court cannot establish a Fourth Amendment violation merely on bad tactics that result in a deadly confrontation that could have been avoided. Courts must not judge officers with the 20/20 vision of hindsight in their quoting Graham versus Connor for that issue. So we'd be moving for a mistrial on those grounds. And alternatively, we would also be moving for a directed verdict based on the motions that we just filed with the court. Given the complexity of the case, we would ask the court to review the written motion that we filed before making a ruling on that and before we move forward in our case in chief.
Mr. Baker?
We haven't got a copy of the motions, so it may be nice if we got one too, but I think there's no reason to grant a mistrial because they talk about objective reasonableness. The court, we've talked about this over and over again in chambers that, objectively reasonable officer, and we made sure to stick with that standard for the testimony of the experts. So there's no basis. And the experts can talk about Michigan law. The law's up for the judge to instruct on. So to say they weren't talking about the law, that's not their role to talk about the law, interpret the law. That's the jury's role in terms of determining whether somebody's engaged in self-defense, and that's a question for the jury. So they stay away from that. There's actually no grounds for mistrial.
Anything else? Hamilton?
The only thing I would add is while they were testifying, they were talking about the laws and policies from other states. They were talking about what applies from the International Association of Chiefs of Police. They talked about all of these other agencies from Mexico and South Carolina that it's not grounded or not required under Michigan law. And we outlined that in our trial brief with and attached 4 declarations explaining that that is not something that Michigan law requires or that GRPD trains their officers.
Anything else?
Yeah.
Okay. So, I'm prepared to rule on the motions for both the mistrial and directed verdict, which incidentally, as soon as we left the courtroom, I did receive the motion, I did review the motion, and I'm prepared to move forward on those at this point. I still give you a break if you need one after, but as far as a mistrial is concerned, I do not believe that the expert's testimony rises to the level of requiring a mistrial. I believe that the fact that they were testifying, they clearly were testifying on generally accepted police practices. They never held themselves out to be experts in Michigan law, and as Mr. Becker stated, it's the judge's role to instruct on what, excuse me, on what the law is, and it was the expert's job to provide opinions based on how they applied the facts in this case as they have been presented thus far to reliable principles and methods. And I believe that they did that. So, and I believe that the fact that they did not testify based on what Michigan law is, that more so would perhaps go to weight to the extent that it does not agree with what I instruct the jurors on. Also, it's ironic that you cited a Supreme Court case because obviously the Supreme Court is the court of the land, and the experts were testifying based on generally accepted police practices nationwide. And so, given that, I don't believe that their opinions or the fact that the juror heard those opinions would rise to the level of prejudicing the defense or the defendant to the extent that a mistrial should be, that I should declare a mistrial in the case. And as far as the directed verdict motion, obviously, as everyone, well, all the attorneys know, that a directed verdict of acquittal is only appropriate if after I consider all of the evidence presented by the prosecution in a light most favorable to the prosecution, I would have to determine that no rational trier of fact could possibly find that the elements of the crime charge were proven beyond a reasonable doubt. In this case, there are essentially three elements. The first is that the defendant caused the death of Mr. Lyoya, that Mr. Lyoya died as a result of a gunshot wound that was fired from the defendant. I believe that is obviously clear. It's on video. No one is disputing that the defendant caused the death of Mr. Lyoya, at least not any of the witnesses that I've heard so far. So it seems clear that that element has been met. Also, that the second element is that the officer had to have one of three states of mind: that he intended to kill, intended to do great bodily harm, or knowingly created a very high risk of death for great bodily harm, knowing that that would be the likely result. As an officer at the time, he was clearly aware that if he put a gun to the back of someone's head and fired a round into their head, that would likely, that at least created a very high risk of death, if not evidences an intent to kill Mr. Lyoya. So I believe that element, again, would be difficult to dispute given the background of the defendant as testified to thus far, as well as the video. That brings us to the only element in the court's view that is really in dispute here, and that is whether or not this killing was justified. It's clear that Mr. Lyoya appears to have possession of the defendant's taser at the time that the shooting occurs. But it is also clear to the court that a rational trier of fact could find that the alleged victim, in this case Mr. Lyoya, was not in a position to use the taser at the time that the shot that killed him was fired. I believe that a rational trier of fact could find that based on the video alone, but if you also incorporate testimony of not just the experts, but also other witnesses, including the witness that talked about the taser, Mr. Childs, I believe a rational trier of fact could find that the killing was not justified. And so, because that is the position of the court, I am denying a directed verdict of acquittal for those reasons, because I do not believe it to be appropriate under the circumstances. And so with that, is the defense ready to put on their case in chief?
We are, Your Honor, and I had a question. We were at some stipulations. I can't recall the court's preference on the stipulations in front of the jury, or should we just do those right now, and then we can move right into
You mean stipulation to admission of exhibits?
Yes, and our first witness, so the court's aware, is our video analyst, and he's going to be playing a lot of videos. So the stipulations that we're looking for are defense exhibit C, C1, C2, C3, C4. And then videos J and K. And then an audio, that's exhibit HH.
Okay, I think these are all similar videos, so I have no objection here.
Okay, C was already admitted, stipulated to at the beginning of the trial. So because there's no objection to the exhibits that you just listed, I'll state for the record that C1, 2, 3, and 4 are admitted. I'm assuming they're separate exhibits from C. Also, I'm admitting J, K, and HH at this time.
And yeah, you're right, just so, it's HH, two H's, I don't know if I made that clear. Okay,
HH.
I'm sorry, I don't hear that well.
All right, and I also received the defense witness list, so I have that printed out as well, so that we'll hand that out to the jurors. And anything else? Before,
No, we're ready now.
okay. And anything for the people?
No, Your Honor.
All right, so we'll have them come in. And right after they come in, I'll have my clerk hand out the witness list. While your witness is coming in. Maybe seated. And my clerk is going to come around and hand out the defendant's witness list, much like the prosecution's witness list. I also have them do a list with names, with space for notes if you'd like to take them. And Mr. Jordan, you may call your first witness.
Thank you, Your Honor. Defense calls Patrick Lyoya. Good morning.
And sir, raise your right hand, my clerk will swear you.
Do solemnly swear that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Thank you. You may be seated.
If we can, I think he needs to be switched over to the card. Is that what, this one?
Should be.
You may proceed whenever you're ready.
Thank you, Your Honor. Good morning, Mr. McFarland.
Good morning.
Now, I've been referring to you for most of the trial, and you've been sitting back there, correct?
Correct.
All right, so you're a video guy?
Yes.
What's the technical term for what you do?
Forensic video analyst.
Okay, can you tell us a little bit about your background?
Yes. I was in the Air Force for about 8 years as a security policeman. From there, I served at the Oakland Police Department in Oakland, California for about 12 years. And after that, I've done litigation support at a law firm. And for almost the last decade, I've been doing forensic video analysis.
Okay. Tell us about your education and training.
I have a bachelor's degree in criminal justice management. I have almost 200, possibly more hours, 200 hours of training from an organization called LEVA. That's LEVA. It stands for Law Enforcement and Emergency Services Video Analyst Association International. And this particular association focuses on audio and video forensics for people in that specific field. I've attended their training. There are 4 levels. You attend level 1 and level 2, similar to Sergeant Batchelor, who was here. You get a certification of a video technician. And then since then, I've attended level 3 and level 4, which is the final level of their particular training. And from there, you go on to get certified by the organization as a forensic video analyst.
Qualifications as an expert.
Thank you, Mr. Becker.
Did you want to have them listed from the jury, or would you like to simply be recognized as an expert in this case?
I think we would ask that he be recognized as an expert, Your Honor.
Okay, an expert in what field?
Forensic video analysis.
And you have no objection? Correct. Okay, so he shall be considered an expert in that field.
Okay. So, Mr. McFarland, you were asked to do work on this particular case. What was the scope of your work for this matter?
I was provided with the cell phone video that we've watched, the dash cam video, and the body-worn camera of Officer Schurr. Those 3 videos were provided to me. I was asked to put them on a screen as a multiplex, sort of all 3 at the same time, to synchronize them so that the actions in the videos match, so you could see, and I'll point out those synchronization points. In addition to that, I was asked to create the same sort of matrix, but do a subtitled sort of transcript along the side for the words that were spoken that I could capture on the synchronized video. From there, I was asked to create a couple slow motion, maybe 1 slow motion exhibit and an enlarged or magnified cell phone video exhibit. And the last thing was dispatch audio file.
Okay. And you mentioned a synchronized exhibit. Tell us how you create a synchronized exhibit.
With that exhibit, there are three videos. I decompile or export each image individually as a bitmap file. Each image is a large raster file. It has a lot of information in it. You take all of the images out of each one of the video files, and then I numbered them. I labeled them so we know what camera the particular videos came from, and then I recompiled them back together. I also exported the audio files from each of the 3, put them into an audio program, and synchronized those 3 audio files and put them back into the matrix so we have the 3 videos that play at the same time and all 3 audios.
Okay. So let's pull up the synchronized video, which is Defense Exhibit A. And it's one that has already been admitted and the jury has already seen. And before you start anything, I want to ask you some questions about Defense Exhibit A. We've been talking a lot about RFN as sort of a way to bookmark particular parts of the synchronized video. What does RFN mean?
RFN is a relative frame number. With each video, as you see the dash cam videos on screen, there's what's called an AFN, which is an absolute frame number. For instance, the very first frame you see is number 1. The very first relative frame for the overall matrix is number 1. If I scrub forward just a little bit, I'll show you. We have an AFN that's on the dash cam. That's the absolute frame number for the dash cam. And down here on the bottom, we have an AFN for the cell phone video. So the reason we have an RFN is that when you look at this matrix, you refer to this as sort of the index or a bookmark for the particular video.
And how many RFN relative frames are there in 1 second?
In 1 second, this particular video, 30.
30. So 1 to 30 is actually 1 second, but it's broken down 1/30th at a time. Is that
Correct. Each image is 33 1,000ths of a second.
All right. Can you show the jury a couple of the synchronization points to show them how you did this?
Sure. One synchronization point is the time when Mr. Lyoya closes the door to his car.
And you can say which point you're talking about and how you're talking about it.
That's Mr. McFarland. If you could continually reference the RFN number.
Yes. So I'm going to first, because the purpose of this type of tool is to use it as sort of an analytical tool. It's tough to watch everything all at once. So you want to watch one video and then the next and then the next, and then you'll want to watch them all together. So right here, if we look at RFN 3103 in the dash cam, you see in the center of the image, the light from Officer Schurr's car glinting off of the door, the driver's side door that Mr. Lyoya is closing. I'm going forward a single frame at a time. And there we see it at 3107, it's closed. So if I go down to it's still open. Let me close it. Shut right there. 3108, it's closed. In the image below, it's closed. And so when we take it out, you can see the doors open and close in both images. There's another synchronization point with the action of Officer Schurr's foot, his right foot. And I'm at 5733, I believe. Let me find it. Just a second, looking at my notes. So it's right here. When we're at 5756, we inch forward and you look at the cell phone video, and I'm going to bring that in so you can see what I'm talking about. You see Officer Schurr's right foot. I'm going to back it up, and then I'm going to move it forward. And right here, we see his right foot is underneath Mr. Lyoya's left leg. If I go down, and that is RFN 5760. So I go down to the body-worn camera and back it up. You see his foot disappears just because it's off the image. When I inch forward, we see it's in place at 5761, 5760.
Okay, thank you. That was very interesting, but what's the point of doing the synchronization as a forensic video analyst?
When you do a multi-view, you want the people who are viewing what you have on the screen to understand that it's synchronized, that you're not just throwing 3 videos up there and playing them and hoping that they can understand what's happening. So you synchronize the dash cam with the body-worn camera, and then the cell phone video was only on for a short time, but I was only able to synchronize that with the body-worn camera. And so that shows that all 3 have synchronization points.
And what's the benefit of having a synchronized video?
It's a multi-view, sort of give you different angles of the incident. Because when you look at a video, you're looking at a 2-dimensional image of a three-dimensional incident. When you have multiple angles, you can see what's occurring from different camera angles at the same time, simultaneously.
Can you give us an example of what you're talking about?
Yes. We could go, well, here's an example. So on the RFN 4696, I'll zoom in so we can see what's happening here. We see Officer Schurr on the back of Mr. Lyoya. We see his right arm over Mr. Lyoya's right shoulder. And it's tough to tell because it's at a distance and it's a bit pixelated. But we see sort of the same thing. But when you back out and you look at it, we also see in the distance, I believe that's Fred Butler in the white t-shirt. He's got his arm extended and he's pointing. And if I inch forward, you see the movement of Officer Schurr's left elbow come up. That's when he grabbed his radio. So I'm going to go back to 4697 and I'm going to go forward to 4703. And I'll continue to go forward. And we see in both of the videos, the left or the right arm of Mr. Lyoya come up. I can go back and forward. And then if I play it, we're at 4726. You see them both up and standing at 4810.
And you did that, you watched all the videos in a synchronized format and analyzed it pretty much frame by frame, right?
Correct.
And you also created a synchronized exhibit that includes a transcript.
Yes.
Tell us how you created that.
It is the same video, the synchronized video. I just added a section of pixels on the right side of it, and I had the audio playing in a separate program. And when words were spoken, at the time the words were spoken, they started to be spoken, I would put the sentence or the phrase into the video itself as the subtitles of what they're saying, so that the statement starts as on the screen, starts at the same time.
Okay. And this has already been admitted as defense exhibit B, Your Honor. If you could go ahead and play that video start to finish.
Yes.
At normal speed.
Yes.
Nelson, North of Grace, King Paul, 9367, Hamilton. Hey, stay in the car! Stay in the car! Stay in the car! Get in the car! Dude, I'm stopping you. You have a license? You have a license? I'm stopping you. Do you have a license? Do you have a driver's license? Do you speak English? Yes. Can I see your license? What do you want? The plate doesn't belong in this car. Do you have a license or no? Do you have a driver's license? Yes. Where is it at? Get it for me. The plate does not belong in this car. No, no, no. Stop. Stop. Put your hands down. Stop. I can't get it. Yeah, we're on it. We're on it. Stop. 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 Okay. Stop. Stop. Get your hands behind your back, okay? Hands behind your back, okay? Get your hands behind your back. 1950, 34 cars. Okay. Stop. Stop resisting.
Hey, good now, you did nothing, bro. Why you gotta do what up, bro? He's good, man.
Let go of the taser. Let go of the taser.
No, that he's good. Like, you can talk to him, bro. Yeah. Like, he's good, bro. Like, can you talk to him like good? Like, can you, yeah. Stop grabbing him like that. Like, he's good at first. No, you hit him too. No, he ain't got no taser. I see.
Let go of the taser.
How many times you got going?
Stop the taser.
Everyone. Six in total. Is this guy something else in the game? It is.
Get back.
Thank you, 15. For the shooting. That would be great. 1915, 10-4, Nelson agrees. Sorry, medical. Thank you, 15. Are y'all there? Nothing great, nothing for. Something down. Nelson, North Norfolk. Nelson, North Norfolk, suspect down. 1920, I've seen. 15 Roger, subject, the access city weapons, what do you think? 1950, here's my taser. Staging till we figure it out.
I got the car on the driver's side.
You and I have seen heading to the north off of Oroville. 1918 looks like you're coming in. 1918 Oroville. Definitely. Between 1746 and 1752. Can you call those two residents for me to know where that was?
Now, Mr. McFarland, at the beginning of this video, and we've seen it several times by now, you see Officer Schurr in his car as his body cam goes on, but there's no sound. Can
Right.
you explain why that is?
The Axon Body 3 at this particular time had what's called a pre-event record buffer. And what happens with that is your body-worn camera is constantly buffering. It's capturing images. When the officer activates the camera, that only activates the audio, but what it does is save or preserve the last 30 seconds of images. So when this camera right here is on, he actually didn't activate it until 30 seconds later. These are images that were in this buffer, so to speak, for 30 seconds.
And, you created this transcript. Are you the one that created the transcript?
Yes,
And you use headphones to listen?
I did.
Okay, and it's to the best of your ability, but you understand the jury's the one that decides what is actually being said.
Correct.
This isn't a certified court reporter transcript.
It is not.
All right, so you made some smaller videos related to the cell phone. That's Mr. Tuyasheme's cell phone, right?
Right.
And those are C1, C2, C3, and C4.
Yes.
Why did you do that?
When you look at the matrix or the three videos on the screen at the same time, you can see the cell phone videos sort of long and tall and distant. And the reason for the creation of the cell phone video is to crop the top just because that's where all of the action occurred. Nothing happened in the lower half of the cell phone video. So I made that so it could fit on the screen without continually zooming in and out and such. Also, that the other two exhibits were the motion tracking for the taser wires and or the probes, and then the final one was the part of the incident in slow motion.
Okay, well, so let's start with C1. This is the cropped image. Could you play that for the jury, please?
Yes. Oops. So this is the first frame. Up here in the left, I put the RFN number just because we've been relating to the RFN number and everything. This is the RFN number where the cell phone video lands in the synchronized exhibit.
And what is that number?
The RFN number 4146, I believe.
And that's when the cell phone video starts?
In RFN 4146, correct. I'll play it.
Yes, I'll reach you back. Okay?
Yeah, man, you good.
Sure is on your back.
Don't go in like that, though. Yeah.
1950, service more cars. Okay?
Now, he said he's good for me. But, yo, what's up, man?
Stop. Okay? Stop resisting.
Now, he good now, resisting nothing, bro. Okay, why you gotta do all that, bro? He good, man.
Let go of the taser. Let go of the taser.
No, like he good, like you can talk to him, bro. Yeah, like he good, bro. Like, can you talk to him like good, like, can you, yeah. Stop grabbing him like that.
No.
Like, he good, like, for real. Yo, you hear him too.
Let go of the taser.
Now, he ain't got no taser. I see that.
Let go of the taser. Stop taser. Get back! 1915, I'll just about that shooting. Nelson Grant. Nelson.
Okay, and then you made additional videos from that video. Exhibit C2, can you tell us what we can see and then play the video?
Yes, this is the last part. This is a segment of the cell phone video. It is,
This is C2, right? Exhibit C2.
C2?
yes,
Yeah, you're using C2, Mr. Crown?
I am. This is 6 seconds in length. It's the last portion prior to the shot being fired.
Go ahead and play. And now there's a yellow box in the bottom of exhibit C2. Can you describe to the jury what you did there and why it's?
That particular portion there, I magnified what you could see in the smaller box in the video, and that was to capture the taser in the hand of Mr. Lyoya.
And exhibit C3?
This is, it looks like the same thing, same exhibit.
Is it in the same speed or is it slow?
Let's
slow
see.
motion?
Slow motion,
Okay. So that
5 frames per second.
Right, so the difference is the speed of the play.
Yes. And again, this stops prior to the shot being fired, about 15 frames or half a second.
Okay. And, you know, we neglected to say the RFN numbers
Okay.
for C.
For both those exhibits are RFN 7407 through 7602.
And then there's a C4.
Yes.
What is exhibit C4?
This is just the full length with no motion tracking. It just runs the length of the incident. Oh, I guess it does. So it's a mixture of, it has the taser wire motion tracking, and it also has the magnification part where we point out Mr. Lyoya in possession of the taser.
Let's talk about you said it's the taser wire motion tracking. What do you mean by that?
I put the video in my forensic software, AMP5, and I circled the images where the taser probes were present and they were being dragged across the lawn. And it's motion tracking is what it's considered when you do a single frame advance and you keep that circle over it and you go all the way to where it's no longer useful, and then you back it up and you put a different circle around the other one and you do the same thing. And then when you play the video, those filters are applied over the video to show you where those taser probes are going.
Okay, and this program that you use is called AMP5. It's the same one that Sergeant Batchelor uses?
Yes, AMP is just the word AMP, and 5 is FIVE. It's an acronym for Forensic Image and Video Enhancement.
Well, we want to see the whole video again. Could you just go to the part where you just referenced with the wires and the motion tracking?
Yes.
And reference the RFN number and then tell us what you're seeing here.
Okay, we're at RFN 5719. The yellow circle, it's kind of hard to tell now, but it's encircling one of the probes. And the reason I knew that that's where it was is because I watched this enough times and watched it go across the grass that I had to back up to where I first could see it and circle it. And then I can inch forward from RFN 5719 and you can see it move across the grass. And then you see the blue circle come on, and that's another probe, same sort of motion tracking. And I follow that as they both are.
If you could stop for a second and back up 2 frames, maybe 3. You can actually see some sort of gray-white thing dropping down. Do you know what that is?
Gray-white thing.
Is it rain?
Oh, yes, those are raindrops.
So this is slow enough. You can actually see the rain coming across.
Yes,
the line.
sort of motion blur, but you can see the raindrops as they're descending. You could also see in this on Officer Schurr's right leg, and I'll zoom in a little. Those are the taser wires. I'm not sure who they're wrapped around, but those are the wires of the taser going across Officer Schurr's right lower leg. And I can inch forward. Now we can see that they're look to be to the around Mr. Lyoya. And we continue forward 5741, and we can see the probes move 5754. I lost the blue one momentarily. And I picked it back up at 5775, and I'll just inch forward and you can see the probes move. Here we are at 5790. They seem to be sort of stable. Closer together at 5809. And that's sort of where they end up. Five, 827.
You analyzed all these videos. You looked at them many times, I assume.
I did.
Okay. And you were able to find significant points like this, where the taser wires, you could actually see them sort of bouncing across the lawn.
Yes.
All right. You have the ability to take still shots and create exhibits on the stand, correct?
Yes.
All right. I'm going to ask you to do that as we go along. You don't have to make the exhibit now, but if you could, we could just say we're going to make an exhibit now and then make them all later. And can you put that in a file, and then we'll ask the court if we can move it into evidence?
Yes, I would do sequential images.
Okay. And we're going to start with the majority of the moments that you're going to capture. Is it from a particular exhibit, A, B, or C, or?
I would say that the best exhibit is the one with the transcript.
Okay. And that's B. So when I call out an exhibit, I'd like you to note that RFN for the record, explain what's on there, and then we'll identify it, and then I'll move it in for admission at the completion of your testimony.
Okay.
All right. And now you saw significant points. Obviously, it's not that long of a video, relatively speaking, right?
Correct.
But the advantage of blowing things up is to show the jury things that is not readily apparent from just watching either the cell phone video or the body cam.
That's correct.
All right. I'd like you to go to RFN 265. It's basically the start of the video. And play that till about 3:14. Tell us what's going on here.
Okay. So 265. This is the part of the incident where Officer Schurr is making just about completing a U-turn to pull in behind Mr. Lyoya, and in the distance, where my arrow is pointing in the dash cam, almost in the middle of the dash cam image, we can see a car, and that car is Mr. Lyoya's car. And if I play it forward, you can see the car move and also Officer Schurr accelerate. And I'm sorry, where did you want me to go to?
314.
Okay,
That's not very long, is it?
no.
If you could mark as exhibit, just to be safe, we're going to call this B3. And if you could back it up a little bit so you could see Mr. Lyoya's car. And that would be RFN 269. That's going to be exhibit B3.
Okay.
And then further on in the video, Mr. Lyoya takes a second right turn. Can you go to that around RFN 499?
Back up here.
Go ahead and play a little bit.
So we'll start at RFN 492. On the right side of the dash cam, you see brake lights. And this is Mr. Lyoya's car down the street a little bit, and I'll play it. And at 696, Mr. Lyoya completes the right-hand turn.
Okay, we can mark that as B4, RFN 696. And then if you could go forward to Officer Schurr, calling the stop out and Mr. Lyoya exiting the car.
So this is right about RFN 1020. And what you'll see here in the dash cam or the body worn camera video, you're going to see Officer Schurr's hand coming up across toward his face with a police microphone in his hand, his right hand, and Mr. Lyoya exiting his car.
Nelson, North of Grace, recovered King Paul, 9367, Hamilton. Hey, stay in the car!
And we're at RFN 1280. Could you tell the jury what they see in this part of the synchronized video?
This is Officer Schurr getting out of his car right after Mr. Lyoya exited his car.
Okay, and that's going to be marked as B5. And if you could play forward until we get to where Mr. Chiyoshime opens the glove box.
Stay in the car! Stay in the car! Get in the car! Dude, I'm stopping you. You have a license? You have a license. I'm stopping you. Do you have a license? Do you have a driver's license? Do you speak English? Yes. Can I see your license? What do you want? The plate doesn't belong in this car. Do you have a license or no? Do you have a driver's license? Yes. Where is it at? Get it for me. The plate does not belong in this car.
So I'm going to pause here at 2737.
Okay.
And I'm going to zoom in on the body worn camera. And at the near the B pillar of the car, there's a hand that is the right passenger. And as I inch it forward, you're going to see he right there opens the glove box, and the glove box is open at RFN 2807.
And can you toggle back and forth so we can see the glove box open and close?
Yes. Closed. Open.
And the order's open, closed, right? Not close open.
Oh, I just reversed it, sorry.
And so could you find an RFM where you can see Mr. Tiusheme's hand on the glove box?
Yes. RFN 2759.
That's gonna be P6. And if you could go forward to the point where Mr. Lyoya breaks away and shoves Officer Schurr.
Yes. Okay, RFN 3317.
Okay, and what do you see on that?
You see the clenched fist of Mr. Lyoya, his left fist. You can see his right hand, and you see Officer Schurr holding the left and right wrists of Mr. Lyoya with his left and right hands.
Okay, if you could make that B7, what was it, RFN 3317?
Yes.
If you could go forward to the point of the breakaway.
Okay. I'll play it and then come back.
Okay.
More or less right here to 3349 where he's completely free.
Okay, and is there any point where you see Officer Schurr be shoved backwards?
Yes. So I'll go back to 3317. And then I'm going to single frame advance the images. So if we advance to 3318, we see the right hand of Mr. Lyoya come closer to Officer Schurr's body-worn camera. Then his right hand breaks free from Officer Schurr's right hand. And I'm inching forward. At 3329, Officer Schurr grabs the right shoulder area of the sweater Mr. Lyoya has on. And you can see in 333, Officer Schurr's hands are now sort of crossed in front of him. And you see Mr. Lyoya's arms and hands are up in the area of the forearms of Officer Schurr. And as we inch forward to 3340, we can see the knuckles from the right hand of Mr. Lyoya over Officer Schurr's left forearm. We can see Officer Schurr's left hand making contact with his right forearm. And then as we continue forward to 3344, we see that Mr. Lyoya is completely free. But if we back up at the point of 3340, this is right around, I'm going to go back to 3338 and single frame advance and just pay attention to the dash cam. Officer Schurr, both feet are off the ground. And I go back and you can see Officer Schurr stop right there. So you toggle this action. And you saw what happened in the body worn camera, but now you have it from a different angle. And I toggled that section 3345 to 3345.
You said you toggled 3345, but I think you said 3345 again. When you say toggle, you mean you're moving frame to frame?
It's 3338 to 3345.
Okay. Do you have the ability to take multiple images and put them in one exhibit?
Yes.
Okay. So can you mark 3338 to 3345 as B8?
Okay.
Okay, and at this point, you also have a timer, and it's in the bottom right of the exhibit B, and it keeps time to the second, and then it's 8, 12, 55, and you have .403. Now, we're not used to even the 55. Can you explain to what degree of accuracy the clock is?
So the 403 is milliseconds. Because there are 30 frames in a second, when you watch a video and you say, I'm stopping the video at 3 minutes and 55 seconds into the video, the question becomes, well, which one of those 30 images did you stop on? So that's the reason for the numbering, but also for the millisecond. If you wanted to understand timing, you would understand everything right down to the millisecond.
Okay, and you were asked to figure out some timing, and you were asked how much time it lasts for the time Mr. Lyoya exited his car to this point right here in RFN 3338.
Yes, that was approximately 1 minute and 10 seconds.
All right, and now we're going to skip forward to past the chase to the point where Mr. Lyoya first gets to his feet.
Okay. We're going to RFN 3582, and I'm going to zoom in on the dash cam. And you can see, if I toggle forward and back, you can see that the legs and feet of Officer Schurr up in the air as he's on the back of Mr. Lyoya. And they're both appear to be facing northbound.
That direction's north?
Going toward from the back of the car, Mr. Lyoya's car, to the front is north.
Okay. You actually figured that out?
He said somebody was running northbound.
Oh, okay. All right. And so if you could toggle forward or play forward to 3778.
You can't see the RFN when I'm zoomed in, sorry.
Okay.
So there was about right here.
Okay.
3778, and I'll zoom back in on the dash cam video. And you can see Mr. Lyoya's up to his feet.
Okay. What RFN are you on?
3778.
And you previously had showed us in the dash cam video, Officer Schurr's feet were in the air and they were headed north.
Yes.
Do you recall what RFN that was?
The first one of this,
Yeah, I forgot to ask you.
that would be 3582. Let me go back and make sure.
At this point, I'm going to object. I don't know what the relevance is. They can play around with the video as much as they want in the jury room. So, I mean, I was giving them some leeway, but I don't know what we're doing here.
It's not our published in the jury, things that the forensic analyst has either blown up. They won't have the ability to blow these up. Certainly the jury's.
What's your response to his objection about the relevance?
I'm explaining the relevance is we're showing, posting to the jury, blown up and highlighted areas that the expert is specified. And he's explaining how we made those exhibits, and I'm making exhibits for the jury's consideration so they can view the evidence through Mr. McFarland's work.
Sure, I mean, it's up to your discretion. That's my objection. I gave you some leeway, but this is seems to be going on.
Right, it's pretty cumulative, I believe, and I mean, the jury will have your exhibit, so I don't know that highlighting certain portions is relevant.
I don't know that the jury is going to have the ability to blow anything up, Your Honor, or
Or if they want to.
Well, I mean, if they don't want to, that's up to them, but I've seen the TV, it's a box TV back there, and there's no ability. Certainly the jury, at the end of the questioning, can ask Mr. McFarland if they want to blow something up right now and make an exhibit.
So, I mean, what I'll do is I'll sustain the objection. This doesn't seem like a good use of the court's time to go through each frame and blow certain ones up and making them into separate exhibits. Obviously, the jury will have access to the exhibit. They can play it as fast or as slow as they would like. If they're unable to see it in the jury room for any reason, we can certainly come back out and play for them whatever they would like on the record and blow it up.
Yeah, all right, may I just make a record of the ones that we're going to blow up and move into evidence?
How
And
many
then,
are there? It sounds like.
well, there's much less than the thousands that the prosecution has entered into evidence, but
Well, I don't recall them doing any thousands of blown up images.
they went through and published some of the thousands that they, I think they said it was about 1,000
Thousand what?
images. That's their exhibit. He broke down still frames, and then he's been calling them out through the testimony. And so we'd like the opportunity to do the same.
I don't recall this happening in prosecution's case in chief, but I do find that, again, this is cumulative, and so I'm gonna sustain the objection. I'm not sure the benefit of this exercise to the jury. I don't know that it's a good use of our time.
Your Honor, my client has a right to present a defense. We believe that that includes analyzing the video in front of the jury. We're far away. If these things need to be blown up, they're not going to have the ability to blow it up. I think they're entitled to see what Mr. McFarland's work has been done. There's no objection to his qualifications. There's no objections to the exhibit. But I would like to make additional exhibits that we believe are important to the defense of my client. If the court's not willing to let me publish them now, I would like to be able to enter them into evidence at a later time. I can recall Mr. Brown without publishing them to the jury. And that would save some time if that's the court's concern.
That is my concern, because this seems like it's very time consuming.
I have no objection to that. If they want to create something off site and we can take a look at that, that's fine. It just seems like this.
Would you like to blow up certain parts of, because it sounds like you're creating an exhibit as we're sitting here with.
We are,
the,
yeah.
and I don't believe that that is something your client would have a right to do, create exhibits on the fly like this. So it sounds like there's no problem with your witness creating additional exhibits that go along with this one to blow up the areas that you would like for him to, without us having him to go frame by frame and doing that on the record.
Okay, Ron, what I'd like to do is, well, to save time, we'll have our coordinated, and then we can always recall Mr. McFarland and the jury if they want to pass a note that we'd like to see this part blown up or something. Certainly, that's something that they can do now. It's going to be a lot easier with the software that they're not going to have unless the court is going to allow us.
Again, I'm not saying you can't put those exhibits in. I'm saying you're creating the exhibits and saying, stop at this, go this many frames. Oh, wait, go back. I think I forgot which one we were at. So he's creating the exhibit on the fly right now. I don't have any problem if there's no objection, especially to admitting those exhibits if they're created. I just don't think it's a good use of time to create them on the record right now. So I'm not sure. So I'm sustaining the objection to the extent that it.
It's a waste of time.
It was a bit cumulative.
Well, I don't know that it's cumulative, Your Honor, since we're not taking the same picture over and over again. And so what we'll do, Your Honor, is we're at B10. We had a number about 1, 2, 3, 4, 5, 6, 7, 8, 9, 10.
So you have more areas that you would like blown up.
Yeah,
for
so
this witness. So he can do that, create that, and then you can certainly recall him, and then he can go through those particular ones. And then I think that would be more efficient for
Okay.
the court.
Fair enough, Your Honor. We can do that.
Did you have other questions for him, or was that?
No, that's not, that's all he's doing is looking at the videos.
Okay.
Okay, I'm not gonna have you play this one, but the exhibit HH, it's already in evidence. Can you tell the jury what that is?
This is the truncated dispatch audio. We received this audio file of the communications between dispatch and Officer Schurr and other units in the field. It wasn't received in real time. It was each individual transmission put into one continuous stream. And for that particular exhibit, I took the audio from the synchronized video file and put that in an audio program called Audacity. And then I put silence in between the transmissions to match the timing of the transmissions in the synchronized video so that when you listen to the dispatch audio, it plays back in real time.
Okay, and we'll publish that at a later time, Your Honor. And I just wanted him to explain what it was.
So you don't want to post that now?
How long is it?
I think it's 4 minutes long.
It's up to you if you want to publish it now. That's fine, since it's already been admitted.
Okay, if the court's okay with that, we'll just publish it now. If you could just play HH.
Down. 1915. Nelson, North Grade, W2 Paul, 9367, Dan Nelson and Graves.
So we're hearing nothing right now. What does that mean?
That's the time when Officer Schurr announced the car stop, and the car stop was acknowledged by dispatch. And there's silence because nobody else is providing any transmissions.
Okay, so this is only Officer Schurr and dispatch. What's dispatch?
Dispatch is the police dispatcher at the police department in the communications division. They're the ones who receive the transmission from the officers.
Got running. Go back. One running northbound, additional units of Nelson and Graves. Turn more cars. 1915, what's your location? What's your location?
1915.
How many cars you got going?
Everyone. 6 in total.
Is this car still Nelson and Gray?
It is.
1915. I was just involved in shooting. Nelson Gray.
1915 10-4 Nelson and Graves. Starting medical.
1915. I'm Nelson. Northern Gray, 7-4. Northwick down. 11-7, so we pull 23.
Nelson, North Graves, suspect down.
1920, I've seen. 1510, or your subject, the access to any weapons, and which way you think? 1950, that's my taser. We're addressing one more.
1625 10-4 addressing one more.
15, then once you start a couple ambulances, started switch.
They're on the way, mid one. 1610, they're staging till we figure it out.
That's the evidence of the HH drive. And so I think the plan is for Mr. McFarland to step down but not be excused.
Right. Sir, you may step down at this time, and Mr. Becker, I'll wait and allow you to do cross-examination once they're finished creating those exhibits, and then I believe moving further admission and possibly function with the jury, and then I'll let you do your cross unless you want to cross on what's been asked.
I have no cross right now, so unless, depends on what you present with this exhibits, but at this point in time, I would have no cross.
Okay. All right, so then you can step down, Mr. McFarland, and have your next meeting.
Yeah, we need a break. We're not ready to call someone right now, but we probably have another like half hour.
Oh, okay.
Sorry.
Okay, so, I guess we can for lunch now.
If that's okay, I know it's a bit early. Maybe people are hungry.
Okay. So then that means we start back up earlier, because we still have the same hour-long break. There's also, you have a question for the witness? So my clerk will grab it, we'll see if you need to answer it now, or if you can wait until he's recalled, because he will be recalled. Oh, I think this is a fair motion that.
Right. They went for lunch. whatever the judge was trying to say and trying to explain and say no or not, I couldn't hear a thing. I have this. She's back again.
Good question. The comments that are get the keys, Amy, get the keys. There were 3 comments. They had the asterisk next to them. That was there because the audio, when I synchronized the 3 audios together, the body worn camera kind of distorted some of the sound. When you listen to those comments, they're more clear on the cell phone video all by itself. So the asterisk was there just to point out that you can hear them, but if you want to hear them better, look at the cell phone video and listen to that audio.
Great, thank you. We will take a break for lunch and we'll come back at 1:45. It's almost 1:45. I don't know if that'll be enough. I don't know if it'll be lunch or but anyway, we'll make sure everyone eats. Meanwhile, if you please leave your notes again upside down in your chairs. Please remember to not discuss the case with each other or with anyone else. Also, please remember the restrictions with respect to news reports on the media, in the media and on social media. And then we'll see you back in about an hour or so.
Welcome back. I'm Lauren.
All right, well, I am gonna remove them for a little bit so we can chit chat. And we've got Zio in the house. She can come up on stage any moment that you want, if she can hear me. Because you guys know it's Wednesday. I'm gonna go away for a little bit. I'll come back. I'll come back. But yeah, because it's Wednesday, you guys know I have my commitment. Even though I am not feeling great, I still have to honor my word. Um, but the judge was ruling on some stuff, right? Okay, they are just rewatching stuff. I'm keeping an eye on the other feed because I've got 2 feeds ongoing right now. But it's she's she's going on something else. They are rewatching the thing like they always do. So the judge needs to start listening for needs to turn on the microphone because we cannot hear her, and that is annoying me. Um, that is very, very annoying me because we can't hear anything. It's really angering me because we can't hear whatever she says. I have this boosted. I have my sound thingy majiga up to the maximum. I can't put it at more than it already is. And yeah, there is a defeat that I'm keeping an eye on that you guys got solved for a millisecond there because Zio is playing in the background. And I don't know. I just hello.
Peekaboo.
Peekaboo. Hang on, let me mute my feed because the woman is talking in my ears and she's annoying me. Oh, we are together again. Yay! Look
Together
at us.
again.
Okay. Okay.
We're little
All right. No,
bitty.
we're little babies though. Hang on. So just trying to learn to maneuver through Facebook and other platforms. Oh, it's okay. Like if you need any help, just shout, William, and yeah. So just let us know. So I know because it's like I have the audio boosted. You can hear the. I don't think she has the microphone on, or she's not talking to the microphone, which really annoys me. Really grinds my geese. No, I didn't hear anything that huh? The judge said. So I don't know because they said they went on lunch break first this quick and this early because they said we the next witness is not ready yet. We have a next witness, but is not ready yet. So hang on 1 second. You're playing music, and I was like, what's going on?
can't even hear it.
I had one headphone in and I'm like, I'm hearing something else. Do I have an? Yeah, it's just you. Yeah, I hear music too. I was like, huh? So
You can make me
slowly
laugh.
she's trying to Katya, shut up, go.
No. How long are you gone today?
Okay.
¿Cuánto tiempo te vas a salir?
Oh, hoy.
No, mañana.
Mañana. Hang on, let me do math in my head. So,
It's a while. A while.
Oh, come on. About 4 hours.
We'll be done by the time you get back.
4 horas. Is that okay?
Yeah, we'll be done by the time you get back.
Well, the thing is,
No, you're gonna miss a verdict.
We ain't gonna get a verdict today. Are you nuts?
I'm just kidding.
Are you nuts? We're not gonna get a verdict today. But no, I was like, the thing is, Garden Bot wants to take me out for dinner after the commitment we have. And I want to say yes, but I don't want to, like, you guys think that I'm barely here now, or I always have you or Robert doing it.
You gotta play hard to get. You're like, no, Garden Bot, I can't do that.
I need to tell him to listen to this so we can listen.
That was Katya. That was not me.
That was not me. Repeat that, because now he's listening. So repeat that. Repeat what you said.
You know, hablo inglés. No, what about. Why does it say? Are we day 2? Aren't we on day 3, Sweet Pea?
Yeah, we are in day 3. I say day 3. Who says day 2?
Your live stream, your SEO says day 2.
Oh, I forgot to change that. Are you yawning? Yeah, Paula says to stop yawning. Stop yawning.
Just take us all out for dinner. That's right.
Well, I can take the computer there. That's for sure. I can take you all for dinner, and then you guys bite. No, I'm joking. Hey, I am not shy. You know.
So Judge Pretty Curls, you couldn't even hear what she said, huh?
Oh man, that judge. I'm sorry, but she needs to speak up or speak into the microphone, cause girl, I can't hear her.
Couldn't hear a word.
She speaks like this, and then I don't know what is.
You got burnt today in the sunshine?
Yeah, because he forgot to put sunscreen, and let's not start on that one because I've already told him off. Yeah, Mister, I forget to put sunscreen on.
Oh, that other feed ended.
I can live stream that. I can put another camera on the screen, and you guys can see the pub that we're going to, because we're going to a pub. The place that we are gonna go eat. Well, it's not that hard to do. But then, yeah. So yeah, maybe, could be this. Yes, William. Yes, it is the defense case now. Oh, look at the birdies. So yeah, this was the first witness for the defense. That was the video analyst. He literally went frame by frame through this video, very exhaustively. And yeah, you know what? I will try to zoom in from there. Zoom in, come in on the StreamYard through there, and so you guys can see a UK pub in real live from the pub, and then
You're even allowed to film in there?
Yeah, why wouldn't you be?
I don't know. I don't know where you're allowed to film and where you're not.
I film everywhere. I just don't film in the bathroom because it's not you know. No, I'm joking.
So I'm quite perplexed on the mixed signals I'm getting. So there is a trial that you and
Not
I've
for
talked
me.
about. No, there's a trial that I want to cover out of California, and it's been saying that they're doing jury selection for the past 2 days, and that today, hi Garden Butt, you have a feeder cam.
Oh, you need to stream that, Zizi. You should stream that. If you have a feeder cam, go
Right?
on YouTube and yeah.
Lots of people will sit and watch it. I put this kind of stuff up for my puppies when I leave home so that they're not
You
bored.
never leave home.
Right, so I never put it up. But when I do, what I was saying was that I wanted to stream this case out of California, and they said they started jury selection and trial should have started today, and that's what I planned on doing for the next 75,000 weeks of my life, and it's not on.
Yeah. Oh man, I
We'll
was
try.
looking forward to that, but
Yeah, we'll
like
try
I'm not
again
gonna like.
tomorrow.
Yeah, because the thing is, you might just actually take the whole day in jury selection, because it's only barely 9 a.m. there today, isn't it?
Yeah,
Right
well,
now.
so the last 2 days they've done jury selection. Today was supposed to start the trial, but
So they
maybe
got a
there's a
jury
delay.
though.
That's what they said. They said they seated the jury, but like I said, I'm going to keep watch, and we'll just keep watching,
Yeah.
and then hopefully this trial will be
Maybe.
done, and you can come and visit me for a little while. And
Yeah, of course, that would be awesome. Because I was really interested in that case, but as you guys know, it's California time, and we run out of California as everything,
California, yeah. Well, we'll take it.
Yay! Yeah. Do not copyright me. I'm halfway. Whoop, whoop. Toasty
We're gonna
Bot.
rename
Yes,
Garden
William.
Bot to Toasty Bot.
Yes, I think that's his new name. But you guys probably can't see as much through the screen and because of the lights and everything. But I need to take a picture proper, like of how tan Garden Bot is. He gets very, very tanned during the summer, which I don't mind at all. I am very sad about that. Oh no, I'm gonna cry of how sad I am. Guess he gets even sorry to say, sexier. So.
How dare you think your husband's good looking? Like, why would you even?
How dare I? Isn't it? It's so it gets very, very. Oh, I like it. I love it. So, yeah, it is a butt. So yeah. So where's this cam feed from? Is it
This is Michigan.
Oh, is this Michigan? Nice weather then. Well, yes, more than the Portuguese, because I don't go out in the sun. I run away from the sun. I don't like it.
That's because you're a vampire.
You know what? Like, she has. It's gonna be live, right?
What is?
Because Donna Adelson has a hearing today. You could cover that if you wanted to. I am gonna cover that. You guys know we're gonna cover the Donna Adelson hearing. It's at 4 p.m. Florida time, 4 p.m. But we can, after the court, we can watch that, or we can watch during a verdict watch.
Yeah, we'll see if you're awake at 4 p.m.
Well, I will be, because yeah, I really want to cover that Adelson hearing. It's absolutely guaranteed. So probably over after the court, or even tomorrow or something, because we have my days, we have so much stuff to cover, because I've been finding things. You guys know me. I have sometimes way too much time on my hands somehow.
Yeah,
I found
her.
Go.
So her request for the new judge was denied like a week and a half ago.
I think this one is because there was a lot of new evidence or evidence coming in, and they are gonna ask for a continuance on the case. So, yeah.
Gotcha. So for
yes,
new
Zizzy, if you
discovery.
get your up, share with me, and we can work that together. Absolutely, that would be amazing, girl. But yeah,
There's a person. There's a man there. There's a tiny
Where?
man down there. There was a tiny man. Look in the right. There's a tiny man down there eating the bird food.
Yeah, I saw.
He's eating the bird food.
Exciting. Sorry.
Get out of here, tiny man, eating the bird food.
We only ever see the birds go away. So yeah, so there's that hearing today from Donna Adelson. There is the cross-examination of the Jennifer McCabe. There's two people. It's getting exciting.
They're all eating bird food.
He's changing the buzz water.
Listen,
he's looking at the
listen,
camera.
sissy. Don't ruin my fantastical
Knowledge?
fantasies about what they're doing. Yeah, they're eating bird food down there. That's what it is.
It's your perception.
She's always trying to break my balls, I swear.
But what I was gonna say, so we have loads to do. We have a loads to cover. So we've got this trial to finish. I am waving. You can't see me, but I am waving. So we have we have the people to cover. We have this trial to cover, right? We have the Donna Adelson to cover. We have the Jennifer McCabe cross-examination to cover. And I found out a sentencing for Jalen Jackson that he wasn't involved on another speed car chase, but in the wrong way in Cleveland. So there's a sentencing for that I want to watch it as well. So we've got a lot of stuff to do, guys. There is a lot going on. So maybe the next, if I know that one is shocking. When I saw, I was like, whoop, save it for later. Save it for later. Yeah. So we will do Donna. Dawn is only at 4 p.m. Eastern, so we might do after court today. Not 100% sure. I'll see how I feel when I get back, because obviously Zia is going to probably be with you until I get back from my night out, and then we'll go from there. But tomorrow, while we are we're moving. What's happening? Tomorrow, definitely, while we are on Verdict Watch, which I think tomorrow we might be in Verdict Watch. So we can cover all of that good stuff. I agree. I will probably, maybe. We can watch the Spicy KR. We can stay online until 5 o'clock in the morning. I would.
We can do what we want.
We can do what we want. There is the Spicy KR. There is the Donna Adelson hearing. We are going to cover everything.
We did a short video this morning on part of the Tyree Nichols case where Desmond Mills Jr. was testifying. This evening or tomorrow morning, Kathy and I will be putting out a video of Tyree Nichols' mother. She was speaking about the Scorpion officers that were charged in her son's homicide. So we're going to do that. So that video will be coming out tonight or in the morning.
Yeah, we're going to do that. And also, when they go on Verdict Watch for that case, we are going to be on Verdict Watch for that case. And hopefully we'll be going live at that for that case. That is an awful case. I absolutely agree, Zizzy. Absolutely awful. Absolutely horrendous
Now,
case.
I'm going to say this out loud as well, and just in case something happens, we are having terrible storms here, and my lights have flickered off and on a couple of times. So if for some reason that happens, I will get on my phone and I will make an announcement. I'll let everybody know, but we should be okay.
Okay,
Your feed
if not,
up in the background, so.
Yeah, if not, well, you can't do anything. If not, just text me and I'll rush home. So just make sure that you are okay. Make sure that you and yours are okay, Dofa. You guys come first, obviously. You know that.
Yeah, no, we're okay.
Hannah, hello. Good morning, good afternoon. Well, for you, it's good afternoon, good evening almost. Hopefully you are okay. And and you caused a lot of chaos. You need to put stuff back, man.
Yep. Everybody was wondering where you were.
Yeah, I think everyone had gone to a rabbit hole of Karen Reed.
Where are you? Because you're the one who tells everybody that it's guilty. Guilty verdict, done. Case closed.
Yeah,
move on to the next one.
I know. Oh, you know that case that we were watching out for the Colorado one, that was the RV and
the golden
case.
RV.
They haven't been streaming that because it said Jefferson County on 130, but they haven't.
They haven't been streaming that.
Where have you been? I don't know. Where have you been, Hannah? If you've been enjoying the sunshine that UK has, I hope you are okay though. Before I forget, pickles. Fair enough. Absolutely agree. It's absolutely necessary. Sometimes it's good to stay back, go outside, touch grass, and get in. Yeah, absolutely agree.
I have a song about touching grass. I will play that at lunchtime Either if I don't have a chance to do it today, I will play that tomorrow. I wrote Katya a
Yeah.
song about reaching out and touching grass.
Exactly. That's why I mentioned it.
The
See?
good grass.
Pickles. Pickles, she is okay. Do not worry. Our friend Pickles is okay. She's at the urgent care at the moment. She has not been feeling very well. I've been texting her. She's just getting some IV fluids because I think it's maybe a bit of virus or something that's going on. So she is just getting some IV fluids. She's getting there. She's getting some blood work done. Doctors are looking for. I've been in touch with her, so just making sure that she's okay. But she sends her love and hello to everybody, and she can't wait to be here with you guys again.
Oh, we miss
yeah.
her. Oh,
I know, we do. And we send the positive thoughts and good thoughts her way for sure.
Absolutely.
So she can recover quick and join us. It's okay, Hannah. You can clean up the mess as long as you apologize. It's absolutely fine, my friend. No worries. Oh, you. Okay. Also, guilty life without the possibility of parole plus 100 years. You know what? I think I'm gonna go against what you're saying. I think I'm saying not guilty, Hannah, on this one. Absolutely. But time is running out for me. I'm gonna love you and leave you all.
Don't say it like that. That's not time's not running out for you. You have things you need to go do.
You know what I mean.
No.
Okay, time is not running out with me.
Go reach out and touch grass somewhere, girl.
I'm gonna go outside, touch grass. I'm gonna have to enjoy the sun. Apparently, no, I'm joking. I don't like the sun. I am a vampire. Playtime is over. Well, with me, playtime is over. You're gonna be in a very beautiful hands of Zio for, well, hopefully if the weather doesn't crash around her, you're gonna be with Zio. If not, I will rush back and I will stay with you guys because I'm gonna leave my computer on, and in case I can access my computer remotely and I can put the thing up for you if needed. So yeah.
Yeah, what you'll do when you leave, if you'll unmute your audio, and I will mute it on my side, and if I need to, then I'll bring you up on stage, and that way I have your
that's
audio
a
in the
good
background.
that's a good idea.
Because you are right. Do you see that? It's right there.
Yeah,
Just in case.
I'll leave it muted. That's absolutely a great idea. Yep. Okay, so I will see you guys very soon. Later today, I will see you very soon. Bye, everybody. Enjoy.
Bye, Katya.
But
You be
Zio is
safe.
staying. Don't go anywhere. Zio
No,
is
I'm
staying.
here.
Don't go.
I'm not going anywhere. I'm right here. I'm gonna upload this video so we can reach out and touch grass. Everybody ready?
You're always online, chasing the thrill. In the dark corners where nightmares are real. Whispers and shadows, stories unfold. Innocence lost and the secrets they hold. Reach out and touch grass. Leave the screen, step outside. Reach out and touch grass. Feel the earth, feel alive. Sensational headlines.
Can you hear that
the
song?
Dramas you'll muse.
Can you hear the song? It's not creepy, Hannah. I love hearing your voice too. Well, one day I will. Can you hear the song? Okay, good. Okay, we'll keep going.
Capturing moments, the heartbreak you choose. Behind every story, a life to reclaim. Remember the human, not just the name. Reach out and touch grass. Leave the screen, step outside. Reach out and touch grass. Feel the earth, feel alive. lights glow, don't forget to breathe. Disconnect to reconnect, it's okay to leave. Step away, take a break, find some peace of mind. True crime and drama, but balance you'll find. Reach out and touch grass, leave the screen, step outside. Reach out and touch grass, feel the earth, feel alive. Your world's more than stories that keep you up at night. Ground yourself, find the light, everything's alright. Reach out and touch grass, you'll be just fine. Breathe deep, step away, it's your time to shine. Reach out and touch grass, leave the screen, step outside. Reach out and touch grass, feel the earth, feel alive.
Well, there you go. That makes me happy sometimes. There's just things that, yeah, Thor and Blossom. Yeah, I forget that I have a Thor too. My sweet kitty, my sweet Thor. I love playing with that website. You can write anything. That's how I wrote Katya's cute little song for her. Okay, you guys want to watch a few of these parole hearings before they get back from lunch? It's only 12:32, and then 12:45 they'll come back, and then we've got a 30-minute delay. So, Suno, I think it's called. Something like that. I know Nightbot's gonna put me in a corner. Look, you see? Don't be rude to me. Play with this. I tell my husband like him. I had to. I had to approve that comment, Cara. I had to approve that one too, Hannah. You guys are cute. Yeah, in Grand Rapids, Michigan, right now it is 12:33 p.m. I could hear Katya's song in the background. No, we do not listen to Light at all. What has she got going on? It said, drag me to the sandwich stand because freedom tastes like food, is what I heard. That is exactly what I heard in her music. I had not heard that. Let's see what they're doing over here. Let's do a little bit of this till I find something else for us to listen to.
Okay. Mr. Thrasher, is there anybody in the room with you? You're on mute.
No, sir.
Okay, we really don't need anyone. Okay, Mr. Thrasher, please state your name and DOC number for the record.
Tremaine Thrasher, 556383.
Okay, Mr. Thrasher, today is your revocation hearing. Speaking on your behalf will be Mayola Williams, your ex-girlfriend. And what will happen is your case has been assigned to Ms. Stapleton. She will read you the violations. You plead guilty, not guilty, with or without a statement. And then we'll make our decision on your fate today, okay? First off, do you have your parole questionnaire with you?
No, sir.
Okay, can we put one up on the screen for him, please? Okay, you see that questionnaire? Is that your signature at the bottom? Mr. Thrasher?
Yes, sir.
Okay, that's your signature. Okay, so that form says you're not eligible for appointed counsel. So if you wish to have counsel today, you would have to hire them. Do you want to proceed or you want to wait and hire counsel?
Proceed.
Okay. All right, Mr. Thrasher, like I said, Ms. Mayola Williams, are you on, Ms. Williams? Y'all don't have?
You can hear me?
Yes, ma'am, we can hear you. What do you want us to know about Mr. Thrasher?
Sir. Good morning.
Morning. What do you want to tell us about Mr. Thrasher?
Tell us about him.
I told him I was okay with him being released.
Okay.
That's what she wants us to know.
You're the victim in this offense?
Well, years ago, that's why they did it. But I'm fine with him now. That's been like 4 years ago.
Okay. Any particular reason y'all were trying to lie to police about the protective order?
Right, Cara?
Well, I can barely hear you. What you say?
I said there was any particular reason that y'all were trying to lie about the protective order?
Yeah, because I didn't realize that it was still. I thought when he did like 2 years, I thought when he came home it was okay, which I wasn't living there. I had my own place, but I found out then. I think Miss Jerry let me know that it was still on a protective order. It was still going.
Okay. All right. Anybody else have any questions?
Did anybody understand what that meant? I didn't understand what she's saying. She's saying she thought that when he got out that he could come back home and it wouldn't be a problem.
So you're not scared of him at all?
No, sir.
Any other questions? Not really. Okay. Thank you, Ms. Williams, for participating. All right, Ms. Stapleton, you can ask him the questions.
Okay, do y'all read out the rule violations?
Yes, read
Okay.
the rule violation and
All
he
right.
can plead guilty or not guilty, and he can give us a statement.
Okay. Okay, so I'm gonna read the rule violations, Mr. Thrasher. Rule violation number 2. And that records reflect you failed to report to your parole officer on 11/14/2024. Guilty, not guilty? With a statement?
I pleaded guilty at first, but can I change my plea? Because I wasn't sure about Mike being my parole officer. I had a different parole officer, and all of a sudden he jumped on the case and started coming behind me like 4 days in a row. And I told him I was I had medical reasons. I was checking on my health at that time, and he told me he understood, but it seems like it's a problem now. And
So you're saying that
they changed the parole officer at a spur of the moment. I didn't know about it.
You know, it's fine. So he's pleading not guilty?
Not guilty.
not guilty? Okay. All right, didn't know your parole officer. All right, and then the records reflect that you failed to allow your agent to visit you at your residence on 11/13/2024. Guilty, not guilty? Statement.
Not guilty.
Did he ever get to come to your residence?
Yes, ma'am. He came there and searched my home. Everything was okay.
Okay. And the records reflect that you failed to refrain from associations with persons involved in the illegal possession, sale, and distribution of scheduled narcotics, as evidenced by your positive drug screen for THC on 11/18/2024.
I plead guilty on that because I told him that I had smoked prior to the election day. And then he said it was okay, as long as it was THC.
Huh?
Nah, I don't believe that. No,
I
come
don't
on.
either.
That's what he told
I'm
me.
not buying that. Okay, let's move on down to number 4. Another rule violation. 4.
Let's not lie.
Records further reflect you were engaged in criminal activity on 11/18 and 11/19, which led to the arrest by probation and parole and subsequent charge of violation of protective order on 3/26/2025. You pled guilty to this offense. under TAN number 2402606 and received credit for time served. So you pled guilty.
Yes, ma'am.
Okay. Violation of protective order. Okay. All right, number 7. And the records reflect you lied to your parole officer on 11/18/2024 in an attempt to obstruct him from criminal investigation of violation of a protective order.
No.
You know, you didn't lie?
Well, I plead guilty on them because, like, you know, they told them they ain't want me to get in trouble. So, yes, I do guilty.
Guilty, like you did originally. Okay, number 10, and that records reflect you have failed to pay supervision fees since your release on good time parole supervision, resulting in the current arrears balance of $378. Guilty or not guilty?
Guilty. I didn't have a job at that moment.
Oh, okay. Okay, so on the paperwork that I've got that originally, everything that came up, you plead guilty to.
Yes, ma'am.
And the original charge against you was domestic abuse battery and battery on a dating partner. And that's why, and so that did happen, correct?
Yes, ma'am. That's the reason why I'm on parole.
Yeah, and then that's why you got the protective order.
Yes, ma'am.
Okay. And it's against the lady that spoke earlier?
Yes, ma'am.
Okay. And y'all are separate and apart now?
Right now, right? Yes, ma'am.
Okay, you better check about that protective order, how long that thing is in effect, because sometimes it's years, sometimes it's a lifetime. So you better know what the status is on the protective order that the judge put in place.
So you don't think we could get that taken care of, get that off me?
That's
what you need to do. That's what you should have done.
Yeah, y'all got to check into that.
Got to check into it and get it off. Y'all can't be around each other.
Okay.
They can make it permanent. They can make it 10 years, 5 years, however serious the judge at that time felt it was. And then anytime you go, even speaking to her on the phone, because she did say when she spoke to us earlier, I told him. So that means y'all are having conversations on the phone. Is that correct while you're incarcerated?
Yes, ma'am.
Yeah, that's what I thought. Well, that's not staying apart because that includes telephone conversation and even third-party conversation. You can't tell somebody to tell her. That would be violation of your protective order. So you need to get that taken care of, and she needs to find out what she has to do.
No, it's my understanding, and correct me if I'm wrong, it is my understanding that during the time of incarceration, your calls are all recorded. So how is it that this man who has a temporary or a protection order and a violation order in place is able to communicate with this lady while he's in jail? I would say that sounds a little bit like Louisiana might need to look into their policies and procedures.
Can I say something?
Sure.
At court, when I was doing court, before I got to speak to y'all, Judge Foster had granted like the protective orders to be, disposed of, and I don't know if they really still accurate or whatever.
Okay, Judge Foster. Well,
Yeah.
she, I'm sure, is listening to this conversation online. So she needs to get with Judge Foster and find out the status of the protective order so you won't be in violation of it if y'all talk on the phone even.
Okay.
All right, that's all.
I have no question.
Where would you live if you were released?
At the same address, 502 MC Moore Road, apartment B.
Oh, she came to his house.
Yeah, right.
Okay, and do you have a job lined up?
Yes, sir. I'm thinking about still doing the construction, but at that time I didn't have, because all the storms that were going on at that time. So I was out of work at that time.
How long have you been incarcerated?
Going on 6 months.
But were you having any problems with your parole officer? You said you're in line now with the right parole officer.
Right. At that time, I had a new, Miss Amy at that time. And I didn't know he had changed it, whatever they did.
Yeah.
Okay, all right. Good questions.
Okay, is the panel ready to vote?
Yes.
Yes, I am.
Ms. Carolyn?
Mr. Thrasher, I'm going to revoke you because you did plead guilty to several, different crimes, so today, but I would love to see you get into a DBOP program in jail, in the prison where you're at, a domestic violence program, so that when you do get out, you'll have that, training and understanding. That's all.
Mr. Jones?
I'm gonna have to concur with Ms. Carol, and also, do you have a drug problem?
No, sir.
Okay, well, my vote's gonna be to deny, revoke.
And my vote would be to not revoke. And I would have ordered you to make sure you got that protective order straight before you ever talk to her again, but today your vote is two to revoke, one not to revoke, so your parole has been revoked. We'll sign out at Tangible Parish Jail at 9:09.
That is the face of a man who is defeated currently. You know, you have a lot of people that are agreeing with you. Yeah, he's shook. A lot of people that are agreeing with you that tend to do the same thing, that people run away and then sometimes run away and exclude themselves from internet time and then bring themselves back when they're ready. So you're most certainly within your right to do stuff like that. And you should. Let's see. I have one more that I'm going to share, and then we'll go and we'll see what they're talking about with the review of the trial for Christopher Schurr. Oh, this is Katya's song. Okay. All right. We'll listen to this and then we'll go over there. I think everybody's heard this song.
She's a Portuguese soul in the UK, rolling dough at the bakery day by day. Sugar on her apron, flour on her face, but when evening comes, she steps into a darker place. Grab the keys to the car for that Costco run, loading up on snacks before the work's all done. 'Cause once she's home, it's time for the show. True crime on YouTube, spotlight aglow. Late night trials and conspiracies. She's digging for truth for the world to see. Documents on Discord, she's on the hunt. In the hush of midnight, she's on the front. She's got her boyfriend by her side. Together they host this chilling ride. Nightbots watching, chats alive. Everyone's hooked, ready to dive. Her days are sweet and filled with bread. Her nights are dark, deep in her head. From morning dough to midnight files, she dances between the day and trials. Late night trials and conspiracies. She's digging for truth for the world to see. Documents on Discord, she's on the hunt. In the hush of midnight, she's on the front. Portuguese pride in the UK sun. She'll solve every case till the morning comes. Daytime bakery, nighttime sleuth, our true crime addict.
think everybody's heard that song. Paula, you can't figure it out? No. We'll have to work on that. Nightbot says, please make sure you left your DNA on the like button. It helps out the channel. It gets us out into the algorithm. We're going to switch gears and we're going to go back to right, Anna. Nightbot, just chill. I know, William. I think it's an awesome song as well. All right, so we're going to go back over here into the. Once I can figure out what to do here, we're going to go back to the coverage of the trial for the third day of Christopher Schurr. Here we go. They're not quite back from lunch yet. They have a little bit. Case one, I think we're doing okay. How are you doing over there? How are things over there in the world of Karen Reed? Anything good? Anything new? Anything we need to know? We know you have the tea. Let's see what they're saying here.
But if it does, you make sure that that record is as strong as possible so the Court of Appeals has what to look for.
And Tanya, I want to go back to you because you were able
The
to confirm to
circus.
us very quickly that the jury was not in the room when those two motions were filed. But I wanted to ask, does this put anything in perspective for the jurors? Does this make them sway either way, or even have they even heard the filing of the motions? I guess, how does this impact what the jury is now thinking?
A great question. These types of motions are specifically held outside of the presence of the jury because
is this their second day on the stand, right? Watch the broken glass. You got this face when you stumbled in and fell. Don't tell her. Oh, I won't tell her. I will not tell her. Her favorite. Oh, not her face. Yeah, I imagine you would be. This case, they tried to fill in a motion for mistrial. So it was dismissed, and so they're not having that at all. The Reed trial is such circus. I lost all interest in that trial because of the BS happening. Yeah. Yep. Ooh, and then what? Lori Vallow in the circus that is Lori Vallow will be back up. On March or May 14th, somewhere abouts. Listen here. I got to figure out somewhere for me to be. There we go. This guy.
Because jeopardy attaches, versus if it's a mistrial, it would depend on who caused the mistrial. If it's just a general mistrial, then we would start the process over. We would correct whatever was wrong, and we would do it again. Pick a different jury, do a lot of different things. If it's caused by the prosecution, then it can result in what would essentially be a mistrial with prejudice attached, and that would act as if it was a directed verdict because jeopardy would have attached, and then you couldn't be retried for it under the double jeopardy rules. And so there's a distinction. It's possible you could end up with the same outcome. The most likely outcome, had the court granted the mistrial, would just simply have been a new trial, and that's why courts are loath to do it. I mean, it makes sense why Judge Mims would say,
"Who's Spanky?" When Spanky is speaking, you usually leave. Who's Spanky? It's kind of funny, Carl. Looney Lori is going to be saltier than the Dead Sea. At the end of the other trial, she just looked like to me like she gave up. She was just like, this one's in the books. Like, it's done. Can't do nothing about it. Musical chairs. Oh, my goodness. They're making a spectacle. So where is everybody leaning? Do most people think that Karen Reed is innocent, or is that the opposite? Do people think that she's not innocent? Do people think she's guilty? Oh, Hank Brennan. Okay. Yeah, you could tell I have not been following that at all. Spanky, Hank Brennan. I'll remember that.
Trial and a direct ver- okay.
Yeah, in fact, in criminal law in Michigan, there's no such thing as a frivolous motion. You can challenge every aspect of the prosecution's case. Where in civil court, you file a motion that the court's like, there's no way you had a chance of winning. Why are you filing this? You're just making everyone do work. The opposite is true in criminal court. You file as many motions as you want.
Don't tell people that.
Just simply because it's the prosecution's burden and the stakes are so high. So there's no such thing as a frivolous motion. And I'm
Now
not
I
saying that
got
these
it.
two motions were frivolous. I think that they're well-grounded motions. But there's a reason you do it.
And Tanya, I want to ask you, we saw the defense brought these motions on after the prosecution rested their case. On the flip side, is the prosecution also allowed to ask for a mistrial or direct verdict once the defense rests their case? And what is that process like?
Well, certainly a prosecutor can ask for a mistrial. It's very rare, at least in my experience, it's very rare for a prosecutor to ask for a mistrial, but they can. And it would be very similar to what we saw play out in this particular case, but they would be alleging some kind of wrongdoing on the side of the defense, or the defense introducing evidence that somehow prejudiced the jury and how they would listen to and deliberate about the facts that had been presented.
And Sarissa, is it risky to file these motions at this time? When I hear the possibility that if I put together a direct verdict motion and it's approved and it doesn't go my way, to me, that scares me. But obviously, I'm not a lawyer, so break down maybe the risk factors of these motions.
Yeah, there's absolutely no risk to the defendant by filing those motions. I guess the only risk would be, irritating the judge. But every judge, every trial judge expects that at the close of the prosecutor's proof, the defense is going to file a motion for directed verdict. It is just going to happen. It is going to happen pretty much in every single case. And if it doesn't, then the lawyer, unless there's extenuating circumstances, the lawyer's kind of at risk of being found ineffective, like Andrew just said. So there's no risk in that at all. And as for the motions, there's no risk in filing motions. And in fact, if something else came up that the defense thought was problematic, they could file another motion for a mistrial, or they could have filed 4 motions for mistrials if they had different reasons to, upon which that they were based, right? So there's no risk at all. You hope that maybe one will be successful. I don't know that you expect that to happen, but you certainly hope each and every time. But no, there's no harm done to a defendant by filing motions that are.
I personally think this lady has a beautiful lipstick choice. She made a great color choice. Batgirl! Welcome back in. Hannah says hello, Batgirl. Great lipstick choice, yep.
They already had the motion and ready to talk about it. We were thinking that if they did decide to do this direct verdict, that it would take some time. Is that normal
sad.
to see that happen that fast?
That's sad that you can't depend on
In
justice.
fact, the normal is that you don't even file anything. The normal is you just orally make a motion at the close of the prosecution's proofs. Everyone knows it's coming. I mean, there's like Sarissa said, I mean, you do it in every case. So everyone expects it. And most times people don't actually file a formal written motion. You make an oral motion on the record. And the court reporter, takes the motion and the judge listens to it and the prosecution responds. And it's usually fairly quick. And sometimes you're just doing it just to preserve something for appellate reasons and you don't expect to prevail. So it usually doesn't take, in most trials, it takes less than
1 o'clock in Grand Rapids, Michigan, which puts us about probably 15 minutes out from court. Step away for your lunch break, Paula. We will be here with you. Cara, you know me, these cases that, which cases would make my blood boil. So you saying that, I believe you. Enjoy your lunch, Paula, Cara says. Cason agrees with you as well. This one has been not infuriating, but this case in itself with all of the advocacy and the protesting that came along with it, and um, the undertones that were pushed out into the media and stuff like that. I haven't seen a whole lot of that during the trial. So, the fact that they've pulled out all of these, what did I just see? Make sure you Nightbot, go to sleep. The fact that they've put all of this stuff out into the ether that made it a racial undertone in this case, and they haven't brought any of that to court, to me, has been a miracle. We made homemade stuffed ricotta shells with meat, with green pepper and onion sauce. Okay, bad girl, you're chefing it up out there. Actually, I made pulled pork tacos with guacamole and pico de gallo and refried beans, regular beans. Only 3% of the UK police are armed. I did not know that. Nope, I did not know that. Will always be like that when yeah, I agree. I just think that it hasn't been like that in court, and that's been refreshing to see them basically just go for what the facts of the case are and not base that on anything, as far as what the undertone dictated. You use lasagna noodles to do it. Come on over, Cara. Everybody's going to Bad Girls for dinner, and y'all come over here for lunch tomorrow. Said he's very animated. What did she say?
In a particular way that is going to show what we're trying to argue on defense. So that was a really common objection on both sides. What bothers me about
ChatGPT gave you a recipe for chicken and lentils, Indian style. It was pretty shocking that ChatGPT gave you that. In a date. Just like will be with the kid that stabbed the other kid. Yeah, that's here. That's close to me. That's about 5-6 minutes down the road, down in Frisco. Yeah, it all of a sudden did go from a kid pushing his way under the tent of another school and doing what kids do, yelling and squabbling with each other, and then mistakes being made, to now it has an undertone of a racial type that I can't get down with, but that's just my opinion, and that's okay. I added seasoned ricotta to the noodles. You get 16 pieces out of a 13 by 9 dish. I don't think that's enough for Chat and me and you, and Hannah's coming all the way from the UK, so you're gonna have to remake it because it won't be fresh anymore. Yeah, I agree. Garlic bread and a salad. Let's turn this stream off. We're heading to a bit of Bad Girl's house. There's the girl with the good lipstick.
Was trying to get the evidence in the way that it was doing it. And Tanya, I understand what you're saying. It's not so different.
William's coming too.
Marking an exhibit. I mean, that happens all of the time. People draw on maps or they mark a place on where a car was, something like that. That happens all of the time. And what's interesting is that this is kind of a modern day way of doing that, but it is slow. And so I thought it was a strategic decision. And I could be completely wrong on this, but this is what my take on it was, that the defense was making a strategic decision for some reason to try to get the evidence to the jury in the way that it was trying, through the experts sitting on the stand, creating the exhibits as they went forward in open court. And the strategic decision is, why did they decide to do it that way versus having these exhibits prepared in advance, just like the judge now has told them to do, and they're going to go and they're going to do it? Why didn't they do that initially? right? What was the decision making in trying to proceed in the manner in which they did? So that's what I found as striking. Again, maybe I'm wrong, but maybe that they were, but maybe there was a different reason for it. But that's how I took it. And they're going to go back and they're going to make the exhibits, and it's going to be perfectly fine. They're going to come in. And they're going to show the stuff to the jury. The judge didn't say you can't do it. The judge just said you can't do it in the manner in which you are trying to do it. It's taking too much time, right? And so they were prepared for that. The defense had, I'm 1,000% confident that the defense was prepared that the judge might rule that they couldn't proceed in the manner in which they wanted to, and so therefore they had a contingency plan in place. But I don't know that we'll ever know the answer to why did it start this way. But I thought it was really interesting.
Well, Sarissa, I have to ask, when people do that, whether it's marking or clipping clips, screenshots in real time in front of the jury, does that make the jury kind of think about what's happening more? I mean, if you show someone a picture, they'll have a thought right away. But if they're stopping, doing this process in front of them, does that make the jury or give the jury idea of saying, oh, I didn't see that before. Oh, maybe I should think about this. Like, how does that impact the jury?
So the jury, the amazing, terrible, wonderful, horrible thing about trial work is that you never know what's in the mind of jurors at any given point, right? So some jurors might have the same question that I did. Why did they try to proceed in that manner rather than a different manner? Some jurors might say, why are you wasting my time? Some jurors might say, oh, I like the way that he was doing it. I'm sorry that we can't proceed. We have no idea what the jury or each individual juror is thinking. And to the extent that they were, worried that, oh my God, this is taking forever, great for those jurors, to move this along quickly. But then if you have the ones who are like, oh, I really liked the way that this was going, this made a lot of sense, then that kind of stinks because.
Yeah, it sounds like you have the TCAs of the jury, and then you have the HEOs of the jury, the ones that like the technical side of stuff, and then you have the other ones that are like, this is boring, let's move on. So it's hard to know what the jury's going to think and what they think about the situation until we actually get into it. And you bring Katya and the British food, and okay, that'll be awesome. We're going to have a potluck true crime style. I like that idea. I like that a lot.
And the fact that suddenly he's concerned that this is taking too much time, I don't know why the defense was proceeding in that fashion. I have to believe it's strategic, but it's routine for somebody to create an exhibit in trial just using the testimony. We do.
Look, Katya cannot stay away. She's still here listening when she's supposed to be on a date with her husband. Should I time her out, chat? Put a 1 in chat if we should time Katya out of her own chat so she goes on a date with her husband.
The fact that he objected as it's quote unquote cumulative, it's like we're all going to see these videos 1,000 times by the time it's done. And the fact that the defense has an expert that can break it down into a way that's easier for everybody to understand and to get to the nuances, it sounded to me like, hey, we don't want the best evidence. We want people to not see this, and because it's bad for us. And it sounded like,
yep, time out.
I don't know. I mean, if the job is to get to the truth, then why wouldn't we want to break it down and see it in a way that we can understand? Like when Chris Schurr's on the street with Patrick, it's like things are happening fast, and thank God we've got this technology now where we can go back and look at stuff and see what happened. Like, where were the prongs to the taser? I mean, because the experts made certain arguments. Well, let's see if we can apply the facts to what they're saying. And so I've have found that expert to be very helpful in just understanding. And I like how he puts all the videos together and explains the reference points. And so when I heard the objection, I just kind of chuckled to myself. It's like, yeah, okay, you don't like it, so you got to find a way to object. So they'll fix it, and we'll get to see it again. So,
and I have sorry, I have one last question for you all, and that's just your reaction to the whole entire case presented. They have rested their case. I know that we won't really know who did the best or be able to compare everything until essentially the verdict. But now that we've seen the prosecution's whole entire case, what is your now reaction to what they have presented? And going forward with now the defense? I'll start with you, Andrew.
Well, first of all, the big question is whether or not the prosecution proved to the jury beyond a reasonable doubt
Right.
that it was not justified. And the problem in self-defense cases is it's a double negative. And so
I love your face too.
like when a juror's thinking about it, it's like, well, was he justified or not? And from Chris Schurr's perspective, man, it's an argument to be made that they never proved beyond a reasonable doubt. If I can now put on evidence to show in my favor that in fact we can prove that it was justified, well, that helps the jury reach that conclusion, because you're not required to claim that you can prove that you are justified. The prosecution is required to prove beyond a reasonable doubt that you were not justified. And so I think now what they're going to do is they're going to really attack that in the defense. And so I'm looking forward to seeing how they do that going forward.
And Tanya, I also want to hear from you about your reaction to the prosecution resting their case, what they presented, and now what you look forward to with the defense.
Yeah, similar to Andy, I think in this particular case, there's no argument that Christopher Schurr caused Mr. Lyoya's death. That's not the issue here. And what his state of mind was as far as, was this an intent to kill or cause great bodily harm? But I'm looking forward to how the defense now presents, even though they don't have the burden of proof, with respect to presenting the case of self-defense. The self-defense jury instructions in Michigan are very favorable to a defendant raising the defense, right? And they say that we have to look at what the defendant's subjective state of mind was, and then we look to see if it was objectively reasonable. And so it's not surprising to me that the prosecution spent a lot of its case trying to establish that his response, Mr. Schurr's response, was not a reasonable or proportionate response, and trying to knock down this idea that he was reasonable in his calculation that he needed to act in self-defense. So I'm really looking forward to how the defense presents that other side of self-defense, what Mr. Schurr was thinking, why he thought he was at risk of imminent death or great bodily harm, and how the defense expert witnesses, I anticipate they're going to bring in experts, will help establish that.
And Sarissa, I also want to get your thoughts on what the prosecution has presented and what you're looking forward to as defense begins their case.
Well, I think the prosecution did what they intended to do, in that they tried to present enough evidence to a jury for the jury to find that Mr. Schurr didn't act in self-defense. They tried to take it piece by piece, and only the jury, will determine if that's the case. What's interesting and going to be interesting at this point for me is to kind of go back to what we talked about yesterday.
I can't be bothered with you guys fighting in chat. I'm looking at this lady's lipstick. Establish
Mr. Schurr's fear of what was taking place without Mr. Schurr testifying. That's, again, another strategic, interesting point just from a defense lawyer's perspective when you're watching a case like this, and you just, it's always at risk to put your defendant on the stand. We talked about that yesterday, but in a self-defense case, most times you really need to. So are they going to be able to get what they need without Mr. Schurr testifying, or will he have to be put on the stand? So that's really what I'm looking forward to seeing as this progresses.
And I know I said that was my last question, but as you know, we are on a 30-minute delay, and my producer just told me something very interesting that just happened. I'm
breaking
hoping to get
news.
yours all, initial opinions for what I'm about to say. Essentially, the defense wants to include evidence that would speak to Lyoya's intentions and character. The judge has said that is not relevant to the case. This is the second time that the defense has tried to add in things about Lyoya's character. Is that normal? Is it strategic for when they're doing it now that they have their own case to present? I just want to know your initial reactions to just hearing that little blurb of that. I'll start with you, Sarissa.
So the defense is going to do everything possible to try to get in character evidence about Mr. Lyoya. I mean, that's what you want to do, but rules of evidence kind of preclude that from happening unless you have certain things that come up that allow you to do it. And so in the same way that we were talking about motions earlier, that you try everything that
Yeah,
you
you gotta
possibly
throw that
can
spaghetti against the
to
wall.
try to represent your client in the
Yeah,
best
they
way
do it all the time.
possible. And so now they're trying this, and again, they're trying it now. And if they get denied, it's possible that something might change in the future, and they might try it again. There's no harm done in trying. What the judge decides,
It's
the
their
judge
job.
decides. But if they have an open door, they're going to take it, because that is evidence that would be helpful for the defense if it was able to be presented to the jury.
Tanya, I want to hear your take on this latest opportunity, I guess, that the defense is trying to bring in more evidence of Lyoya's intentions and character.
Yeah, picking up where Sarissa left off, of course, the defense is going to try everything they can. That's their job, to zealously represent their client. And remember, when the defense is self-defense, the reputation of the victim's reputation for aggressiveness is admissible. But in Michigan, we've seen the courts rule that the defendant has to be aware of it, right? Because if the defendant's not aware of it, how does it affect the defendant's state of mind in thinking he or she has to act in self-defense? So just like it was ruled on earlier, if something comes up where it becomes evident that Mr. Schurr might have been aware of some of Mr. Lyoya's prior record, then it all becomes fair game again. And I would expect the defense to continue trying to get to that evidence.
Yeah, and the reason, so the defense is arguing self-defense. They want to introduce evidence of the victim's character to suggest he had a history of either violence or aggression, alcoholism. So if they claim that and they can support the reasonableness of Christopher Schurr's actions, then they're set. So we'll see if it gets in.
And they try to do it. Well, what they're communicating to the jury at that point in time is, hey, there's stuff here you're not allowed to look at. Wouldn't you be really curious to know what it is? And jurors will oftentimes grab onto that stuff. And so that's like one of those things a trial attorney will do strategically and broach the issue in front of the jury, just to plant the seed in the jury's mind that, hey, the court and the prosecutor is keeping stuff from you, that we've got the secret thing that you'd love to know about, but you can't because they're stopping you. And so that's a little trick that trial attorneys will use. And so that's why I asked that question, if it's in front of the jury or not.
Well, we just got word in my ear that the jury was not in the courtroom when that was said. So I guess what's your reaction to that?
Well, then they're trying everything they can. And I go back to Tanya's point about, hey, if the guy has a violent past and it's known to Officer Schurr, then that changes the analysis. And so, like, for example, let's just say that when he pulled up, he didn't know who he was. That's the whole thing. Like, but we don't know whose plate was on that vehicle. So all he said was it's a wrong plate. So I don't know if Patrick's name was attached to the plate or if another person's name was attached to the plate. But it's possible that his name was attached to the plate, and then if he knew that he suspected that that's the person that he's dealing with, and that person has, a violent criminal history, it would likely show up on lien. Here's the other possibility.
Well, Sissy, the plate didn't match the car. So if the plate that he ran matched the guy that was in the car and he knew, okay, he might have known the reputation. But if he didn't know who it was, he doesn't know particularly who that guy is. Irregardless, we don't know. We don't know what type of history the guy had. They're just trying to say basically on what happened at that moment is that this man is no longer living, and was what this officer did excessive use of force or not, regardless of what the guy's past was. The fact is, in that moment, he did not comply. He grabbed a taser. He was inebriated. Okay, looks like we're going back into the courtroom here.
Take a listen.
Reasons that we feel may show intent on the part of Mr. Lyoya to use the weapon on Officer Schurr. So far, it's been the prosecution arguing what his intentions were, what was apparent to a witness, based on a cell cam video where it's pretty clear, maybe recording when the the user wants it, it gets put down, oh, he hit you too, gets put back up at a certain time, so everybody's basing their opinions on what Mr. Lyoya's intentions may have been from the cell cam video. But we feel we should be able to argue what his intentions may have been based on the fact that if he were placed into arrest there, he's either wanted on several things or was certainly in violation of the law from several courts on probation.
Okay, I'm just gonna stop you because I don't like wanna place a bunch of things about Mr. Lyoya on the record. If the court's already determined that they're not admissible or relevant. And so just addressing the renewed motion under 404 and 405. 405, I don't believe is applicable because that has to do with reputation or opinion in Part A of that rule. Part B of the rule says that when a person's character or character trait is an essential element of a charge or defense, then it could be proven by relevant specific instances of the person's conduct. That's not what you're requesting, so that particular rule does not apply. As far as 404, I believe that perhaps maybe 404(2)(b) could apply because in that rule it states that in a homicide case, when self-defense is an issue, the defendant may offer evidence of the alleged victim's trait for aggression. However, in the motion that you listed, the only point out of you listed 9 separate issues, the only one that could potentially have to do with aggression is the first one, and then that is the arrest warrant that you mentioned before, which is not evidence. There's nothing proven, it's a warrant. So, like I said, and compared it to your client, it's as if saying your client has a particular trait for aggression because he's had a warrant for the second-degree murder charge, and that wouldn't be appropriate either. And so I also believe that any attempted explanation, even those that have already been put forth by different witnesses, any attempted explanation of what was going on in Mr. Lyoya's mind, it would be pure speculation on the part of any person. It's impossible to know what was in his head. It's also not relevant what was in his head. What is clear, what is in evidence, is that he was clearly fighting with the officer. Why he was fighting, I don't know that that's relevant. He clearly is fighting. He's clearly drunk. That is evidence that has been placed on the record. He clearly didn't have a driver's license to present to the officer when he stopped him. He clearly didn't obey several commands. It doesn't matter why he didn't. It doesn't matter why, just like it doesn't matter why he was drunk. He was drunk. Those are the facts. You can clearly argue that he was intending and he was trying to do this. You can argue that just the same as the people can argue that he wasn't trying to. So because his character is not an essential element, this particular, again, trait for aggression, the only one that we're doing is the arrest warrant that was pending, and there's no evidence that Mr. Lyoya was even aware of that warrant. So,
Your Honor, but there were, just to note, there are several other warrants for some of them for years.
none of them have to do with aggression.
There's prior convictions for domestic violence. So if the prosecution opened the door, he's a really good guy. At least usually when it's my client, if I call a witness and they say that, the prosecutor's following right up with
Because that's
prior
a defendant,
conviction.
and you're treating Mr. Lyoya as if he's a defendant, and he isn't. Your client is a defendant.
So the door can't be opened on other parties involved.
Not from what I've heard so far, for sure.
So the prosecutor can argue that what they feel his intentions were. His intentions, opening statement, his intentions weren't to use the taser.
His intentions were definitely to fight the officer. His intentions were definitely not to comply with his commands. I'm not sure to say, did he intend to use the taser? I don't know how you get that from what you're trying to report.
Well, that's what they said. They said his intentions weren't to use the taser.
Okay, so.
But so, and
I'm just saying it's fair argument that maybe they weren't, but maybe they were. No one knows, because that's what it was in his head at the time. So to say, well, he's got this warrant, so he must have meant to use it, that it doesn't jive.
Well, a car full of unlawful contraband that would
Well,
show
again-
multiple felonies, I'm just,
Again-
those are legitimate reasons why you would not.
Right,
follow
but
the
say
standard.
none of that existed, but he's still, everything that we know is already there. Why does it matter if he had all these prior things versus the fact that he's clearly, at least 3 times the legal limit drinking and driving? For example, he's clearly fighting with the officer. So why he's fighting with the officer, if it was no reason, it wouldn't change anything.
Right.
It wouldn't change the fact that he's not complying.
Your Honor, you made a ruling prior to trial, state of mind, and then now we've had several occasions where the prosecution argues what his intentions were, what Mr. Lyoya's intentions were.
I didn't hear them argue several times. I think during opening, he may have made a comment, but.
And the witnesses that they've elicited testimony from about what Mr. Lyoya's intentions were. So I don't mean to test the court's patience. I made a record as far as why we get the doors.
And I don't believe that testimony was necessarily elicited. I do recall witnesses testifying to things, including on the video, that, as you mentioned, I don't know if you mentioned it, Mr. Schurr, who mentioned it just a few moments ago, but stating how the cell phone video, the friend taking the cell phone video, saying he doesn't have a taser, or I don't see a taser. Oh yeah, yes I do. So it's, I mean, the jurors will see what they see. They know, they have the evidence that has been presented by the people. And I just still am maintaining my previous ruling for all the reasons that I stated, that these 2 rules do not allow or make that those particular allegations or the things listed doesn't make them relevant or admissible. I'll say admissible. So they're not admissible. And then we can have the jurors come in. If there's nothing else. Is there anything else for defense before the jurors come in?
No, Your Honor.
Mr. Beckman?
Thank you, Your Honor.
Okay, so we'll have them come in. And then I'll have you call your witness.
And Your Honor, just for the record, the parties have stipulated to exhibit L4 and defense exhibit DE. for this witness.
Is it L4?
L4 and EE.
And is that Mr. Becker?
This is true, Your Honor.
And L4 and EE are not admitted.
Thank you.
Welcome back. You may be seated. And the defense will call your first witness, or your next witness.
Your Honor, the defense would like to call Sergeant Timothy Johnston to the stand.
And sir, before you take your seat, if you please raise your right hand, my clerk will swear you in.
Do you solemnly swear that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You may be seated.
Thank you.
Whenever you're ready.
Good afternoon.
Good afternoon.
Could you please state and spell your full name for the record?
My name is Timothy Johnston, Timothy Johnston.
What is your current occupation?
I'm currently retired.
Have you had were you previously employed at GRPD?
Yes,
And that's the Grand Rapids Police Department?
that's correct.
And since you left the Grand Rapids Police Department, have you had a haircut since then?
No, I have not.
And while you were employed there, what was your position?
I started out as a patrol officer on night shift and worked for 28 years on the street as a patrol function, and the last several years as a supervisor on patrol.
And can you briefly describe what your duties and responsibilities were around the time of April 4th of 2022?
Yeah, that was a day I actually came in on overtime. They were short-staffed and were asking for volunteers to come in and work. And I was assigned to the East Service area as a supervisor.
Can you describe what the East Service area is?
It's one of the geographic areas that Grand Rapids is divided up into teams cover. So the East Service area is generally from Cottage Grove, which is just south of Hall Street, and it runs all the way south to 44th Street out by Kalamazoo. And the east-west boundaries are from Clyde Park all the way out past the East Belt Line to East Paris.
And I think you had mentioned that at that time you were working overtime because they were short-staffed.
Yeah, the week prior at the shift that I work, announcement was made that they needed volunteers to come in and work that day.
How many people were usually assigned to the East Service area?
That service area is usually assigned 7 to 8 officers and then 1 supervisor.
And how many officers were assigned on April 4th of 2022?
I believe at the time of this incident, I think there was either 3 or 4 officers and then myself.
And as part of your duties as a supervisor, can you explain a little more what your duties were?
So I would respond to major incidents. I wouldn't go to some of the, I guess, standard type of calls that come out, but anything involving like felonies and that sort of thing. And then to supervise those scenes as well as review officers' reports.
Okay, and that day were you in the field?
Yes.
Okay. And in your experience as a Grand Rapids police officer, were you ever involved in tense, rapidly evolving hand-to-hand use of force situations?
Yeah, I worked the entire 28 years on patrol. So, I mean, if I averaged only 4 a year, it'd put me well over 100, I think.
So I want to go back to April 4th, Monday, April 4th of 2022. You mentioned that you were working that day. What time did your shift start?
My shift started at 6:30 a.m.
And before this incident occurred, which was, I guess, between 8 and 8:15, where were you?
I was at the parking lot of the Croc Center at Division in Alger.
Approximately how far away is that from where the incident occurred?
It's 8 city blocks for a mile. I guess it's probably about 3 miles, maybe 2-3 miles.
How long did it take you, I guess, from the time that you heard Officer Schurr calling out the traffic stop, how long approximately would it take you to get there to?
Between 2 and 3 minutes, I believe.
And do you recall hearing Officer Schurr call in a traffic stop?
Yes.
And when you hear someone call out a traffic stop, what is the common practice at GRPD?
If you're available, you would slide by or start heading that way until we know that everything's safe and that there's I guess every traffic stop's an unknown risk traffic stop.
And can you explain what you mean by unknown risk?
Sure. I was a field training officer for 24 years. And so we teach high-risk stops and unknown risk stops. An unknown risk stop, any stop is a potential threat. You don't know who's in the vehicle, even if it's for speeding or what may seem just to be a traffic violation. We still have tactics that we employ to keep ourselves safe until the conclusion of the stop.
And so that you typically will have at least one person respond, even if help isn't explicitly requested?
Yes.
And when you were on your way to respond, once you heard Officer Schurr call out the traffic stop, what did you do?
I was on a phone call from another officer. Also was the supervisor of our mounted unit team, and I was on a phone call with another officer that had a scheduling issue with that. And so I was at the point, I think, that Officer Schurr called out that he had somebody running. I ended that and responded code 1.
And can you explain to the jury what code 1 is?
That'll be activating all the emergency equipment on the vehicle, like sirens, exceeding the speed limit.
And you had mentioned you heard him say the second, or just say, "I've got one running." Is that
Yes.
correct? Okay. And did you hear Officer Schurr call out another command or request on the radio?
I did hear him ask to send more cars.
What did you interpret that to mean?
I could hear in the radio transmission sounds of like a struggle, heavy breathing, the I guess tone or inflection in his voice.
Can you describe what that tone was like?
Labored and I guess an excited, elevated tone, desperation.
And at that point, what did you do?
One response. I think that was, I don't know if I was halfway there yet or something like that. Just continued as fast as I could to get there.
And do you know approximately how long after you heard Officer Schurr call out the initial traffic stop that you arrived on scene?
I think it was, again, somewhere between 2 or 3 minutes.
And that would have been potentially from when he called out the request from that he had one running?
Yes.
Okay. And did you hear him give any other requests over the radio?
I just heard I was probably maybe 3 blocks from the scene or his location that he was at when I heard him get on the radio again, stating that he'd been in an officer-involved shooting.
And when you heard that, what was your initial response?
I was still had to make a couple more turns to pull up on scene, and I came around the corner and could see his cruiser and the suspect vehicle ahead of me. Another officer, Mott, and his partner, Officer Grace, arrived pretty much simultaneously with me at that point.
And what did you know when you arrived on scene?
Really, only what had been transmitted over the air, that there had been a foot pursuit, the sounds of some kind of struggle, and then Officer Schurr saying that he had been an officer-involved shooting. At that point, I didn't know who was a suspect, how many suspects, what their locations were, what kind of weapons were involved. There's more unknowns than knowns.
And what did that indicate to you?
For me, as a supervisor, even line officer arriving first on scene, our priority is to secure the scene and make sure there are no more threats to officers or the public in any way, and then render aid.
And when you arrived on scene, once you got out of your car, what did you observe?
Again, I think either Officer Grace or Officer Mott kind of ran up at the same time that I did. As I approached, I could see Officer Schurr off the side of the curb to my right as I was running up towards him. Looked like he was next to a tree or behind a tree. I still didn't know how many suspects there were. And Officer Schurr was either leaning on the tree or kind of hunched over, breathing hard and just pointing.
And what did that indicate to you?
That's where I should focus my attention.
And what did you observe about, or I guess, have you worked with Officer Schurr before April 4th of 2022?
Only on a couple of occasions because we worked opposite rotations. So I did have one incident with Officer Schurr a couple months before that. We worked a sexual assault case together that we received awards for.
And when you saw Officer Schurr that day, what did you notice about him when you arrived?
Complete exhaustion. He was bent, like I said, he was sort of bent, hunched over. You hear him breathing. Even in his radio traffic as I was approaching, you can hear this breaths, gasping for air.
Okay. And what did that indicate to you?
That he'd reached his physical limit. It reminded me of at the end of a Olympic sprint race or something. You see the athletes afterwards with their hands on their knees, breathing hard.
And once you saw Officer Schurr, what did you do next?
He was on his feet at least, and I knew another officers that were closer to him would assist him. So I guess I turned my attention still to trying to secure the scene. I could see another occupant outside the vehicle, and I could see Mr. Lyoya on the grass off to the right.
And at that time, did you know who either of the parties were? Either Mr.
No.
Lyoya or the passenger of the
No.
vehicle? Okay. And were you wearing a body-worn camera at the time that you responded?
Yes. Yeah.
And was your body camera on when you responded?
Yeah, it was automatically activates when you activate the emergency equipment in the vehicle. As soon as you turn on your lights or your siren, your body cam is activated, as well as the in-car dash camera.
Okay. And have you reviewed the body-worn camera footage related to this incident on
Yes.
April 4th?
Yes.
Okay. Your Honor, I would ask to publish Defendant's Exhibit EE, which has already been stipulated to, which is the body cam footage of Sergeant Johnston. Could you turn the lights down too, please? Thank you.
On your head. Turn around, face the car. Walk back towards us. Keep your hands on your head. Keep to the right. Keep to the right. Go to the right. The right. Now come back this way. Keep walking back. Keep coming back to me, partner. Keep coming back to me. 10 more steps.
Pause it. Sorry, thank you. And for the record, this is at the 22-second mark of Defendant's Exhibit EE. Sergeant Johnson, I noticed that you have your firearm drawn. Can you explain why?
Again, with an officer-involved shooting that's just occurred, again, I do not know what kind of weapons may be involved, who is in possession of them, who all may be in the vehicle. So it's just for protect myself if someone was to draw a weapon. The same reason we order them hands on their head. We don't want them reaching around the waistband or pockets where weapons may be. So we'll keep the hands in view the whole time.
Okay. And why were you ordering him to walk backwards towards you?
We would bring him back in this position, puts us at a tactical advantage, and then we can secure that person and pat them down for a weapon, make sure they're unarmed before we proceed with securing the rest of the scene. I can't let that person just be wandering around or get behind me and potentially attack me. Because again, I don't know where these threats might come from. A lot of unknowns.
Bob, can you play these?
10 more steps. 10 more steps. Keep going. Okay, down to your knees right there. Keep your hands up. Keep your hands on your head. Down on your knees. Put your hands lying back, palm facing the air, bend over your waist. Do not look back.
Pause it again, please. So we're at 49 seconds of Exhibit EE. I noticed you were what seemed like kind of yelling at the individual who was getting out of the car. Why is that?
If you notice at the beginning of the video, I started giving him commands to move right, but he moved left several times. And so I'm just projecting my voice so he can hear me. And I guess to emphatically give those commands to gain compliance or obedience from them. So as quickly as I can, because I'm still, my ultimate goal still is to clear that car and then render first aid. So I need to get obedience quickly, make the scene safe as quick as I can in order to administer first aid.
And why did you order the passenger of the vehicle to be detained at this point?
Again, I still don't know what his involvement was in this incident, and I don't know if he has a gun in his sweatshirt or in his waistband or anything.
Okay. Bob, can you play, please?
Here, I'm gonna move. I need wireless coverage on the vehicle here. Is there anybody else in that vehicle?
No one else in the vehicle.
Okay, next car up. Anybody else in the car, make yourself known now! Yep, we're gonna clear the car first.
At this point, I'm waiting for more officers. That's why there's a pause here. There's no backup yet. I'm just waiting for another officer because we go up in either a 2 or 3 man team to clear a vehicle, but nobody's available.
Okay. And why do you, I mean, when available, why do you typically want 2 or 3 people to clear a vehicle?
So you can cover multiple sides of the car as well. There's also, I guess, sometimes concerns even with surroundings too. So whenever there's high risk incident, there's people, some are focused on the car, one side of the car, the other side, and other people covering, you know, and again, I don't know how many people have fled from this car. I don't know if there's other potential suspects hiding between these houses or anything.
Okay. And that was stopped at 1 minute and 26 seconds. Bob, can you play, please?
Javon, Nick, you guys with him, you go clear the car from driver's side. We're gonna keep rubbing on him. Yeah. Who's gonna read? You need. All right, you two go up and clear that car. I'll help with you.
16, we're gonna get back to the northwest. 10-4, you're not being a headache.
And this is 1 minute and 51 seconds. I notice everyone has their firearms drawn at this point. Why?
Again, this is standard police training that this is an unknown threat in this vehicle. For me, at the beginning of my career, Officer Scott Flahive from Grand Haven was killed going up on a car like this because somebody was hiding in the back seat and shot through the door at him. And we always will stop even behind that called the C pillar, that block between the rear window and the back seat, and you sort of use that as a shield for yourself to even look in that back seat, make sure there's not somebody crouched down in there before you move forward and look in and move forward up to the driver's side or the driver door.
Okay, you can play.
Heading to the north off of Oroville. 1918, looks like you're coming. 1918, I'm on
Can you see anything in there? Nope.
Between 17, 26, and 17, 15.
Okay, it's right front.
You have those correct information.
They are from that side. I don't know.
And when you approached the car from behind, Bob, can you back up just a little bit? Sorry, I don't know the time mark, but if you could go back to as they were approaching the car from behind. A little further. Yeah. Or a little further back, sorry. All right, from here, I guess, go forward a little bit. Yeah, play it from here. Okay, if you stop it from here. I guess as you were approaching the car, could you tell how many people were inside or if anyone was
No, I
inside?
think it was a combination of, it was like rain and sleet, so it was cold on the outside of the car, and I don't know if it was from breathing occupants inside or it was like the back window particularly was very obscured, like fogged up. And then with the reflection with the wet glass and rain, it was very difficult to see in there. At one point, I think if you go for, I think I even put the light on the end of my gun, like right up to the window to try to get at least the back seat floorboards and that to light up. Because I couldn't really tell through the back window.
Okay. And once you were done clearing, or I guess what happened next after you cleared the car?
At that point, we sort of rallied back, I think, near the cruiser and go around and then form a team to move up to where Mr. Lyoya is laying in the grass there. And again, I still don't know, we have a fear of this person could be playing possum, so to speak, or, if there's still a potential threat, even as we approach to render aid, if there's any kind of weapon present.
And when did you first become aware that there was Mr. Lyoya had possession of a taser?
At the point that I approach him, I think if you show the video further, we approach, and at first I see like a black angular object slightly. He's face down and sort of under where his left hip would be. I initially thought that was like the back corner of like a Glock handgun or something, but as I got closer, I could tell that it was Officer Schurr's body camera that apparently fallen off, and it was under, like halfway under Mr. Lyoya. And then I ended up grabbing Mr. Lyoya by his right arm to roll him towards me. And as I did that, I could see the yellow taser under the right side where I pulled his arm out from.
Your Honor, permission to approach? And I am, and I am showing him what's been previously marked as Defendant's Exhibit L4, which the parties have stipulated to. Sergeant Johnson, do you recognize this?
There appears to be a still picture of Officer Schurr's taser in the mud next to what I believe is Mr. Lyoya's hand.
And you had just described that when you found the taser, it was under Mr. Lyoya's body.
Yes.
Was this photo taken, I guess to your knowledge, was this photo taken after you had already rolled him over?
Yeah, when we originally came up to him, it was over top of it, so we didn't even see it until we rolled him over onto his back.
Okay. All right. One moment. All right, thank you. I have no further questions.
Briefly, Honor. Good afternoon.
Good afternoon, sir.
I was asking if you're on vice, because usually vice officers kind of look like that, and you just retired.
Just retired, yes, sir.
Just want to go back to some of your statements that you made. The first thing you said is, you taught this when you were with Grand Rapids Police Department. You did some of the training for officers on traffic stops, correct?
Yes. Yeah.
And one of the things you said was every traffic stop is an unknown risk.
That's correct.
You don't know what's in that car.
Yes, sir.
You don't know who's in that car. You have to
Yes.
answer out loud. I can see
Yes,
you.
sir.
And quite frankly, there's a lot of times with guns in cars in Grand Rapids. That when you were working, that was an issue.
Yes.
It was not uncommon to find a gun on a person in the car
No, not uncommon.
and between the seats in the car,
It's very common.
under the seat of a car,
Even more common.
even more common. So, guns and going back to some of your training, I've got some training records here. When you talk about training, did you train the recruits or are you training officers?
They go through what was labeled an in-house training through our training unit. And then once they're put out on the street, they enter the field training program, and they have officers that they're with a 4-week through different phases. And I was one of those field training officers.
But in terms of even the training, I think a lot of the training, when you train those people, they talk about even when you start is the danger of weapons in a car. Is that a fair statement?
Yes.
That you have scenarios where you may have one person with a gun in the car or two people with a gun in the car, correct?
Yes, sir.
And you when you're doing an unknown traffic stop, that's part of the unknown traffic stop is you're approaching. You basically approach every car that it could have a weapon in it. Is that a fair statement?
Yes.
All right. And one of the things you said, and it kind of backs up your. Did you have an opportunity to review your report?
Yes.
Okay, and I highlighted some of the things in your report, and you kind of testified to this. My goal is to make the scene safe as quickly as possible so we can safely move forward or render aid. So you definitely want to render aid to Patrick. Correct?
Yes, sir.
But without being attacked or shot by the subject standing outside the car. So you were worried about that.
Yeah, again, I don't know.
You have no idea.
Unknowns. Yeah.
And even at that point in time, though, you at least had 4 officers because you said you responded 2 pulled up at the same time.
A 2-man unit that was Officer Grace and Officer Mott. And
Officer, the defendant.
And then Officer Schurr was.
And then yourself.
Yes.
So there's 4 officers, but you were still concerned, even with 4 officers at the scene, that you didn't know who was in the car.
Correct.
You didn't know who. Ame is his name. If the passenger was armed.
Yeah, we still have 2 suspects.
Sure.
Mr. Lyoya, that's on the ground. So, and then Officer Schurr is obviously out of commission because he's so exhausted. I wouldn't even consider him a usable asset at that point.
But there's at least 3 of you.
Yes.
So you clearly outnumber the passenger.
Yes.
But there still could be somebody in the car because you don't know.
Correct, sir.
And that's one of the things you said. And one of the problems was even in your report, the rain and reflections on the car windows obscured my ability to see clearly inside the suspect vehicle.
Yes.
So that was an issue because it's a complete unknown in there. There could have been somebody else hiding.
Yes, sir.
And that's why you kind of go through all that we saw on your body cam.
Yes.
All right. Thank you. I have nothing further.
And Sergeant Johnson, I just have one question for you. You were asked about the passenger, but you weren't worried about the threat with him anymore because he immediately complied with your commands, right?
Once he's been secured, detained, and patted down, yeah, he's secured off to the side. But somebody's got to be keep custody of him. So that takes another officer out of, my available assets there, and I have to wait for more to respond to fill those positions.
And at that time, there were how many officers were on scene?
I don't even know because a lot of the activity was behind me. I could hear some sirens getting closer. At some point, I think Officer LaHeis and then Officer Sanders arrived. And those are the 2 that went up with me to clear the car.
And when you chase individuals, is it also common for them to be armed with weapons?
Yes, I've tackled several people that had guns on them.
Thank you. I have no further questions.
Just one follow-up. I just want to make sure you're clear. She said in her question, that one question was you weren't concerned about the person standing outside the car. But your statement, you said, in your report, the subject in the front yard without being attacked or shot by the subject standing outside the car. So when you initially showed up, there's a person standing outside the car, right?
I don't understand what the discrepancy.
That was her question. I just want to make sure.
Well, I think the point was that at what point was he no longer a threat, and that's why I explained not until he's secured. He's a threat until he's secured and patted down.
So that's what I'm saying. When you pull up and he's standing outside the car,
He's a potential threat, yeah.
No further questions, yeah.
Well, so you guys raised on jury, may this witness be excused? Ms. Hamilton?
Yes, Your Honor.
Any objection?
No objection, Your Honor.
Thank you very much, yes.
Thank you, Your Honor.
Your Honor, the defense calls Sam Mott.
Good afternoon. And sir, before you take your seat, if you could please raise your right hand, my clerk will swear you in.
Do you solemnly swear that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You may be seated.
Thank you, Your Honor. Good afternoon, Officer Mott.
Good afternoon.
Where do you work?
Grand Rapids Police Department.
How long have you worked there?
Approximately 4 years.
Okay, and what's your title and describe your job duties?
I'm a patrol officer on our day shift.
Okay. And were you on duty April 4th, 2022?
Yes, sir.
Okay. Did you receive a call to respond to a scene involving a shooting by a police officer, Christopher Schurr?
Yes, sir.
Okay. When you received that call, were you in your car?
Yes, sir.
All right. Was anybody with you at that time?
Yes, sir. I was doubled up with a partner.
What does that mean?
It was 2 officers in 1 car.
Do you recall who was with you?
Yes, sir.
Who was that?
Officer Jordan Grace.
Okay. Did you respond to the scene?
Yes, sir.
Okay. I'd like you to tell us what you saw as you arrived in your car.
As I pulled up to the scene, Sergeant Tim Johnston was pulling up as well. We saw Chris standing a couple of houses down in the block to our north. He was standing in the middle of the street, and we couldn't see anything else other than another vehicle with an individual standing on the passenger side of that vehicle.
Okay. And you want to refer to Chris, you're talking about Officer Schurr?
Yes, sir.
Had you ever met Officer Schurr before?
Yes, sir.
Okay. Are you guys friends? How do you describe your relationship with him?
We played basketball a couple of times when we weren't at work.
Okay, so kind of just somebody you might hang out with playing basketball, but no deeper relationship than that?
Correct.
All right. Now, you say you played basketball with him. Have you ever seen him exert himself playing basketball?
Yes, sir.
Could you describe his level of physical fitness?
He had excellent cardio. He was one of the few guys that would continue to run the entire time we were playing.
Was he in better shape than you or worse shape?
Yes, sir.
Okay. All right. Okay. So as you approach the scene, did you get out of your cruiser?
Yes, sir.
And did you have an opportunity to engage with Officer Schurr?
I did.
Can you please describe what you saw as far as Officer Schurr's physical condition when you engaged with him?
As I approached Officer Schurr, he was standing on the rear passenger side of a vehicle that was parked along the curb. Officer Schurr appeared to be out of breath, and he was having trouble making any comments towards us. And he looked absolutely exhausted. He was kind of looking down towards the ground. At that point, I told Officer Schurr to go take a breather.
Okay. Did you follow up with him at a later time?
No, sir.
Okay. You also mentioned that there was another individual at the scene that you were concerned about and other officers were engaging with. It was the passenger of that car?
Yes, sir.
All right. Did you have a chance to interact with that passenger?
Yes, sir.
Okay. Please tell us what you observed when you talked to the passenger of the car.
I took possession of the passenger, placed him in cuffs. As I was walking him back to the car, he appeared very intoxicated. He smelled of alcohol and continuously asked me if his friend was okay.
Okay. And you placed him in the back of a patrol car?
Yes, sir.
Did you obtain his phone for evidence?
Yes, sir.
And you preserved it for such?
Yes, sir. I placed it in airplane mode.
And nothing further. No questions?
I don't see any hands raised on the jury. May this witness be excused, Mr. Cordova?
You may, Your Honor.
Your objection.
No objection, Your Honor.
Thank you very much. Your excuse.
Thank you, Your Honor.
Defense may call your next witness.
Defense would call Nicholas Kalani.
Good afternoon.
Good afternoon.
And sir, before you take your seat, please raise your right hand and my clerk will swear you in.
Do you solemnly swear that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you. You may be seated.
Thank you, Your Honor. Good afternoon, sir.
Good afternoon.
Sir, could you please state your name and spell it for the record?
Nicholas Kalati, spelled Calati.
How are you employed, sir?
Grand Rapids Police Department.
And how long have you been employed with GRPD?
27 years.
Okay. And, sir, were you on duty back on April 4 of 2022?
Yes, sir.
And assume you know the incident we're referring to on April 4, 2022.
I am.
And if you could just tell me what were your duties that day prior to this incident?
That day I was working as the patrol supervisor for the south end of the city.
Okay. And what do you recall as far as how you became involved in this situation here with Officer Schurr?
That early morning, Officer Schurr called out a traffic stop. Shortly thereafter, he called out for pursuit, and that drew our attention and started going his way.
Okay. Where do you recall where you were when you first heard the initial call out?
Yeah, I was right around Franklin or MLK and Ionia, or 131 right there.
Okay. And if you could just explain as far as what you do after those calls are coming out.
When those calls come out, we activate our lights and sirens because it's an emergency response. And then as I'm going as a supervisor, I help coordinate a response from the other officers or any other needs that we have, be it medical or anything like that.
Okay. And did you ultimately go to the scene here?
I did.
And what do you recall observing when you arrived?
When I arrived, I was not the first one there. There were a couple other officers that had arrived first. As I was approaching, we had coordinated what we needed, protected. We then see who we still had to make contact with, surroundings, like anything that could be dangerous for our officers, had to keep an eye on that and coordinate a rescue effort.
And was it your understanding when you arrived that it was a situation where a subject had disarmed a police officer of their weapon?
Correct.
And is that a fairly rare situation for
It
GRPD?
is.
So was it treated very seriously as far as very
It was.
carefully?
Yes.
Okay. Now, did you have the opportunity to view Christopher Schurr here?
Yes, I made contact with him as soon as I got on scene.
Had you known him before this?
Yes.
And if you can, explain what was his condition when you made contact with him?
When I made contact with him, you tell he was like worn out, tired. His face was pale, still breathing kind of heavily. I would say kind of like a slouched posture instead of having all the strength type of thing. Like if you were to sit up straight, as opposed to having a bunch of energy and after you have expelled all your energy.
Okay. How long did you end up staying on scene, roughly? Do you recall? Quite a while?
Yeah, for the duration of the day, pretty much.
Okay. That's all I have. Thank you, sir.
No questions?
We'll see one hand raised based on the jury. So have my clerk help me grab that question. It's not really a question for the witness. So, if you want to approach him. May this witness be excused, Mr. Hodge?
Yes, please.
Any objection?
No objection, Your Honor.
Thank you very much, Officer. And defense, you may call your next witness.
Your Honor, we'll be calling Captain David Cyber to the stand. And, sorry, Your Honor, before we do that, can you take a 5-minute break? I'm sorry.
So 5 minutes is not long enough. We're gonna take a restroom break because there's 14 people, if not 14 restrooms.
Sorry, maybe 15-minute break, is that okay?
It's a little early for a break, but I guess we can, anyone know? Haven't been in here an hour yet.
I know, I'm sorry.
Okay. We'll just do a brief, we'll do a 5-minute break, then we'll just take another longer break later, since it's only been an hour, so hopefully that's enough. And we will take another restroom break. So we'll come back in 5. Meanwhile.
Okay, so it looks like we're on a 5-minute break. They haven't even been back an hour yet, so the judge is like, what the heck's going on? Five-minute break it is. We're crawling through the witnesses pretty quickly this afternoon, I think. What do you guys think? Do you think we're going to get the other side to rest today? Chat. Wake up, chat. Where's my chatters? Verdict watch tomorrow? Yeah, I agree. I think so too. You don't be working while I'm asking you questions, Paula. You can't be doing that. You're fine, hon. Yeah, I think they might rest today. I think they might rest today. Verdict watch tomorrow, I think. And Paula's working during all of this. Having to do all the things. You are getting paid to work. Ugh, no, I can't afford to pay you to chat, so I guess I ought to leave you be. I'm just so glad that you're here, actually. That's the truth. That's the truth. Trying to decide if I want to hear the Touch Grass song while we're waiting for break. Yeah, why not? Why not? Let's touch grass while we're waiting.
You're always online, chasing the thrill, in the dark corners where nightmares are real. Whispers and shadows, stories unfold, innocence lost and the secrets they hold. Reach out and touch grass, leave the screen, step outside. Reach out and touch grass. Feel the earth, feel alive. Sensational headlines, the dramas you'll muse, capturing moments, the heartbreak you choose. Behind every story, a life to reclaim. Remember the human, not just the name. Reach out and touch grass. Leave the screen, step outside. Reach out and touch grass. Feel the earth, feel alive. Spotlights glow, don't forget to breathe. Disconnect to reconnect, it's okay to leave. Step away, take a break, find some peace of mind. True crime and drama, but balance you'll find. Reach out and touch grass. Leave the screen, step outside. Reach out and touch grass. Feel the earth, feel alive. More than stories that keep you up at night. Ground yourself, find the light, everything's alright. Reach out and touch grass, you'll be just fine. Breathe deep, step away, it's your time to shine. Reach out and touch grass, leave the screen, step outside. Reach out and touch grass.
I'm going to be singing that all night long now. Reach out and touch grass. We don't specify. Just touch any kind of grass, okay? Doesn't matter which grass you touch. Just touch it. Uh-oh. There's a wild rubber in the back chat. Reach out and smoke grass, Williams. It's legal here. It's not legal here where I'm at. It's not legal here. If it was, I think more people would probably do it. Me personally, I'm not able to. I don't enjoy it, but that doesn't mean everybody else doesn't. You're on paperwork night to night, and you've been off for a while sick, and you have enough nurses on shift. Oh, well, you should have just stayed home then. Missouri, the show me state. What are you showing? Your grass? Showing your grass? Oh. See what rubber season though. Just showing our grass. And I bet it is the most prettiest grass ever. Oh, here we are. Looks like we're getting back into court. David Silver. Not legal in Texas. Nope. All right, here I go. I'm going to mute. Hi, Sheila. Welcome up.
Thank you, Dove. I'm here. I appreciate you. We appreciate you. We have to be quiet. Mute. Shh.
Good afternoon.
Good afternoon.
Can you please state and spell your name for the record?
Yes, David Siver, DAVID-SIVER.
And what is your current occupation?
I'm a police captain with Grand Rapids Police Department.
And how long have you been a captain at the Grand Rapids Police Department?
I've been a captain for approximately 3 years, a little over 3 years. I've been a police officer now for almost 26 years.
Okay. And can you talk briefly about some of the different positions you've held at Grand Rapids Police Department?
Yes, when I hired on started out as a patrolman, was assigned to second shift patrol, also midnight patrol shift, and then in 2004 I was selected for the special response team, our department's full-time tactical team. Spent 11 years in that team, and then was promoted to sergeant in 2015. Worked nights and day shift patrol as a sergeant for a couple of years, then went back to the SWAT team in 2017 as a sergeant. Promoted to lieutenant in 2019, was the midnight, one of the midnight shifts shift commander. And then in February of 2022, was selected to take over the training unit until a couple years back. We had a little reorganization that became a captain's position, where now I oversee the training and engagement division, which houses the training unit and the community engagement unit, kind of our hiring, recruiting arm, and our training arm.
And how long have you been involved with the training unit generally?
As the commander for 3 years, a little over 3 years now, but I've been involved in training since roughly 2002, when I was selected as a defensive tactics or subject control instructor. And then 2004, emergency vehicle operations instructor through the state police. 2006 or 2007, I became a firearms instructor, Krav Maga instructor.
What is that? Sorry.
I'm sorry. Krav Maga is another form of defensive tactics, a system, if you will. And then 2013, I became a field training officer as well.
Okay.
And I'm sorry, and then also a taser instructor since 2005 or 6 as well. And a master taser instructor a couple years back that just lapsed.
Okay. Have you received any, in addition to this, have you received any specialized training in law enforcement, defensive tactics, or other use of force?
Yes. The certification courses are usually a week or two long. And then I also have attended the Force Science certification course. That's a week-long course. The executive management program through Northwestern's Policing Institute also.
Okay. And but prior to working with the Grand Rapids Police Department, did you work for any other agencies?
Yes, I started my career in the city of Saginaw back last century, 1999. I got laid off. That's how I ended up here.
Okay. And when you came to Grand Rapids, what are some of, I guess, why did you come to Grand Rapids?
One, for the opportunity, right? It's a much larger agency than city of Saginaw, a lot more growth and opportunity, job satisfaction, those kind of things. So.
Okay. And have you taught or trained officers in the use of force and defensive tactics?
I have, since roughly 2002 in those various areas. We have regular mandatory training where it's in-service training, if you will. So those blocks of instruction rotate through the year, and I've assisted in those since 2002, 4, 5, 6, in that range. Also, during my tenure on the SWAT team, we trained pretty much every week, and I assisted instruction or teaching in those areas. I also assisted teaching at Grand Valley State Police Academy in the areas of subject control, use of force, other topics since 2004 to roughly 2015. And then I also taught a couple sessions at Kalamazoo Valley Community College, 2005, 2006, in those areas as well.
Okay, and you mentioned subject control. Were there any other topics that you have taught?
Yes, obviously firearms. Kind of I refer to it more of a critical skills area, so that component of communication, driving, use of firearms, subject control, kind of just a broad spectrum of the job, if you will.
And in addition to the certifications you spoke of, the force science and the Northwestern policing, have you completed any other advanced courses or certifications in regards to the use of force?
Just the Master Taser program.
And who is the, can you explain what the Master Taser program is?
I'm sorry. Yes. I think you've heard from the Axon rep. Axon is a parent company that manufactures our body cameras, our tasers, a bunch of different devices and equipment. So the Master program is an intensive week-long program where they take you through the history of the taser weapon systems, from the invention of them, every model that's still currently manufactured. While some agencies, currently we have the Taser 10, some agencies still have the Taser 7s, some have the X26s. So they take you through the history, the nomenclature, and you're required to understand how to operate, diagnose, train, and all of those areas, along with some skill building exercises. And then you have a bunch of written and practical exams at the end. And the concept is you're a master instructor, you can then anywhere in the country go teach a taser class for an agency and then certify instructors for that respective agency.
And are you familiar with Grand Rapids Police Department's policies on the use of force and practices and procedures?
I am, yes.
How did you become familiar with those?
Through being part of the training cadre. Historically, our agency has always had instructor development sessions or instructor days. So we discussed trends and policies and that. And then as I promoted up, it became more of a command level. That's historically how the chief's office and work groups get policy changes through by several different entities reviewing them within the agency.
And have you reviewed the specific sections of the policies that were in effect at the time of the incident involving Officer Schurr? Which
Yes.
is April 4th of 2022?
Yes.
And Your Honor, this is marked as Defendant's Exhibit G, I believe. Oh, sorry. Defendant's Exhibit E is the Grand Rapids Police Department policies.
So E is all the policies. No objection, Your Honor.
To the commissioner.
Apparently it's E 1 through 10 is what I'm understanding.
Can you move for initial of at this time?
Yes, Your Honor. And these are the Grand Rapids Police Department policies, and it's E1 through E10. It includes the use of force, firearms.
All right, so I'll admit 1 through 10 into evidence at this time.
Thank you, Your Honor. And I guess while we're doing this, we also have Defendant's Exhibit F, which is the mandatory training. And it's Defendant's Exhibit F 1 through 18.
No objection.
To F1 through 13.
18.
18. And you said no objection to their initial.
Correct.
All right, then they are admitted at this time, F1 through 18.
Thank you, Your Honor. And Captain Cyber, how many times have you testified in court regarding GRPD matters?
Over the course of my career, I would estimate probably in the about 100 range, maybe.
And in those cases, who are you usually testifying for?
Many times for the city attorney's office here in GR, and then the county prosecutor's office as well.
And at this point, have you had the opportunity to review the video footage from Officer Schurr's body camera and dash camera and the passenger cell phone video from the incident on April 4th?
Yes.
How many times would you say you viewed those videos?
Prior to this week, through the trial, probably 12 to 15 times.
And do you feel familiar enough with the content of these videos to answer questions related to the training and policy topics involved in this incident?
Yes.
And have you reviewed the facts of this case?
I have.
And did you form any opinions regarding the use of force by Officer Schurr?
I have.
So he can't give opinion testimony because he's not an expert.
I was going to move to qualify him as an expert at this time.
Do that before he introduces his opinion.
Yeah, I was not going to ask him before the opinion. I just had asked if he had formed one. But at this point, we would move to have Captain Cyber recognized as an expert in the Grand Rapids Police Department training policies and procedures.
Any objection?
Just simply for Grand Rapids Police Department training and policies, that's fine, Your Honor.
So he will be considered an expert in Grand Rapids Police Department training policies and procedures. Is that what you said?
Yes.
So he shall be considered an expert in that.
Thank you, Your Honor. And Captain Cyber, can you tell us a little bit about your role at GRPD regarding policy review and analysis?
Yes. So like I explained a minute ago, as I promoted, especially since I took the lieutenant role in charge of the training unit and now my current captain position, yearly, roughly, we do policy reviews to keep up with national changes or court decisions that would affect our policies and procedures. We continually try to update our training materials, I guess, outlines every session, things like that.
And are you familiar with the GRPD's policies on the use of force?
Yes.
And Your Honor, I do have, I would ask for permission to publish a demonstrative that has Exhibit E, which is the GRPD policies on that.
Publish, I'm sorry.
Defendant's Exhibit E, but I put sections of them just for purposes of trying to go through them.
The ones that I just admitted?
Yes.
Yes, you may publish that.
Okay. All right. Okay, so can you tell us a little bit, I kind of want to walk you through and have you help explain to the jury what Grand Rapids Police Department policy is on the use of force. So I'm going to kind of have you talk to us about that a little more. So I am showing you what is part of E, Exhibit E1. Can you explain a little bit, can you explain what GRPD relies on for their use of force policy and what that is?
Yes. The Supreme Court case, Graham versus Connor, is the basis, the framework for our policy. As you can see, the language in there, reasonable bound of force, reasonable threat of death or serious bodily injury, number 3, the fleeing felon, that's Tennessee versus Gardner case. But yeah, that's the framework for our use of force policy.
And how do you usually, I guess when you're talking about the Graham versus Connor, can you explain to the jury what you mean by that?
Yes. So the term objective reasonableness, which you can see that's highlighted there, some of the factors or things to take into account, the phrase totality of the circumstances, meaning the factors of that incident, that time, then there. So you can see A through G, the immediate threat to safety of others, officers, and B and C, resisting arrest or attempting to evade arrest by flight. D, the term again, a reasonable officer on the scene. So these are all factors kind of combined together as you work your way through the reasonableness of the force.
I'm sorry, this is a separate page.
Oh, sorry, Your Honor. This is policy 9-1.2. which is defendant's exhibit. It's still part of E1. It's just the second.
It's like number 6 on this page.
Yes.
And then the other one was different.
Yeah, for the record, the first slide we discussed was the use of force, 9-1.1, which is exhibit E1, section 1, 2, and 3. All right, and now we are talking about exhibit E1, 9-1.2, section 6. So you had talked a little bit about the objectively reasonable officer standard. How does this standard guide officers in how to make decisions in high stress situations?
Well, mainly that kind of boils down to a similar trained officer in a similar circumstance or similar situation. Would they perform the same way or in a similar way? That's kind of the easiest way to boil that down. And the big factor is hindsight 2020 can't be used in evaluating that use of force, right? The comfort of your desk or your office or your couch as you're watching that video. That's not the goal. That's not the objective there. You can't have the hindsight 2020. You got to be able to articulate or look into it in that time and place.
And when you say that, does that mean you have to, can you explain more what that means? Like, who are you supposed to be, what perspective are you supposed to be evaluating it from?
From the officer on the scene or a similarly trained officer, right? Put yourself in that officer's position. I can kind of use a sports analogy, right? When we're yelling at the TV on a football game or a basketball with the Pistons last night, put yourself in that position. That 3-point shot's not so easy, right? So the circumstances of that right there, not you removed and you're in the safety of wherever. You've got to put yourself in that position. So exhaustion, you're tired, you don't know all these factors, the totality of the circumstances. It's an extensive list of things. You've got to be able to recreate that and put yourself in that situation or a similar trained officer as you're judging or evaluating that use of force.
And is that part of what you do in your current position is evaluate?
It is. I'm responsible for use force analysis and reviews. And we average between 500 to 600 use forces a year in the last, for pretty much my entire career. So yeah, I'm tasked with that. I'm part of the use force review board.
And you mentioned the totality of the circumstances, and you started mentioning some of them. And I would direct your attention to exhibit E1, section 9-1.4 to 9-1.5, and this is section D. And you started talking about some of these topics. Can you talk a little bit more and explain what you are or officers are trained to consider under the totality of the circumstances?
Yes. So that phrase, totality of circumstances, it's the tangible facts or the tangible things in that instance. So an easy one is size, right? Is the officer much smaller than the subject they're trying to arrest or fighting with? Exhaustion is on there. That has a huge bearing on use of force incidents, weather, distance from the subject, the type of crime. And then the last one, and this isn't a complete list, obviously there's other factors that are going to play, but reaction time is a huge one because it's pretty well understood that action is usually faster than reaction. So again, sports analogy. A pitcher gets a pitch signal. He knows exactly where he's going to do it. He's going to be able to do it with relative control. The batter's got to react to that. If it was easy, a batter would have 1,000% batting average. So same thing as an officer. They've got to pick up clues or cues ahead of time to try to give them some kind of a fair playing field.
And when you're talking about reaction time, is that something that's also trained to the officers?
It is.
And what are they trained about that?
Just to understand the concept that action is faster than reaction. So officers, for the vast majority of their daily activities, are behind the power curve, if you will. They have to react to other actions. Very rarely do officers take initial actions ahead of time. And I also point out number 5 there. A vast majority of our use of forces, subjects or suspects are under alcohol or drug influence. That's a vast majority of our incidents.
And is that just like something that you train officers to look for?
Yeah, to recognize that some uses of force are not effective. For example, pepper spray, people that are intoxicated historically don't have, they aren't affected the way that a person that wasn't intoxicated might be by pepper spray. Or they're very resistant to pain because of the delayed response to the intoxication or the drug induction.
And you mentioned like not viewing this from hindsight. How do you avoid doing a hindsight analysis when evaluating the use of force?
Personally, I will watch the video or videos start to finish, and then review the incident reports to try to gather some more information, and then I'll try to break down the video frame by frame, or I don't have forensic video equipment, but break it down through the software that I have available by piece by piece.
And as I guess when you're considering things from hindsight, are these some of the factors that you have to consider from the perspective of the officer
They
involved?
play a major role, yes.
And are officers trained with regard to the reaction time? Are they trained that they might have to make split-second decisions in tense, uncertain, and rapidly evolving situations?
Yes, that's reinforced through training.
And how do you train officers to anticipate that?
The best way we try is through reality-based scenarios where we put them at a disadvantage and force split-second decisions to try to reinforce decision-making skills and try to give them some framework to understand, reasonable decisions or reactions off that.
And now you mentioned some of the reality-based scenarios. Can you tell us a little bit more about what those are?
Yes. So as men and women hire into the Grand Rapids Police Department, they do an 8-week in-house orientation, we refer to it as, where we start with very basic skills and then progressively make them more difficult, the scenarios. For example, we'll at some point in that 8 weeks, we do a drill, kind of an exhaustion drill, if you will, where they're in a kind of sensory deprived, it's pretty simple design, but it's more or less a shower curtain that kind of comes over top of them that's enclosed. And then they react immediately to something, and it's usually a violent assault. And the goal there is to get them exhausted, to have that understanding what that feels like, a 30 second to 1 minute scenario, because we found that if we go past that 1 minute, the injury rate gets pretty high. So that's one example. We also voluntarily expose the new recruits to a taser effect, a taser, either a drive stun or NMI, as you've heard, the probe, and then pepper spray. We also make them drive on a racetrack. So we try to expose them to everything we possibly can that they'll see out in the street or out in a real operational sense. And then once they get done that 8 weeks, they do 16 weeks of field training with somebody sitting next to them that evaluates everything they do, every call they go on, every stop they make, and it gets progressively harder. And the expectation is they have to do the whole 100% of the work by the end of that field training program. Then when they're done with that, we have between 8 to 10 mandatory training cycles a year that vary in topic to try to maintain skill sets and build skill sets.
And why do you have the new recruits go through all of these scenario-based trainings?
Just to give them a perspective of what, one, that time compressed decision making, that stress of having to make decisions in a split second. And then, like I said, to try to expose them to as much as we possibly can before they're subjected to it in a real life scenario. So the effects of pepper spray, what it feels like to be tased, what it feels like to be exhausted. We even have foot pursuit scenarios that we do with them. So they understand what that feels like or what that looks like. We really focus on communication skills. And it's a whole list of things from A to Z.
Okay. And you mentioned that you ask people to be voluntarily tased and pepper sprayed. Why do you do that?
The biggest factor is so they understand the effects of it. One, for taser, for example, what that does to another human being, that if you're tasing them, to understand that, to avoid excessive taser deployments or taser rides, if you will. Also for their own benefit, to know if they were incapacitated or the pain associated with the drive stun. Also, pepper spray affects people differently. Some people have very little effect. Some people are completely kind of incapacitated by the effects of it. So just so they have that before they get out on the street in a real life operational sense. They've never been exposed to it.
And I'd like to pull up what I think has previously been published as the people's, actually, I'll just do ours. So I will, would like to move to admit defendant's exhibit. And Your Honor, I would have permission to publish defendant's exhibit J and K, which are the videos of Officer Schurr being tased.
Okay.
And Bob, can you pull up exhibit K, please? Or sorry, J. Sorry, can you pull up exhibit K? Okay. Sue, do you mind dimming the lights, please?
I'm sorry.
Could you dim the lights, please? Okay, this is defendant's exhibit K. Can you play this for us, Bob? Nope. And is this the voluntary tasing that you had talked about?
Yes, it's consistent with what we do. And if you notice, the retired captain now that actually tased Officer Schurr, he's well within that 4-foot range. And we do this to demonstrate various effects of the taser, where we'll get a quote unquote proper spread of the probes to somebody. And then the next person, we might do a close probe deployment to show that, it's super painful, but there's varying effects to it. Or we might drive stun somebody, or we might do a third point of contact to create that lockup or that NMI. So that is consistent with what we do, yes.
And based on the close range that Officer Schurr was tased, how close do you think this would be?
It looks like he's probably within about 2 feet of where he sends the probes.
And based on that, how far would you anticipate that the probe spread would be?
That's a previous model. That's an X2 model that when Officer Schurr was hired, we were still carrying. So the previous model, the T7, but in that range, it's probably about I would guess about a 6 to 7 inch spread from there.
Okay, and as part of the voluntary tasing, why? I mean, I guess you've explained why, but do you notice that with different people, their reactions are different depending on their size and body mass, distance?
Yes, and you can see we have to take precautions to because if say Officer Schurr standing up, those two officers would be spotting him under his arms because of that concern of a fall hazard. So we vary the positions just to demonstrate effectiveness, or as you could see in that video, Officer Schurr is able to crawl a little bit, but he's obviously in intense pain. And without his arms being held, I don't know if he would have been able to move his arms or not. We get varying responses, like you said, by body size, ability. People react differently to being tased. That's for sure.
And have you Have you ever been tased?
I have.
And what was that experience like for you?
Miserable. I will say miserable. I've been tased. Part of it was the instructor program. I think 3 times. I have not been tased by the Taser 10, thankfully. But yeah, it's. I've had different reactions each time. That's the unique part about being tased. Is one time you may lock up and not say anything. You may scream, blood curdling screams. You may flail your arms with that quote unquote lock up, the NMI. I've also been drive stunned 4 times. And that's, yeah, very intense pain. And I relate it to like being hit with a blowtorch. That's what it feels like your skin's melting.
Well, I think you're a brave person for doing it that many times.
That's also why I'm not the master taser instructor anymore.
And yeah, so we could do a demonstration, but we can't. So, so when you're teaching officers what it feels like to get tased, are there any other things that you train them to think about when they're about to use a taser, or when they're about to use the taser?
Yes, and that's why we do a ton of reality-based scenarios. We have specific taser-based scenario drills we do because things are dynamic, right? They're fluid. They're not like that mat room or the taser video where everything's static and I'm going to stand here, you're going to pull your taser, and I'm not going to move. So we try to demonstrate that through various different exercises to show, even though it might be a close probe spread, you could fire your other cartridge and get a lockup, or you could create that third point of contact by drive stun or touching that taser to the individual. So there's varying methods we try to reinforce that there's a whole spectrum of issues with the taser at times. So to try to work through that.
And I would like permission to publish defendant's Exhibit K. J.
So it's J.
Yes, sorry. Defendant's Exhibit J. And you mentioned the close probe deployment. Is this what you were discussing?
Exactly, yes. So Officer Schurr there is in very close proximity to it's just a leather wrestling dummy we use. So you can use live cartridges. And that's the limitation of training with the tasers because of some of the dangers with them. We can recreate some of it, but I can't have role players getting hit with live tasers. That's a problem. So we use dummies and things like that don't move. But he deploys that taser from probably 6 inches away and then finds that third point of contact. The other option we've trained in is you fire the first set of probes, you get a close probe spread, then you move and you could fire your second set of probes to make the connection, the electrical connection.
And is there any, even though in some instances, if you're closer than 4 feet or the optimal distance, is there any prohibition on doing that?
No, that's really why we do these drills, just to give them some repetitions and a conditioned response, if you will, that in a dynamic fluid situation, that optimum distance isn't always possible.
And you also mentioned that.
I'm sorry to interrupt, but for that last exhibit, was that the same taser model or was that the prior model?
That's the prior one, Your Honor.
Thank you.
And that was the X2 model?
X2, yeah. The functionality is the same. It's just different cartridges and design of the device a little bit.
And does your training on the close probe deployment or the distance you need to be from the person, has that changed at all now that you've switched to the Taser 7? Or I guess at the time you were using
the Taser 7?
Mm-hmm.
No, that did not change anything.
And you also mentioned that sometimes you have people voluntarily try pepper spray? Or
yes, we
themselves?
I won't say mandate, however, strongly encourage people, unless they're prior law enforcement from somewhere else on lateral end. But again, for the same concept of to experience what that feels like, the your eye ducts kind of shutting down and watering, and just the physiological responses you have to that. And if somebody's never been pepper sprayed, they don't know what their response is going to be. Like I said, some people completely shut down and can't really fight through it. Other people, it doesn't affect them at all. So that's kind of the first step, because in the course of your duties, pepper spray has some residual effects on us too when we use it in the field.
And are you aware if Officer Schurr has been pepper sprayed?
He was, yes.
And Your Honor, I would have permission to publish the People's Exhibit 12, which I think is the graduation video. It's the People's Exhibit 12.
You want me to play it? I'm switching my computer.
Yeah, if you don't mind.
Play the whole thing?
Yeah, you can play it, and then I might tell you to stop it. Okay, thank you.
Oops, sorry. Get the sound going.
I'm killing the sound on that. Y'all know we'll get hit. Not doing it. Nice training video, but no thank you.
Can you pause it?
Okay.
Yeah. And for the record, this is defense or the People's Exhibit 12 at the 53-second mark. And you, Captain Stiver, you notice? Can you explain? Do you know why
Yes.
Officer Schurr looks like his eyes?
Yes.
Are
So
squinting?
typically when we expose our newer officers to pepper spray, we're out at our outdoor range. Then it prevents our instructors from getting the feedback as well. So we'll spray one side of their face, have them close one eye, and spray one side they elect to uncover. And then we give them a little bit of physical training type, some jumping jacks, push-ups to get their breathing up, because some guys will hold their breath, or some folks will hold their breath, try to game it. And then we make them perform some simple strikes, kicks, punches, those kind of things on the training dummies, just to demonstrate to fight through the effects. And like I said, some of our folks really can't. Some people, like you see, Officer Schurr is doing his best to get through that, and he's got some involuntary closure of his other eye. So he's experiencing full value, it appears.
And when you, I guess, expose them, depending on their reaction, are officers required to use OC spray if they have a bad reaction to it?
In the field, you mean? Or
Yes.
No, they're not required.
And you also mentioned that you had been drive stunned in the past. Have you also been pepper sprayed?
Yes.
Would you say that the drive stun is the equivalent of pepper spray?
I would not.
Why not?
The drive stun's, you've heard the concepts of pain compliance with some of these techniques, the kicks and punches and some of these techniques. The goal is to inflict some kind of a pain to gain compliance. And I relate the drive stun is the most intense pain compliance option, device, tool that I've ever felt. So pepper spray is nowhere near. It's uncomfortable and it takes longer to decontaminate and it has some longer effects, but the drive stun is much worse.
And have you ever trained officers to spray pepper spray, or how do you train them to use the pepper spray when they're using it on someone else?
When we set up scenarios specifically where we want to try to elicit a pepper spray response, typically it's at where somebody's not obeying verbal commands. They're seated. You have some distance because, like I said, you'll get some residual splashback, if you will. You'll get some pepper spray back at you. So if I'm in close proximity to somebody, I pepper spray them, I'm going to get the full effect as whatever that person's getting and anybody else around. So It's really designed in its best application to be a distance type tool.
Do you ever train officers to spray it towards themselves?
No,
Why not?
because they'll most likely be suffer the effects of it.
And what would be the harm? I guess what is the risk?
I mean, you could see in that training video, the graduation video from Officer's class, he took one side of the spray. He's got one eye closed, and he's still suffering effects in both eyes. So, without being able to shield one of my eyes, excuse me, there's a chance I can get at both my eyes and then have double the effect of it. The other issue is the design of the device. Can I show mine? I guess for the jury. Not spray it, but just to show you the canisters that we carry and have carried for years has a thumb device in it. So it would be very awkward and odd to try to get my thumb in and point it back at me, right? So we instruct to use your thumb to spray it, not your finger. So that would be the other preclusion of pointing it back at me.
Okay. And where is the pepper spray located on your duty belt?
In front of whatever dominant side you have, if whatever hand you write with. I'm a right-handed person, so I have it on my right hand in front of my gun.
And is that where, do you know if that's, or do all officers carry their pepper spray there?
The vast majority do.
Okay.
Whatever their strong or dominant side is.
Okay. And are there any issues with trying to use the pepper spray if you're at the optimal distance? Is it effective on everyone?
No. I think I mentioned earlier, historically, people that are intoxicated or under the influence of narcotics, a lot of mental health type crisis, people that are affected by that, it has very little effect or no effect. There's also some outside the kind of norm folks that just don't have any effect to it, whether they're stone sober or not.
And in your experience, does it typically work to on certain people who may be intoxicated?
With limited success in my operational use, I guess.
Okay. Mr. Becker, if you wouldn't mind playing Russ, I don't remember.
Nope, not playing the music. We can watch the video, but I can't play the music. Okay, thank you all for your family, friends, and support. Shh, quit playing the music. Okay.
And then if you could switch it back to Mr. McFarland's computer. And when you were talking about the drive stunt, you had mentioned you had been drive stunned multiple times.
Yes.
And have you ever trained officers, or would you equate the drive stun potentially to the eye as equivalent of a thumb?
No.
Why not?
I guess I would say a thumb, you'd have to know kind of how to inflict that damage to the eyeball, where that electricity coming off the end of the model of taser. Again, like I said, I relate it from my experience of being drive stunned 4 times like a blowtorch. So I don't personally want to have it anywhere near my eyeball. I would think that's going to cause a lot more damage, but I'm not a doctor. So.
And without getting too much, what do you train, or how do you train officers to use the taser?
To use the taser? Mm-hmm. Like in the video, for example, that drill that officer does during his recruit class, close probe deployment, where you fire the taser, activate it, pull the trigger from any distance, and then you know that you've got a short probe spread, so you follow up with that third point of contact, or fire the other set of probes into the person at some point, because then that would give you the distance you need between the probes. We've never taught to remove your cartridges to affect a drive stun. That's just not in our training philosophy or program at all. So we've always been from a probe deployment type The only thing we talk about is the older models, especially, they had what they refer to as blast doors on the front of the taser device. So the probes are not super long. So sometimes those probes would get impaled in the blast doors, and then it wouldn't give you any impact to the person. So we've always taught to keep at least like try to get a 6-inch distance before you pull that trigger to send the probes, and then follow up with somewhere else, either more probes or drive stun.
And are there any locations that you train officers to avoid when using a taser?
Yes, early on in the taser days, I think actually I had hair back then. They weren't, the dart to heart concept wasn't around, but then after several litigation cases, they changed that so that they've asked us to avoid that center mass kind of chest area. And it's always been preferred that back or legs, large muscle group areas. And we've always instructed that to avoid the neck, face, genital areas, chest area as of late, obviously, but just because of the danger of probes going to those sensitive areas.
And do you also train them not to target those areas with the drive stun?
Yes.
And regarding how you train, kind of going back now to some of the use of force training and some of the policies, what standards in Michigan govern how police officers use force?
Obviously, we talked about the U.S. Supreme Court case, Graham versus Connor, but then obviously we follow Michigan law, Sixth Circuit Court of Appeals, any of their case law or decisions that come out.
And when you say Sixth Circuit case law, are you referring to the Sixth Circuit Court of Appeals? That includes Michigan, Ohio?
Yes,
Tennessee,
Michigan, Ohio, Tennessee, Kentucky. Yes, so throughout the year, their cases come down. We have legal reviews or legal updates rather, but the city attorney's office. And as cases come down, we try to glean information to if it has an operational impact in our day to day.
And in Grand Rapids, GRPD use of force policy and all of the policies implemented, is GRPD required to follow Michigan law? And
yes.
What other, and you mentioned, I think, that Graham versus Connor is also incorporated throughout the policy. Is that correct?
Yes.
Is GRPD required to follow South Carolina, Florida, or New Mexico law?
No.
Is that incorporated anywhere in the GRPD policies or training?
No. The only thing I would say to that is as incidences around the country pop up or happen, we constantly are trying to glean information off that, trends, concerns, those kind of things. But no, not for policies or state law.
And why is that? Why do you?
Just to try to learn, and because as we sit here right now, men and women are out answering 911 calls, doing the daily duties of police work. So it's imperative that we stay up on it and try to identify training needs or concerns or things that we're seeing as trends happen across the country.
And yesterday we heard from some of the prosecution's experts, and I think there was some mention of consent decrees that were entered, I believe from New Mexico. Is the Grand Rapids Police Department trained on or required to follow any consent decrees from other states?
No.
And is GRPD required to, or do they implement the International Chiefs of Police policy guidance into their policy?
No. I'm actually a member of the ICP and I follow their publications, but no.
And at some of the references to their policy, it was referenced as a policy guidance. Does that mean that GRPD is required to implement those policies?
No.
And you were here yesterday, and I believe, did you hear the testimony by Professor Stoughton and Mr. Bloomfield?
I did.
And did you hear them talking about this officer-created jeopardy theory?
Yes.
And
Right, that was an objection. I'm not sure what for. Kind of right, Hannah. Cue ball. Who wants to play pool? It's nice and shiny. I like it. Sorry, I'm eating ice. I have an ice problem, so I'm always eating ice. So, but I'm still here. I'm still here. I'm just eating ice. I don't want y'all to see me like eating ice. So, anyways, audio is currently sensitive information is being discussed. Oh, I like that little title line there. Sensitive information. We don't need to know it's sensitive. Although they're talking about tasering people in places that don't need to be tased, and yeah. This cameraman is wild with this camera. He makes me seasick every time he moves his camera. I don't know what to do about him. You eat ice, Paula? Yeah, I actually went on. I had bought from the TikTok store an ice machine with those little nugget ice makers, and it lasted 3 months. But I was so addicted to it that I ended up going out and bought me a $250 ice machine. It sits up on my countertop to make nugget ice for me all day long because I have an ice problem. So, yeah. But that was my birthday gift from my hubby. So Hector knew I wanted it, and he bought it for me. So he knows I have an ice problem. But these guys talking about that pepper spray. You know, I had gotten a pepper spray. I had gotten a taser and a pepper spray. In fact, this was early 2000s. And I wanted to test the pepper spray. And I wanted to test it. So I sprayed it down in the trash can, thinking that would be the safest place to spray it. And when I sprayed it in the trash can, it kind of blew back at me. And I didn't realize that it was going to do that when I sprayed it in the trash can. And I caught a whiff of that pepper spray. It killed my whole office for the day. Everybody had to stay out of the office the rest of the afternoon because I did that. So that was a lesson learned with pepper spray. And my taser, well, that was just my sidekick, you know. When I used to work I had a motorcycle business back in the 2000 teens and stuff. And so I always kept pepper spray in my desk. I kept a taser at my desk, firearm. I was very well prepared because you didn't know with motorcycles, you never know who's going to walk in the door. Because believe it or not, there are some bad. We never knew what was coming in the door, so we always had to be prepared. Look at this cameraman zooming in on all his patches and his name badge, and this cameraman needs some training. I know. I want to know what they're listening to. It's sensitive, but we're going to look at his badges. This cameraman, come on. He's bored. He's bored. That's what it is. The cameraman's bored. Hello, Maria. How are you? Right? This cameraman, he's gone rogue with this camera. He needs to calm down. I don't know. Oh my God, y'all. This is hilarious. The cameraman just went wild. I mean, he's going to zoom in on the fringe of the flag or something next. I don't know. Oh, now we're going to get to see the whole audience. Okay. I told you cameraman's bored. Y'all check this out. He can show everybody. Just don't show the jury, damn it. Okay. They're going back to talking. I'm going to mute again.
Okay. I withdraw my last question. Based on some of the generally accepted police practice that you heard Professor Stoughton and Mr. Bloomfield testify about yesterday, are those all consistent with what GRPD trains our officers to do?
Could you rephrase that? Sorry. It seems like a broad, in what police practices, I guess.
During the testimony from Professor Stoughton and Mr. Bloomfield, there were some tactical suggestions that they talked about regarding foot chases. Is that consistent with how Grand Rapids trains their police officers on solo foot pursuits if there is another occupant in the vehicle? Is there anything that prevents or
No.
prohibits that at GRPD?
No.
How are officers trained to handle solo foot pursuits?
Depending on the situation, biggest thing is to get radio traffic out that you're in a foot pursuit and evaluate the factors there, and then execute.
And is there any GRPD policy that prohibits an officer from pursuing a suspect or person when there is another occupant in the car?
No.
And I think we touched on this a little bit, but following up on what some of the testimony was yesterday from Professor Stoughton and Mr. Bloomfield, is they talked a little bit about the taser close probe deployment. Is there anything at GRPD that prohibits officers from using close probe deployment?
No.
And sorry, one second. Could you explain to the jury how GRPD officers are trained to assess actions by arrestees?
Yes. One of the first things we try to reinforce with newer officers is visual cues. Obviously, watching hands, waistline area. It's a well-known fact that the vast majority of firearms or illegal weapons are kind of hidden between the waistline or the hip bones, if you will. So watching hands, if they're trying to access a weapon or a firearm as you're approaching them, that's some of the biggest concerns. Watching for some nonverbal cues, if they refuse to look at you, if they're kind of looking for an avenue of escape, establish some kind of verbal dialogue with them, whether that's commands or directives, and gauge some compliance or lack thereof as you're approaching. There's multiple factors, but those are some of the kind of first ones.
Okay. And if I could have Bob pull up the PowerPoint that has Defendant's Exhibit E, which includes the GRPD policies. Thank you. And I am directing your attention to policy, and this is Exhibit E1, 9-1.3 to 9-1.4, Section 2. Are these some of the available responses that you were discussing?
Yes.
Okay, and you talked a little bit about some of the responses available and some things that you train officers to look for. And what is the officer's, when can an officer use these types of responses?
Well, the first one, A, there, officer presence, verbal direction, that's pretty much immediate. When you arrive on scene, you effect a stop, you make a contact, like I am here, full uniform, clearly marked as a police officer. And then establishing some kind of verbal direction, right? Stop, hey, come over here, get back in the car, get out of the car. Those are simple verbal directions. So that's the first step, and that kind of gives you an idea as you're visually kind of identifying and gauging compliance off that verbal direction. And then just working on that list, I'd refer to it as physical controls, where you're actually grabbing or trying to establish some kind of physical control where you're grabbing onto them. That would be, under B there, soft, empty hand. and then it progresses down from there.
Okay. And this is a continuation of that. So this is Defendant's Exhibit E1 9-1.4. Can you talk through some of the available options?
Yes. So as you saw on the first page, this is just the second series of options as you escalate in your use of force, or the force you tried to affect wasn't successful, right? So the top one, physical controls, I just said that, but that really is any type of you're trying to grab onto them. So now you're into some kind of strike, a kick, a punch. And you can see the sentence up there that, reasonably believes that soft, empty hand controls will be insufficient to establish control and the use of deadly force not justified. And then the next step is intermediate control. So kind of commonly refer to that as our tools, right? Impact, your baton. If you're equipped with less lethal munitions, which the vast majority of patrol officers aren't. And then the electronic control devices, tasers. So again, it has that language in there where you could move to that level, intermediate control before, after you can establish that lower levels of force have been ineffective, or you reasonably believe. So going back to that, to totality of the circumstances or the factors, right? Size is a huge one, right? So if I'm an officer that's 5 foot, 100 pounds, and the subject I'm dealing with is 6'4" and 280, we don't expect them to go hands-on with them. They could escalate to a taser device maybe right away, as opposed to, a bigger officer may have to actually physically go hands-on with them, if that makes sense.
Yes, and sorry, I jumped out of order here a little bit. I'm now showing what's Exhibit E1, Section 9-1.2, and it says number 7, 8, 9, and 10. So can you explain a little bit about what the officer's responses, what they're responding to?
Yeah, so that just kind of clarifies what we expect of our people, right? To gain control of a subject, they're trying to either take into arrest or detain for an investigation, or just general public safety. So that just defines what a response is. And then again, we go back to the reaction time. It's barely understood that it takes some time. Your brain's going to initiate an activity, but it isn't an immediate, right? It takes some time to actually initiate that activity or that response you want to do. And it just goes in there. And then at the bottom, a duty to intervene. That's clearly in our policy that we have a duty to stop another officer from unreasonable force or excessive force.
And now Exhibit E1, Section 9-1.3D, which can you talk a little bit about what the officer's use of force is generally based on?
Yes. So that language in there is just kind of a guideline. We ask our people, our men and women, to explain what that looks like. So inactive resistance, you can see in the parentheses there, clenching a fist, blank stare, looking for an avenue of escape. Those are what you could see and understand. The inactive resistance just gives it kind of a rough phrase there. And then you work down the passive resistance. That's kind of commonly referred to as like a protest or dead weight, right? Stand up, no, is dead weight. So they're not actively resisting, they're passively resisting. They won't react to verbal commands. And then it progresses down to active resisting, where you're actually physically trying to block an officer from grabbing onto you. You're pulling away. And then active aggression and assault, you're striking them, you're wrestling with them, or tussling. That seems to be a common phrase. Grabbing onto the officer, grabbing their equipment, and then a deadly force assault at the bottom.
And we already talked about the officer's available responses in 9-1.3 and 9-1.4. But just to clarify, so the level of control used by the officers, is that typically based on what the person's actions are?
Yes, with the caveat, I think they said it in a couple of them, that we don't have to progress through each one to jump to another one, or we don't have to wait to be punched to do, ABC kind of thing, or I don't have to wait to be shot to use deadly force. So it's all based upon, again, that objective reasonable standard. What would a similarly trained officer in a similar situation, how would they react? So it just spells out in our policy those actions and the options the officers have.
And how do you train officers to account for or incorporate the decision-making options when they're in a situation of use of force?
Yeah, we really focus on that reasonableness. There's more than one way to do it. It doesn't have to be perfectly right. It has to be reasonable with that information they had in that time-constricted decision-making process, recognizing that decisions take time to actually initiate. So you see it commonly where maybe the subject's facing me, and then as I initiate that action, they're faced away from me. So it looks like I hit them in the back or punch them in the back. But as I initiated that activity, they're facing me. So that's kind of the reaction time. We understand that.
And what are some of the challenges that officers might face to make slow or analytical decisions during use of force incidents?
Like we've talked about here, the reaction time, right? They're usually reactive in nature. When you don't have full, complete information, you're going off of your training and experience or reasonable decisions at that point, or what you can kind of, those factors, the totality of the circumstances. So if a subject's acting like they're armed, they're doing what we'd refer to as security taps, where they subconsciously tap their waistline where a weapon might be secreted. That's a reasonable response for me to key in on that and think that they're armed, right? Or they blade away, where they move their body position away from me. Like as you're standing at me, if I put my right hip or right side to you, I've bladed away from you to conceal my weapon. So those are clues or cues that we try to train our folks in, and we expose them to in scenarios to pick up on that, to start that decision-making process. And then we recognize that we try to give them some kind of parameters, and they operate in those parameters, and we constantly coach and train and mentor.
And how does the training account for an officer's reliance on like intuition or experience in these split-second moments?
They get quicker with recognizing threats or cues, or clearly a brand new officer, unless they've got vast life experience reading people, don't pick up on the clues that somebody with 10, 12, 15 years on the job was going to, until they've been exposed to that, right? Where you may give somebody 2 arms length distance away as I'm speaking with you, and then you're in 3 foot pursuits because they can pick up that you don't know they're going to run. So then all of a sudden you close that gap a little closer to be able to grab onto them. Things like that, where you allow somebody to move a little further, then you're involved in some foot pursuits, and you learn pretty quick that, oh wait, he's probably going to run or she's going to run. So I close that gap a little quicker. So it just speeds up the decision making as they get more experience and more training and more repetitions. And looking for conditioned responses, if that makes sense.
And why is that important?
Like I said at the beginning, we try to train the men and women to have been exposed to the vast majority of things we possibly can before they see them in an operational sense. And obviously there's limits. We can't do everything, but a conditioned response to an input is much better than I have no idea what I'm doing, I'm going to go off the fly, if that makes sense.
And when you are training officers in these scenario-based situations, are they, and like we saw with the taser exposure, are they usually in very controlled situations where?
No, starting, if you think of the concept, crawl, walk, run, we like to use that, right? So week 1 through 4 of recruit in-house is going to be pretty static, right? We're going to teach them skill sets, drills to reinforce positive reaction, and then we turn the dial up, if you will, the pressure up, where now it's much more dynamic. So that dummy that maybe he's doing a close probe deployment on now is a moving role player in a suit, and he may move as that taser goes, or those kind of scenarios where we run and we get the foot pursuits and we fight back. And so we try to turn the stressors up as much as we can without injuring the new officers or the role players.
And as part of the training, I guess just finishing up some of the policy stuff. Once an officer, and I'm sorry, for the record, I'm showing what's Defendant's Exhibit E1, Section 9-1.4. Once an officer makes the decision to use deadly force, are they required to try other options?
No.
Why not?
If the situation, that officer has deemed that situation has resulted in they're going to elect to use deadly force, they need to stop that threat in an immediate sense. So lower levels of force have a very less likelihood of becoming successful, especially if you've escalated through multiple options of force and now you're at a deadly force encounter. Like we've talked about, the time constricted decision making, exhaustion, various factors are going to have an impact in that. So deadly force, there's not time to go back to other options.
And are there some instances where it would be reasonable for an officer to go directly to deadly force without having to try
Yes.
any of the lower options?
Yes.
Can you give an example of when that might be?
Yeah. For example, I try to stop somebody here right outside the courthouse on Ottawa, somebody walking on the street. As I go to make contact with them, hey, stop for a second. They spin and they produce a firearm. I don't have to try to use empty hand tactics or anything else. I can immediately pull my firearm and defend myself.
And once an officer decides to use deadly force, are they, I may have said this a little bit already, but are they required to use a different force option before they resort to their firearm?
No.
And once they decide to use their firearm, can you explain how you train officers to use their firearm once they've decided that deadly force is necessary?
Yeah, so we do usually 3 to 4 times a year. Besides scenario-based stuff, we actually do firearms training with different weapon systems, different drills, whether it's standard marksmanship, point shooting, close quarter battle type drills where you're very close to targets. There's a whole multitude of training that goes into the use of firearms. And then in realistic based scenario training, we have the option of using training devices so we can, role players can recreate a deadly force encounter and the officer going through can deliver deadly force without injuring either party. So we have that a lot where we build specific scenarios to elicit those responses. Yeah.
I'm showing you what is marked as Defendant's Exhibit E2, and this is the Firearms Procedure 9-2.2. Can you explain when an officer may draw or display their firearm?
Yeah, it clearly says right there, fear for their safety of the officer, safety of others. So easy example of that is frequently we have break-ins around the city where a broken window in a business at 2 a.m., the officers are authorized to pull their firearms as they clear that structure or begin to clear that structure.
And once officers decide to use deadly force, now I'm showing Defendant's Exhibit. This is still E2 9-2.1. When can an officer discharge their firearm?
So it starts with a reasonable threat of death or serious bodily injury to yourself, another citizen, or another officer, and then to present the escape of a inherently violent fleeing felony crime, and the probable cause to believe that that subject poses a reasonable threat to others or officers.
And when you are training them on how to use the firearm, where do you train them to?
Yeah, so kind of a misconception, unfortunately, is shoot to wound. We train to stop the threat, and we teach to shoot center mass because that's the largest target area that people have. So upper chest, upper back, those areas. We don't train to shoot limbs or shoot the gun out of somebody's hand because the likelihood of success is not very high. So that in its easiest explanation is the preferred target areas for. But like I said, some of the drills, it's point shooting, if you will, where you're drawing your firearm under stress and you're firing rounds at a target. So you're not actively aiming your firearm, if that makes sense. You're not looking through your sights, developing a sight picture, taking your time. It's under duress, under stress, and you're just trying to get a response out right away.
And I think you mentioned close quarter battle.
Yeah, so it's a term, sorry, monikers and acronyms, but all that means is that threat is probably within arm's reach of me. So my arms are almost 3 feet long, probably. So that arm distance away from me, it's a very close-up threat. I don't have time, right, to create distance or put something between us. I've got to immediately defend myself or another. So we've gone through this for years now of draw your firearm, and obviously I can't extend it because I'm going to be presenting that to them. So I'm going to keep that firearm close to me and point shoot. And with the cycle of our handguns, the chance, so not that this is a firearms lesson, but we have a semi-automatic handgun. So as I pull that trigger, there's a top part of the slide that will cycle and come back. If I'm too close to my clothing, and we're in Michigan, so we're in heavy clothing 8 months of the year, I feel like, I've got to keep that slide away from me. So we teach to put the bottom of that firearm, the magazine that the rounds or the bullets are in, against our rib cage and shoot from here. So it gives me a little standoff distance, and it also prevents a malfunction of my firearm, if that makes sense. So that's a standard kind of close quarter battle drill we do, or close quarter combat drill we do at the range. And that's a very static in the sense of I'm standing in front of a paper target and I'm doing that. Due to safety and concerns for injury to my role players and instructors and cops, I can't really recreate those drills very well in training. There's some products out there that you kind of use, but it doesn't give you the same feel. So it's really hard to replicate that in a dynamic training scenario, if that makes sense.
And you mentioned something, I think, that it would be ineffective or something in certain circumstances. Can you explain what you mean by that?
I'm sorry, one more time.
Did you say something about it being ineffective at certain, using it in a certain manner when you're doing that?
Just more of a concern of creating a malfunction myself. So if I bring that firearm in front of myself, the slide could impact me or hit my vest and not cycle properly. So as you pull your trigger, a bullet goes, that round ejects out and a new round feeds in. So if it doesn't cycle properly, you've got a one shot and that's it. So that's why we really focus on bringing that firearm up kind of that rib cage area up here to prevent any kind of malfunction.
Okay. Let's see, I think we've gone through all of these. One of the things that we haven't talked about yet, and I'm showing what is marked as defendant's exhibit. This is part of E1, and this is 9-1.6. And this is also talking about the authorized use of force. But can you tell us a little bit about the verbal directives that are mentioned? What are in number E4? Can you explain what?
Yeah, I'm sorry. So yeah, whenever reasonably possible, officers shall provide verbal directives before deadly force is used. And I like to tell our newer officers that's, for example, you're in a traffic stop, you've got multiple people in the car, and you see somebody reaching for a firearm. That's a proper time to tell them, don't reach that firearm, I'm going to shoot you, right? A directive could be stop, drop it. It's a direction, not necessarily a warning. And when feasible, under life-threatening stress, time-compressed decision-making, exhaustion, some of those, when feasible, doesn't really make sense. It's not practical.
And when with this verbal directive, does it require you to say like stop or I'll shoot?
No.
I think that's all the policy stuff that I have for you for now. Sorry if bored everyone, but all right. So we talked a little bit about your training and the in-house training. When you've talked a lot about kind of how you train officers to be prepared for the use of force encounters in the real world through the scenario-based and the field training. One of the things that it seems like is kind of ingrained throughout this is that a lot of the responses are up to the officer's discretion. Can you explain why that is?
That we don't want to limit telling our men and women there's one response to that input or that stimulus or that situation, because it's just not practical. Like I explained, size of the officer, their ability. Clearly, I'm not a young man anymore, right? So if it's a 25-year-old officer compared to almost 50, right? There's physical skill differences there or experience. So we try to give them parameters, if you will, and to operate with inside those. So their decision doesn't have to be perfectly right. It just has to be reasonable for that situation and circumstance.
And if one officer would do something one way, but another officer might do it a different way, does that make it unreasonable?
No.
Why not?
Like I said, size, skill, and again, I'll use the term articulate. If I explain what I saw, what I felt, why I did what I did, then maybe it looks different than me watching it, right? Like you can't be in somebody's mind to know what they saw, what they thought, what they experienced. You know, videos give you a perspective, but not living through the moment.
And you mentioned that officers' reactions are not meant to be perfect.
Yes.
Can you explain that a little bit more?
Yeah, just are they reasonable? Keep coming back to that term. Are they reasonable for that situation? So yeah, it doesn't have to be perfect, and we constantly review and coach and mentor and train to try to perfect that craft, if you will. But again, we don't expect perfection. It's just got to be reasonable, because they don't have the luxury of having all the time in the world to make a decision, to come up with a tactical plan and have every asset and resource available before they initiate that plan. They've got to make split-second decisions under a lot of times serious stress and with a lack of information.
And is there ever one right option?
No.
I think you've explained, but why not?
Yeah, just going back to that last answer, there's variable factors to it. You know, the officer, their experience, their what they recognize as a threat, where one might not. Though there's just a multitude of factors, and that's why we don't bracket people down into one way, one track, because it's not practical.
Okay. All right, and Your Honor, could I have a brief moment? I realize I need to get my notes.
Your Honor, would it be okay if we just took a brief break? I just need to get some of my notes from my computer. Or we can.
3:15, Your Honor, maybe it's time for the afternoon break, if court declined.
Okay, I was gonna do one at 3:15, we're almost there, so. We will take a break for 15 minutes, come back at 3:30. So meanwhile, please remember to leave your notes and sign down in your chairs, that you're not deliberating, so you're not to discuss the case amongst yourselves or with anyone else, and also the restrictions are still in place to avoid news reports about this case in the media and on social.
Welcome back in. Today is day 3 in the trial of former Grand Rapids police officer Christopher Schurr. As you know, he's charged with second-degree murder and the killing of Patrick Lyoya. You've just heard testimony from Captain David Siver with the Grand Rapids Police Department. He is one of the officers who trained the other officers how to use of force and why. We're going to bring in 13 on your sides Riley Mack, who's been in the courthouse all day long, updating our live blog. And Riley, I'm interested to know, what are your key takeaways from the defense's witnesses?
Yeah, absolutely, Lauren. I think the day started with the prosecution's last witness, which is Nicholas Bloomfield, who is a use of force expert in the case. His appearance yesterday, along with Seth Stoughton, was immediately contentious for the defense. The defense today moved for a mistrial ultimately over the two's appearance in this trial. That's maybe the biggest thing that's happened in this case so far. They say that those two experts, Bloomfield and Stoughton, used outdated policies and an older taser model to base their facts off of, which was unfair to Schurr, saying that the jury has already heard these testimonies from these two men, meaning that it was unfair. They got an unfair view of the case from these expert testimonies. But ultimately it goes to the judge. The judge just gets that final decision. Judge Christina Mims ultimately says they never claimed to be experts in Michigan law. They only spoke on use of force, which is what their expertise is in. And she ultimately denied their motions for a mistrial. Right after that, the jury re-enters and it's business as usual in the courtroom. The defense brings in Robert McFarlane, who was classified as a forensic video expert. He did a second-by-second video going through the footage of the incident, kind of saying what was happening in each clip. And after about an hour of listening to second-by-second video commentation, the prosecution objects to this use of time, and the judge asks the defense, is there a specific spot that you want to highlight within this footage? The defense says, no, we want to show the entire video second by second. The judge, and I'm quoting here, says, you're creating an exhibit on the fly right now. And she says, I don't think this is a good use of time. She asks for the next witness, but the defense says they're not ready for their next witness, so they call for a lunch break around 11:30. And we come back into the courtroom with immediate turbulence. The defense wants to include evidence about Lyoya's intentions and character on that day, April 4th, 2022, which we've seen before in this trial with the argument over Lyoya's previous convictions with domestic violence. The judge ultimately decides once again, no, his intentions are not relevant to this case because Schurr did not know his intentions that day. And any type of decision we can make about his intentions are ultimately just speculation. Defense brings out 3 more.
Okay, guys. Yeah, so I'm back. Sorry, you're back to the present. What did you do, Hannah? What did you do? Oh, okay. No, sorry. I had to walk Hector out, so I had to leave for just a second. That's why I was like panicking because it started over to this. So, all right. So now we're at a point where they're on I think it's a 15-minute break. So we'll continue to listen to this lady and see what she's got to say.
With GRPD, and he's now become an expert on GRPD policy in the case. He can speak now in court on how officers are trained, when they're justified in using their tasers, their pepper spray, their weapons. They even showed a video of Schurr getting tased and pepper sprayed while in the police academy. And he speaks on, how when in GRPD policy, it says that deadly force can be used, what situations.
She's just repeating the same thing the man already said. We already know all that, lady. We already know all that. Okay. So, yeah, I know the Adelson hearing is going on, but 4 p.m. Eastern. I'm not sure how that's in 15 minutes, and they should be back from their break. So, I'm not sure how long the break said they were going to be. So, but she's reading. You know what I just realized? She's
thinking about an officer's behavior. So those are my biggest takeaways.
Was she reading from that website
this morning?
You've been watching all these witnesses so far. I'm curious on what your opinion is when it comes to seeing the differences in witnesses from the prosecution to the defense today.
Absolutely. I think yesterday, we heard from, I think it was just a handful of people, but on Monday we heard from 8 witnesses from the prosecution, a lot of which were, the people who actually saw the events taking place. We heard from the friend who was in the car when Lyoya was shot. He was filming it. He was right there watching. We heard from 2 neighbors who were watching the situation unfold. So we really got that, that firsthand perspective. Now we're hearing from people who arrived after it happened and, what they saw in their coworker, Christopher Schurr. We're kind of seeing a new side to him a little bit of how his reaction was, which is something we have never heard before. So yeah, a lot is being revealed in the courtroom today, I think.
And I wanted to ask specifically about Captain Cyver. It sounded like the defense was almost asking him questions that
I love
were
her
similar
hair.
to the statements that Stoughton
I
said
love her hair.
yesterday in regards to use of force or how people react in situations. What is your take on that?
Absolutely. They're kind of taking what Stoughton said yesterday and kind of rephrasing it in the terms of GRPD, because Stoughton, they asked him multiple times, are you an expert on Michigan law? Are you an expert on GRPD policy? And he said, no, I don't claim to be. I'm an expert on general police practices, what's accepted. Now they're getting into specifics with GRPD. What should a GRPD officer do compared to their handbook, their GRPD policy? So we're getting into the nitty gritty now, the details of how Officer Schurr was trained and how he reacted in comparison with that training.
Well, Riley, I know that they'll be getting back in session pretty soon, so we want to get you back into the courthouse. We appreciate you coming on and talking with us.
Thank you.
And like you just heard, we most recently heard from Captain Cyver. He's a captain with the Grand Rapids Police Department. He is an important expert in this case as he is responsible for evaluating and training officers through their use of force tactics. Cyver has explained aspects of how GRPD officers are trained in his testimony. Take a listen.
Can you talk a little bit more and explain what you are or officers are trained to consider under the totality of the circumstances?
Yes. So that phrase, totality of circumstances, it's the tangible facts or the tangible things in that instance. So an easy one is size, right? Is the officer much smaller than the subject they're trying to arrest or fighting with? Exhaustion is on there. That has a huge bearing on use of force incidents, weather, distance from the subject, the type of crime. And then the last one, and this isn't a complete list, obviously there's other factors that are going to play, but reaction time is a huge one because it's pretty well understood that action is usually faster than reaction. So again, sports analogy. A pitcher gets a pitch signal. He knows exactly where he's going to do it. He's going to be able to do it with relative control. The batter's got to react to that. If it was easy, a batter'd have 1,000% batting average. So same thing as an officer. They've got to pick up clues or cues ahead of time to try to give them some kind of a fair playing field.
And when you're talking about reaction time, is that something that's also trained to the officers?
It is.
And what are they trained about that?
Just to understand the concept that action is faster than reaction. So officers, for the vast majority.
Okay, we've seen this. I don't know what they're talking about. They're replaying what we've already seen because I went to the other one. They're on break, so we're just gonna let him sit there and talk. Let him jabber. The reporter, LOL. She decided she was a. Who's on first, guys? Who's on first? I'm lost. Y'all got me confused. I have no idea. Now you remember, you're right here. You just had to fast forward enough, Hannah. I'm telling you. You got behind. No, this is from earlier. They're replaying what he did earlier because I've got another one open and they're on break. So they're just replaying. I'll let him play and let him talk. I mean, they're replaying what he played earlier because the other site shows they're on a break. So I don't know. They're just, I think, what he already, we listened to him mumble jumble for so long that I think we got lost in his weeds. And yeah, they want to see the bald officer. That's it. That's it. And I think we got lost in the weeds listening to him because they're trying to justify his knowledge and expertise. And I think amongst all that, I think they lost a lot of the jury in that. Welcome back, William. So I think it got lost in the weeds. And I think that maybe these two ladies are trying to discuss putting it back in a perspective of what they were trying to do. Oh, Katya loves Taylor Swift. Uh-oh. Uh-oh. Baby boy is bald. And he's not. So really? Paula, are you serious? Yeah, we're not talking bad about her. She was just the fake one. She had the fake Taylor Swift hair. Thank you, Maria. Thank you, Maria. My man's bald. Hector's bald. Not gonna lie. Hector's bald. I love my bald man. Yeah, exactly. They're just filling in time, and they don't know what they're talking about either. They're not lawyers. I wish I could. It doesn't say how long the break was going to be. Let me back up on my other stream and see if it told me. Okay. So I just went back and looked. They took a 15-minute break because she was trying to get some paperwork together. And really, when Hector and I got together, he had hair and stuff and everything. It is now I'm like, just shave it off. Just let it go. Who cares? Don't worry about it. I like the baldness. I don't know. Oh yeah, Maria. Yeah. Oh yeah. Yeah, I mean, that's what Hector, again, I'm not gonna lie, he gonna be mad at me because I'm talking about it, but what the hell. But it's just genetics and men, it happens. And yeah, Discord, Paula. I read Discord faster than I can read Facebook. Discord's on my computer. But yeah, and I told him, I was like, he was like, oh, I got a little bald patch, Mom. I'm like, just shave that off. Who cares, But I'm not about appearances, so it doesn't matter to me. It's whatever makes you happy, And yeah, it's whatever makes you happy. Let it be, Hector. That's right. That's what I told him. Just it doesn't matter. I love you. Hair, no hair, it doesn't matter. And I don't know what to do about this, but see on this tab, yeah, they're at a break and they're not telling how long they're going to be. So I don't know what to do. Let's see. Paula, he's so handsome. Oh, how cute, Paula. That's so sweet. I seen that, Paula. That's so sweet, Paula. He's beautiful. I don't I'm sure you don't want me to share that with everybody, but if you go to Discord, y'all can see it. But yeah, it's fine if they shave it off. Although Hector has decided to grow his beard out, and I'm like, you know, tame it down a little bit. You know, he has a thing going with one of his brothers, and they're growing it out. I'm like, y'all go, y'all have fun, whatever. You know, it's just a competition, I guess, between brothers growing their beard. So, oh, you don't mind me sharing? Okay, I'll share it. There you go. That's Paula's son, the one here on the left. Isn't he a handsome devil? Look at him. Got his head shaved. Yeah. You're a shaver? Yeah, William, exactly. Exactly. Knocks years off of him. Knocks years off. Exactly. So let's go back over to this tab. And she's still over here just a chitter chatting her way. It's in Discord, William. I don't know how to do all that. I don't even know how to do. I know how to read Discord. I know how to read everything in there. I don't know how to do anything. Exactly. Salute to your son for protecting the community. Thank you, Maria, for mentioning that. I should have said that. You're right. Yes, and thank him for his service, because that's amazing. Yes, William. William. I just read all that. Oh, y'all crack me up. Y'all crack me up. But yeah, I do have a Chihuahua. I don't ever talk about him. His name is Paco. He
and they're trained to shoot in the upper chest or back, but obviously that doesn't always happen. And I want to ask my producer, is this okay? So this is now the proceedings they have started. So let's take a listen.
Okay.
All right, for the jury, please.
Welcome back.
All right. Captain Cyber, I would like to kind of walk through some of the training that Officer Schurr received and how it has been applied in this situation. Bob, can you please pull up Defendant's Exhibit B, which is the sync video with the transcript? B as in boy. Okay. And before we play the video, I just kind of, could you explain to the jury kind of some of the things that you train officers to do it when conducting a traffic stop?
Yes. One of the biggest things is to get radio traffic out as soon as possible, because there's a lot, as you can see in the body camera of Officer Schurr. He's got a computer by him, a radio. He's got to operate the vehicle, turn the emergency equipment on. So try to get radio traffic out as soon as possible, because pulling a traffic stop is an unknown risk. You don't know, again, you're back at that reactive point of their actions. So first thing is radio traffic. Simple as, the description of the vehicle, license plate, location you're at. If you can tell how many occupants are in it. And then activate your emergency equipment, and then approach the vehicle once it comes to a stop.
Okay. And Bob, if you could play the video, start playing the video through RFN 1246.
Marking. Nelson, degrees, Edward King Hall, 9367, channel.
Okay, so for the record, we're stopped at RFN 1236. And kind of backing up a little bit through when, we've talked about this a little bit, but there's no sound in the beginning. What does that mean? Why is that?
Yes, our obviously Axon, the symbols in the top right, same manufacturer's taser, our in-car video and our body camera. So there's an automatic built-in delay of 30 seconds. So there's automatic activations. So when Officer Schurr activates his emergency lights, that activates his body camera and his in-car video. It loops back 30 seconds. So there's multiple opening the back doors, manually or activating the gun locks, the shotgun or rifle, speed. If another officer in the area activates their equipment or their body camera, it Bluetooths into yours. So there's a multitude of factors, and that can be varied by agency, but ours is a 30 second loop. So that's why there's no sound until you see him on the radio and you can actually hear him. So it's just the 30 seconds catching back up. So that's what you see there.
And leading up to this point, was there anything that you would train officers to look for up to this point?
Yes. Obviously, it's 8:15 in the morning or 8:11 in the morning, so there's not a lot of traffic. It's a weekday. And as you see, if you could tell, Officer Schurr is doing a U-turn to turn and follow that vehicle. And as he's making that U-turn, you see it make a turn. And then as he turns onto that street, it turns again. So that could be a clue of they're trying to evade you or get to a driveway to pull into and quickly get into a house. Again, just possible factors that we train our officers to look for as they're affecting that or making that traffic stop.
And here, if you see at this point, when Mr. Lyoya opens the door and is stepping out of the vehicle, how do you train GRPD officers, or what do you train them to do if someone jumps out of the car before the officer has had a chance to get out of his car?
Yes. It's a concern because they again, the action versus reaction. The driver is already open the door, is getting out of the car. The officer's still on the radio or putting his vehicle in park, got to open the door to get out. Countless cases a year of officers being ambushed inside their cars as they pull a traffic stop. Happens far too often. So that's obvious the gravest concern. We try to we show some videos of that and show statistics so they have that in the back of their mind, understand that, and not to say that that's possible in every case, but it's a concern. They have to address that. So the driver's out of the car already, so Officer Schurr's got to hustle to get his car in park, get his car door open, and address that driver immediately. So like I talked about a little bit ago, Watching the hands is the biggest concern right away to see if he's trying to access the weapon. If he's blading away, like I talked about, or hiding a side of his body because he could potentially be armed. It happens. It's one of those things that steps up your concern when somebody immediately jumps out of a car.
And what do you train officers to think about if someone does jump out of the car?
One, to get out of your car. You're not in a good spot in there because it kind of locks you in. Like I said, ambushes happen, or people close that distance and are on top of you in your car before you can get out. So get out of your car, give some verbal direction right away to try to gauge. One, then you can feel for what that situation is. Maybe it is somebody that's late to school or giving their kids a ride somewhere and they're just trying to explain it. But you got to get out, have some verbal communication with them, evaluate that situation right away. So biggest thing, get out of your car, watching the hands, the waistline area, and then have some verbal direction with them, or communication with them.
And why, what manner of verbal direction do you train officers to have?
We're trying to be firm, right? It's not the time to, good morning, my name's Captain Cyber with the Grand Rapids Police Department. They're already out of the car, they're approaching you. It can be a grave concern. So establish some type of control, be professional, but establish firm control, verbal direction right away.
And what do you train officers to think about someone who's jumped out of the car?
Like I said, not to say every instance like this is going to be some kind of a tragic ending or you're going to be viciously assaulted or killed, but it's a possibility. So you've got to mitigate that right away. So getting out of your car, addressing them. Like I said, sometimes it's just they're being evasive. Again, you're reacting to that driver. The driver knows if what they've done or if they have a valid license, they don't have a license, they have something in the car, they don't want you to find out. So again, far more common for people to flee right here or try to distract you enough to get you off of your preliminary investigation there.
Bob, if you could play, could you dim the lights, please? Bob, could you please play the video through RFN 1846?
Hey, stay in the car! Stay in the car! Stay in the car!
Startled me.
Dude, I'm stopping you. You have a license? You have a license. What? I'm stopping you. Do you have a license? What then? Do you have a driver's license? Do you speak English? Yes.
Yeah. Okay, and for the record, this is RFN 1830. Okay. So I want to walk through some of this. What do you train officers to do when they approach the vehicle in this instance where someone's jumped out of the car?
Like I said, watching the hands is the gravest concern right there to make sure they're not going to try to access a weapon. And establishing some type of verbal direction commands to gauge cooperation. Officer Schurr clearly is instructing him to stay in the car, get back in the car. He's not cooperative. And then he wants to argue why he's being stopped. Officer Schurr is trying to communicate with him, confirms he speaks English. So he closes that distance to cut off an avenue of escape. That way, if the subject tries to flee, he's much better positioned to give chase on foot.
And can you talk about, why does Officer Schurr, why do you train officers to ask for a driver's license?
It's just the immediate part of the traffic stop. One, to identify the subject, and then two, to establish whether they have a valid license or a license on them, because then that could lead down the path of having a reason for a valid arrest right away. So you can effect an arrest and continue that investigation.
And if someone doesn't produce a license, what do you train officers to do?
Typically, driving while unlicensed without your license, it's a misdemeanor offense in the state of Michigan. So they're going to at least be temporarily detained, if not physically arrested. So if they refuse to produce a license, or they don't have one, then try to cooperatively talk them into handcuffs. If not, then you have to physically restrain them.
Okay. Bob, could you play the video to RFN 1945, please?
Can I see your license?
And for the record, this is RFN 1949. Do you observe the driver at this point doing anything when Officer Schurr asks him for a license?
Yes, when Officer asks the driver for the license, the driver reaches to, it appears his right back pocket, taps it to like, I'm gonna get it out of my wallet, and then just taps and keeps moving without producing a license. So again, those are verbal cues. We try to train our people to recognize that that's evasive or evasion, if you will, that you've asked them for the license a few times, they're not providing it, and now they're, whether they're trying to initiate a plan or what, they're trying to keep you from your direct action.
Bob, could you play through RFN 3195, please?
The plate doesn't belong on this car. Do you have a license or not? Do you have a driver's license? Where is it at? Get it from me. The plate does not belong in this car. No. Stop.
Okay, and for the record, this is RFN 3213. At this point, what do you observe about Mr. Lyoya?
At the start of the video, or start of this clip, rather, excuse me, Officer again asked him for his license. He opens the door and asks the passenger to find it. Again, not a uncommon thing where, again, trying to be evasive, try to distract you. Officer gives him an opportunity to produce a license. He doesn't, and he's under arrest for driving on license or without a license, at least at this point. So he, right before the end of this, the driver starts to move towards the north of the car, which is common to, hey, I don't have a license. I know I don't have a license. I'm going to try to maybe create some distance and run, flee. So Officer Schurr grabs him by his upper arm and shoulder there, it looks like.
Okay, and this is how you train that?
Yeah,
officers?
to grab and to, limit that avenue of escape. And more times than not, just that grab and pulling their hands behind their back is enough to effect an arrest.
Bob, could you please go forward to RFN 3195? Oh, sorry. Okay, sorry. Can you go forward to 3344?
Stop.
Oh, sorry. Could you back up a little bit? Okay. So leading up to, and for the record, this is RFN 3344. Throughout this, can you describe what you saw here?
Yes. So the start of the clip, officers got a hold of the driver. And as he tries to, I assume, try to bring his arms behind his back, the driver spins and by spinning is able to push the officer off of him or kind of launch him, if you will, almost off of him. And then Officer Schurr goes back in to grab onto him again. And the driver actually like strikes at his hands to knock him away and then is creating this distance here.
Okay. Could you just back up frame, like a few frames? Keep going. So you were saying, when did you see, can you just explain kind of what you're talking about with the?
Yeah. Can you zoom into the top screen?
Thank you.
So you can see it appears Officer Schurr's feet are, if you go back and forth a little bit, his feet actually come off the ground. They're off the ground there. So as the driver spins and Officer Schurr's got a hold of him, he's actually off the ground. So that movement by the driver is enough to actually physically pick him up and spin him. And then he breaks his grip by actually, on the bottom screen, you can see it appears as the driver brings his right arm down. As you can see, it knocks Officer Schurr's left hand off his grab, and then he ends up hitting his own arm and knocking it off by that strike or block of the driver into Officer Schurr.
And at this point, what level of resistance would the driver be using, Mr. Lee?
Active aggression, in my opinion, by the strikes. And it went from a driving offense to now a resistant obstruct or assault on a police officer.
And what type of offenses are those?
State R&O charge is a felony. Depending on the assault on a police officer, that could be two, but not here, I would think.
Okay, and is there anything about the positioning of Mr. Lyoya that you observe in this that you would train officers to look for?
Yes, so I would refer to this as an inside position. So clearly at the beginning, Officer starts with his like a chest to back position where he's behind him. That's ideal. But when we're face to face, that's a problem because then we're much closer to be assaulted. Clearly the driver can block your hands or punch your hands away. It's difficult to control a human being face to face. So ideally we want to be faced away.
Okay. All right, Bob, could you please play this through 3402? Okay, for the record, this is RFN 3415. At this point, and I guess a few frames, backing up a few frames, did you observe anything about the vehicle that Officer Schurr was driving that day?
He's got his lights activated and it's fully marked. We drive Ford Explorers, more or less sedans, so they're fully marked. It's got a full light bar on it and it's activated. And he's in a full uniform, full police uniform.
And you see Officer Schurr reaching for his radio. Oh, I guess we can play it. Bob, if you want to play the video now through 3471. And for the record, this is RFN 3477. When Officer Schurr calls out on the radio, we got one running. What does that mean?
It's just simple radio traffic to let dispatch and other units know that you're in a foot pursuit. So again, it's imperative to get that information out because now you're separated away from our car. Our car's got a locator in it, but we don't have locators on human beings. So as Officer Schurr gets away from his cruiser, it's inherently concerning because we don't know where he is. So for accountability and manpower issues, but so he gets the radio traffic out right away. And if you, in that freeze frame in the bottom, you notice I spoke about concerns of secreted weapons or people carrying weapons from hip bones. It's kind of widely accepted in our law enforcement industry that to access that firearm, I've got to create some kind of an arm angle to access that. So on foot pursuits, commonly we see that elbow bend, and not to say that everybody is armed that we chase, but it's something that we train our officers to watch for, to be cognizant of, because it can easily turn into them accessing a firearm. And we've had numerous cases in my career have it happen. So it could be something as they're trying to keep clothing up, but it is a trained cue for our officers.
And when Officer Schurr called out that he had one running, how do you train other officers to respond to that?
So when he calls out his traffic stop, available area units will start that way. Normal driving conditions, obeying traffic laws, no emergency equipment. Again, it's 8:10, 8:15 in the morning. It was a weekday. So traffic's probably pretty congested in the east service area, on the southeast side of the city. So once he calls out a foot pursuit, at least the east units should be responding emergency mode, lights and siren if they're available. If not, other service areas. So directly to the north of that would be our south service area, and then north, central, and west. So manpower was an issue that day. We were very short-staffed. So whatever units were available should have been heading emergency fashion, lights and siren, and driving with due care and caution, but obviously exceeding the speed limit.
And why do you train the officers to respond with lights and sirens?
Because of the risk, you're fighting with someone. We know that we want more cops there than not. So to try to get people there as soon as possible. One, the cruiser's unattended. You don't know. Sometimes officers end up in backyards. They don't know exactly where they are. They end up in houses sometimes as people flee into a house. So there's a multitude of reasons, but we want to get that radio traffic out right away.
And at this point, once someone is under arrest, do you train GRPD officers that they can just let them go?
No, that is not common practice.
Why not?
Because there's an inherent risk to the community. Just in this example here, if this stops, the driver has already committed a couple of arrestable violations. He's fleeing on foot. We've had numerous cases of people fleeing into other people's homes, breaking into homes, outbuildings. Like I said, it's a school time of the morning. So it's just a risk to the community. That subject knows they did something that they're going to go to jail for, and they've fought with the police and they're running away. So, and if the officer, say he gets back in his car and starts driving to find him again, there's no saying that subject can't get back in his car and drive away, right? And now we've created that jeopardy. So we train people to chase and effect an arrest.
And what do you train them to do if there is another person in the vehicle?
Be aware of it, but it's more of a risk when we're fighting around cars or struggling with people and there's 4 people in the car. Some of those things, we've had multiple instances of that, but running by a car that's occupied is not, be aware of it, but it's not a hindrance to say, don't ever do that.
And in some instances, is there any training that you provide on someone who is in this situation where they're by themselves and they have to engage in a foot pursuit?
Yes, we do multiple scenarios with that in-house where we force the officers to run, chase the role player, and then work through the scenario.
And is there anything that would prohibit Officer Schurr from continuing to follow?
No, we and that's why we train on it. We talk about some of the risks, right? Where people potentially are armed, following the same path, nighttime, backyards. There's a multitude of reasons, or issues, but that's what we train to be aware of it and mitigate those as best possible.
And pursuant to GRPD policy and training, is it your opinion that Officer Schurr was reasonable in pursuing Mr. Lyoya at this point in a foot chase?
Yes.
Even though there was someone else still occupied in the car?
Yes.
Bob, could you please play the video to RFN 3555? Okay, for the record, this is RFN 3555.
Sorry if that startled
what do you train
anybody. It got
officers to
me.
do once someone is actively running away?
To try to catch them, obviously. That's with varied success sometimes, but obviously Officer Schurr catches up to the driver pretty quickly. And then it's sometimes people give up right away when you tell them to stop. They lay down, they put their hands up. Other times we have to tackle them to the ground or push them to the ground. And clearly in this incident, Officer Schurr pushes the driver to the ground or tackles him to the ground.
And based on what Officer Schurr, or it appears that he would know at this point, just that the plates didn't match the car and the driver was starting to run away, what would you train, or I guess how do you train GRPD's officers, or what do you train them to think about with regards to the car?
It's unknown. Again, it could be a multitude of factors there. An improper plate or a plate doesn't match the vehicle isn't in itself that uncommon, but it could be maybe the car's not reported stolen yet, or maybe they just bought it, they didn't register it yet. There's a multitude of factors there, but it's a concern and it's a valid reason for a stop.
And what do you train officers to think about the person who's running at this point?
Well, just this has continued this path of noncompliance, and it's escalated from verbal noncompliance to failure to produce an ID, failure to produce license. Now there's been assaultive behavior. Now they're fleeing on foot. It just continues down a path of lack of cooperation.
And Bob, can you please play the video to RFN 3373? Oh, no, sorry. 4479.
Okay. Stop! Stop! Keep your hands behind your back, okay? Hands behind your back, okay? Your hands behind your back.
Okay, and for the record, this is RFN 4479. Could you zoom in a little on the upper left, which is the dash camera, please? Okay. And could you play this to RFN 4823? Okay, so I guess, sorry, I should have asked you this before this part, but leading up to this point, what did you observe Mr. Lyoya do?
So Officer Schurr tackles him to the ground and has to get his radio secured, and is struggling to try to keep him on the ground. And in these clips that we just saw, the driver is able to get back to a tabletop position, if you will, where his hands and knees are on the ground. He's in a good base, meaning it's very challenging to break that back down. And then he's able to even get back up. They go back down, he gets back up. What is striking is the continued that Officer Schurr is unable to physically control him, and he puts out radio traffic of send me more cars, which now means everybody that's available should be coming emergency mode. So that's the whole city is coming to him because it's an emergency. He's asking for an emergency response. So he's clearly unable to control the driver. He's tried lower levels of force with the tackle, some knee strikes. He's trying to physically push him back down, and he's unable to.
And you mentioned a tabletop position. Can you explain what that is and what that means for the officer?
Yes. So the subject on their hands and knees, think of a toddler crawling, right? That position is what we'd refer to as a tabletop position. It's a very strong position if you don't want to be moved. You have your limbs are kind of shortened. You have all your power in an inside position, I call it. You're tight, and it's challenging to defeat that. And being like riding on somebody's back right there, if I'm trying to put all my weight on them, it's easy to roll that or reverse that situation where the top position now becomes the bottom position, and it's a dangerous situation.
And from the last segment of the video that we just saw zoomed in, what did you observe about Mr. Lyoya when he was on the ground in the prone position?
Just that he was able to get back to a standing position with relative ease, regardless of what the officer was attempting to do.
And at that point, what was Mr. Lyoya's, I'm sorry, this might not be clear. Bob, could you just back up a few frames to RFN 4579? And then frame forward to 4672. If you zoom in on the dash cam. 4579 to 4672. And from, I guess from this position, what did you observe?
Yeah, so that's what I'm referring to is that tabletop position. You see the driver's on his hands and knees, and Officer Schurr is, for a lack of a better term, almost like piggybacked, right? He's just riding them. And both feet are off the ground, his hands are off the ground. He's trying to call out on his radio, so he's distracted with his one arm. He doesn't have full control. So he's calling out with his radio, and he's in a bad position because, for example, the driver would have to do is duck his head forward and lift a little bit, and that officer's going over top of him. So then he's on his back or face down, and then the driver could easily be on top of him.
And a few frames forward, did you see Mr. Lyoya on all, when you say, we talked about prone position, can you explain what that is?
Yeah, so prone, just belly down, your face down on the ground, belly down. And that's an ideal handcuffing position for us. We want to be on top while they're prone or face down. As you can see, the officer attempts that multiple times here, and the driver is successful in just standing up on his own power, regardless of the force being put on him.
Okay. And did you observe Mr. Lyoya go from the ground, stomach down, and push himself all the way up?
Yes, he did that various stages through here, but yes, he does that. And that in itself is going back to the totality of the circumstances, the factors in use of force decision-making or objective reasonableness, size, strength, ability. Those are the factors. And as this progresses, exhaustion. So it's physically, it's extremely difficult to control another human being that doesn't want to be controlled. It's exhausting. So you can see that this has been going on for several seconds now, this struggle, and the officer is unsuccessful in his application of force at this point.
And at this point, what would you train an officer to look for as far as his surroundings? What would be other indicators you would train an officer?
The gentleman in the white, I forget the witness's name, sorry. Is that Mr. Butler?
Mr. Butler.
He's saying something to the driver or the passenger, I forget, but he's there. So that's a concern. He's an unknown subject, whether he's going to help you or help the driver or what that situation is. And then obviously the passenger in the vehicle now is out of the car, and they're both kind of in the peripheral view of Officer Schurr. So now he's got multiple subjects. He's not able to physically control the driver that he's dealing with. So yeah, he's got to be aware and be concerned with it.
And at this point, are Officer Schurr's actions consistent with GRPD policy and training?
Yes.
Okay. Bob, if you could please play through 5408.
Stop. Stop resisting. Make good numbers in nothing.
And based on this, did you, at this point in time, have you heard Officer Schurr call for backup again?
The send me more cars, yes.
And at that point, what would you expect the responding officers in the area to do?
Respond emergency mode, so lights and siren, and get there as soon as possible, as safely as possible.
And what have you observed about Mr. Lyoya's behavior during this part of the video?
The verbal okay is not matching his physical actions. Right? He's verbally saying okay, but there's no compliance there. It's the polar opposite. So the officer, they get to their feet, and Officer Schurr tries almost like for lack of a better term, chicken wing his arms behind him, maybe an attempt to handcuff him, secure him, but they progress across the lawn in a kind of a southerly direction there, and then another knee strike is applied, and then it appears he tries to do some type of a takedown from where he's got him wrapped up in his upper half, and that's unsuccessful as well.
And is there anything that you observe about Officer Schurr throughout this?
Yeah, if you back up a couple frames and play it again, you can hear his heavy breathing. So it appears he's already hitting levels of exhaustion.
And what do you train officers to do once they start feeling exhausted?
Well, and we talk about this a lot, and as they first come aboard, it's kind of accepted that, hey, in 30 seconds of strenuous output, you're roughly going to have about 50% of the energy levels you started that encounter with. So if you're struggling with somebody or fighting with somebody and you start out at 100%, you're going to be greatly reduced here within 30 to 45 seconds. So we teach them to use force reasonably, but with full force initially, because we don't want these to draw out for a longer than they have to.
Why not?
Because the exhaustion level has a bunch of effects to it. It can impair your decision making. Clearly, you potentially can't defend yourself. Your tools on your belt. There's a list of factors, but yeah, exhaustion is a problem.
Okay. Bob, could you please play the video through 5548? For the record, and leading up to this point, what did you observe Mr. Lyoya doing?
Still actively resisting the officer, zero compliance. And again, like I said, he's giving verbal okay, like he's going to comply, but he's not showing any compliance at this point. The officer's been unsuccessful in all of his attempts to use force up to this point. In that bottom left screen, it appears that the officer's got a hold of his sweater, like in the upper shoulder area, and his right arm is going across his body. And as we know now from watching the video multiple times, he's accessing his taser, which is we teach our officers to carry it on their non-dominant side, in a cross draw style application, like I have mine on my left side, to avoid any type of confusion during a deadly force incident or create that where they pull their taser on accident or vice versa. So we've always dictated they carry it in a cross draw style. So as you can see, Officer Schurr's arm is coming across his body to retrieve that. And it's of note, it takes him a few seconds to get it out. From the graduation video where he's on the dummy, he struggled and he had two hands to access that. Our old holsters at this time had a snap brake, and the snap went towards your body. So if I was leaning that way, I'm fighting against myself, if that makes sense. So it takes him a little bit of time. He's one-handed, and he's trying to hold the driver with his back, upper shoulder arm area there, his sweater, and access his taser with his right hand.
And Bob, and is there anything that you observed Mr. Lyoya saying at this point?
I didn't catch that in any of my reviews because I didn't have the dictation until recently, but the get the keys part. So that is concerning because what's the plan there? Is there a weapon in the car? Was there something? So.
And Bob, could you please play the video through RFN 5649? If you could back it up just to frame 5648. Okay. For the record, this is RFN 5648. At this point, what have you observed?
Excuse me. As Officer Schurr has a hold of him and he's trying to access his taser, again, going back to that reaction time, he formulates a plan in his head to grab the taser, but it takes him some time to actually accomplish that. So in that meantime, the driver spins, so now they're face to face. So you see in the bottom left frame, Officer Schurr's got a grip of his upper sweater still, because that sweater's loose fitting and he's able to spin on him. So now he's on an inside position, and it's hard to see over, you're on his computer screen there, but he's reaching for Officer Schurr's taser. I can't tell if he does have a hold of it.
And what does the training teach about the dangers of Mr. Lyoya having a grab on the taser?
It's quite uncommon, frankly. We have a few a year maybe where there's an attempt disarm, but they're usually holstered. We've had a few incidents over the years where they swat at it to try to deflect it, but we've never had where somebody grabs onto it while it's out of the holster like that and is driving it away from themselves. So that immediately raises huge concern of that's not an attempt to just to swat it away. They're grabbing hold of it and potentially going to disarm you.
And what does the training teach about the dangers of having a weapon taken away?
Just that the chances are it's going to be used against you. You get disarmed of your firearm. It's the statistics are out there that it's not doesn't end well for officers. So that's the presumption. Yeah.
And how do you train officers to perceive someone who has taken their weapon?
How do you perceive them? Sorry?
Yeah. How do you train officers to, or what do you train officers to think about someone who's reached for and grabbed their weapon?
That it's it potentially is going to be a deadly force assault. Again, trying to attack an officer and disarm them has escalated into the highest levels of resistance.
And what does GRPD train officers to? How are officers trained to assess threats when they're disarmed?
To fight, to retain that weapon, obviously, at all costs, and then fight to get that weapon back.
And what do you train officers to think once they're fully disarmed?
Again, that it's a deadly force encounter. That's not again, like I said, we haven't had a successful weapon disarming in long time, decades. So it happens around the country, and officers are killed yearly because of it. So it's of the greatest threat.
And what does the training teach about the intent of someone who disarms a police officer?
That you have to presume it's for the worst reasons, right? I don't have to, if I get disarmed by firearm, I don't have to wait to have it used against me. That intention alone to grab an officer's weapon is the gravest threat.
Okay. Bob, could you play the video through RFN 5770, please? Okay, and at this point, what do you observe Officer Schurr doing?
So just as the frame starts and the driver grabs hold of the taser, Officer appears to do, I refer to it as like a wheel weapon retention, where he wheels it to the ground in kind of a circular motion to try to break that grip. And if you look at the bottom left screen, the grips of the officer and the driver there, the driver's got a dominant grip. He's got an overhand grip and his arms locked out, and the officer's got just the handle of that, where the purchase of that taser, the majority of it is on the front of it, not the handle. So he's got a dominant grip over the officer's grip. And the officer's tried a couple weapon retention techniques and has been unsuccessful. And one set of probes is already deployed, where the officer tries to, like I explained earlier, not an ideal distance management, but he could have easily fired one set of probes, fired another set of probes, and gotten the spread that would have accomplished the neuromuscular incapacitation or lockup if he hadn't grabbed on, the driver hadn't grabbed onto the taser.
And at this point, what is Mr. Lyoya doing?
He's driving that taser away from himself, and it appears towards, and they're, well, the cell phone video shows they're both traveling towards the ground.
Bob, could you play the video, please? Through, I don't know yet, but I'll tell you when to stop.
Let's on the taser.
Oh, Bob, sorry, can you stop there and back up a little bit? And zoom in on the cell phone video?
6256.
Yeah, sorry, can you back up? I missed mine. Yeah, if you can go to 5825, or if you can just zoom in and I'll tell you when to stop. If you can go a few frames back.
I can't see the RF.
Okay, if you can just back up and I'll tell you when to stop. Okay, stop. This is RFN 5882. And at this point, what do you observe Mr. Lyoya doing with the taser?
He's still got control or attempting to take control of it. You can see Officer Schurr has still got it in that grip that he had before. And it's pointed at the ground. You can see the LED flashlight pointing towards the ground. So now in that position that Officer Schurr's arm in, it's an odd position, right? He's got that elbow bend going. So the driver's on his back and has, again, locked out arm, a dominant grip.
Okay, and what hand do you observe it in, Mr. Lyoya's?
It appears it's his left hand.
Okay. Bob, can you play it moving forward, please? And yes, if you could stop at RFN 6220. Okay, at this point, what do you observe? Where is the taser located at this point?
It's directly into the ground. And again, similar positions. The Officer Schurr's got an odd angle arm, kind of a bent 90-degree arm angle, and the driver's got, again, still a locked out position with what appears to be a dominant grip.
And what hand do you observe the taser in Mr. Lyoya's?
It appears it's his right hand now.
Okay, Bob, can you play the video, please?
No, like he's good, like you can talk to him, right? Yeah. Like he's good, bro. Like can you talk to him like good, like can you, yeah. Stop grabbing him like that. Like he's good at first. Yo, you hit him too. Now he ain't probably saying, I see.
Can we stop it here? And zoom out. This is RFN 7489. And at this point, what do you observe? I know the camera went out a little bit, but what do you observe?
The biggest thing that struck me was it sounds, you can hear the stress in Officer Schurr's voice, the exhaustion. He's barely getting out commands. They're lagging, if you will, or they're drawn out because of lack of oxygen. He's breathing so heavy. The positions have switched again to be, again, the driver's in that tabletop type position. And you can see as it backs up, he rolls to that position and the officer kind of rotates to the top position again. For a brief second there, he's rocking on his back. His feet are off the ground. He's in a very unstable position, and he moves to access his firearm after a command to let go of the taser.
And Bob, if you could zoom in on the cell phone video, please. Where do you observe the taser at this point?
It appears it's in the driver's right hand.
Okay. And Bob, could you just do a frame forward from here? And I'll tell you when to stop. Sorry, you can play it, I guess. Okay. Frame forward from here. Okay. Stop right here. If you could back up for the RFN. Okay, and what did you observe here?
The struggle, the position is fluid, right? The officer's access his firearm, it's out of the holster. He's trying to maintain some type of a position on top. The driver is now turning back to the inside position, appears where his right hip is towards the ground and he appears to be spinning into the officer. He's got control of the taser. It's in his right hand, it appears. And the officer's got his left arm kind of draped over the driver's left shoulder to try to maintain some balance.
And at this,
and another command to let go of the taser was in that clip there too.
I think it was drop the taser on that one.
Was it?
Yeah, this is, we're at the, like, right, the last drop the taser. So this was after he had given the final command of drop the taser. And at this point, I guess we can just play it forward from here. Okay, and for the record, this is RFN 10,181. So leading up to this point, and I know we kind of talked about this a little bit before, but in your experience, how fast can someone on the bottom reposition themselves so they are facing you or gain some sort of advantage?
How fast can they reverse that position? Is it
Mhm.
in a blink of an eye? That can be in a second or two.
And in high stress, close quarter situations like this, is it realistic to expect that an officer could stop someone from initiating or completing a full spin if that happens quickly?
I'm sorry, could you ask that one time?
In this type of situation where it's dynamic, it's moving very quickly, is there a situation, is it realistic to expect that an officer could stop someone from initiating or completing the spin rolling towards them?
No, in the sense too of the video, if you saw the steamy breath out of Officer Schurr, that would indicate how deep of a guttural breathing he's trying to accomplish there. So at that level of exhaustion, no, I don't believe he could have prevented that situation from spinning in a second or two.
In your opinion, based on your training and experience, does the threat from the bottom position ever end until they're fully controlled?
No.
And based on everything we've reviewed, do you have an opinion on whether an objectively reasonable GRPD officer in Officer Schurr's situation would have been in fear of a serious bodily injury or death when Mr. Lyoya started getting up off the ground with his taser in his hand?
I do.
And what is that opinion?
That it was reasonable, that a reasonable officer could perform the same way in that situation.
Thank you. No further questions this time.
I just want to start out with one of your statements. Your statement was the GRPD is trained to chase and effect an arrest. That's what you just told the jury, correct?
That's a common practice, yes.
Those were your words. Those are your exact words. I wrote it down. Trained to chase and effect an arrest.
Do we train? Yeah, we train our officers to do that. Yes. That's an expectation. Yes.
But when we were notified you're a witness, you talked to Detective Tubergen, didn't you?
Yeah, I did.
You said there's no foot pursuit policy.
There's not a foot pursuit policy, correct?
But you train them to effect an arrest.
Yes.
Now, this has been pending for like 3 years. Did you prepare this?
I did.
You typed it?
The affidavit?
Yes.
No.
Who typed it?
The defense.
So the defense. So the defense typed it. So
Yes.
you've been how many times have you met with the defense over the course of the last 3 years?
Probably 5-6 times.
And you've had access to some of their videos as well. So you've gone over this case with them 5 or 6 times?
I did not have access to the video until now. I haven't seen it until this week.
You
I mean, the video I had access to was Axon, the body camera stuff, okay, we're not the forensic video.
But this week you said the one with the writing on it, you said you had access to it. You watched it earlier this week.
I saw it, yeah, this week. Yes, not before this week.
So this is one of the biggest events in Grand Rapids in probably your career, isn't it?
It is.
And you don't bother to do a report?
I did an incident report.
An expert report. You have access to our expert reports, haven't you?
Your expert reports?
Correct.
Yes.
So you read our expert reports. It's like a 56-page report.
It is.
You're brought up as an expert for the defense. You're their expert. You got at least their degree, GRPD policy, and you produce a 2-page affidavit.
Yes.
Even in that affidavit, you don't say anything about training to chase officers or to effect an arrest. You don't say that in this affidavit, do you?
No.
You say includes training on solo foot pursuits, such as drills and scenario-based training. GRPD does not prohibit officers from chasing a fleeing suspect.
Correct.
That's different than you train them to apprehend a fleeing suspect, isn't it?
The solo foot pursuit drills will end in an arrest.
Prohibiting and training positively are two different things, aren't they?
Yes.
Where is that policy? Where's the written policy where you train to effectuate an arrest? We spent an hour and a half here looking at all the policies. Where's the written policy where you effect an arrest? You train your officer to effectuate an arrest.
Off of foot pursuit?
Yes.
We don't have one.
You don't have one. But that's your testimony now suddenly in front of this jury that, yep, we trained that.
Objection, Your Honor. This was argumented, and if he wants me to go through the mandatory training, I will gladly do that, but.
I think he's not cross-examining. So which part? I mean,
The fact that he's trying to portray that there's no training or policies. I did not walk him through it. If you'd like me to walk through this, I'll gladly go through all this, but I'm trying to speed it up.
I'm gonna overrule the objection, and you obviously will be able to redirect, and you can certainly point out what you'd like, but I don't believe that last question was argumentative. So.
I mean, you had an hour and a half to present the policy, and we didn't see any policy. These are the policies were provided. These are the training policies for Officer Schurr.
These are training outlines. These are policies, yes.
Okay. Where? Point it out. Where is it?
His recruit class one is in here? Is that in here?
There's a recruit class. We got everything.
Okay. His recruit class is 15-3. These are, this is 21.
These are the training documents we have.
He has a recruit class book of 15-3. We, not being argumentative, we train in foot pursuits. We do solo foot pursuit drills. We don't have a policy that mandates, but we don't have a policy that prohibits it.
So it doesn't mandate. You said you train to chase and effect an arrest. It doesn't mandate. It means that basically they can chase based on the circumstances, right?
Yes.
All right, that's a bit different than they just run. You don't train them to be greyhounds chasing after rabbits, then, right?
Correct.
It's based on the total facts and circumstances.
Yes.
So if somebody's driving down the road and guy's got a gun in the car, passenger's got a gun in the car, driver flees, you're not going to chase the driver. You're going to stay with the passenger, right?
Potentially.
Potentially?
Do we know if he's got a gun? Do you see the gun?
I just said the passenger's got a gun. Passenger's got a gun. Driver flees. You're going to have your officer stay with the guy with the gun, aren't you?
Yes.
Okay. Well, that's based on the totality of the circumstances. That's a little bit different than what you testified to, right?
That situation is completely different.
Sure. So it's based on the totality of the circumstances, just like we've been talking about. All those policies up there, the totality of the circumstances controls, not just you're trying to have an officer just chase anybody that runs down the road.
Yes.
So one of the things we do talk about, and were you in here for former Sergeant Johnson's testimony?
I was not.
You weren't. But one of the things he testified to, and he said one of the things that Grand Rapids is very specific on, is every traffic stop is an unknown risk.
That's correct.
Okay. You don't know what you're going into when you get into a traffic stop. Anything can happen, right?
Yes.
And one of the concerns Grand Rapids Police has is guns in the car.
Correct.
Guns are, guns on people in the car?
Mm-hmm.
Is that a yes?
Yes, sorry.
Guns under the seat?
Yes.
Guns anywhere in the car?
Correct.
So when you pull somebody over, you got to be worried about a gun if you don't know about it.
Potentially, yes.
So every person in the car potentially has a gun.
Correct.
Let the record reflect on showing opposing counsel with Marcus Peoples Exhibit 36 for identification purposes. Captain, I'm going to show you what we marked as Exhibit 36 for identification purposes. Do you recognize that?
I do.
Could you tell the jury what that is?
This is a mandatory training 19-2. 19 means 2019 was the year we performed this, and 02 would mean it's early in the year, the second training of the year. So it's a firearms training outline.
And so this is, we have a number of training documents where you go through mandatory training for your officers, correct?
Yes.
And this would be training that we've received for the defendant that he took in 2019.
Correct.
His signature's on that.
Yeah, sign in. Yep, sign in right here.
I would move the addition of people to Exhibit 36, Your Honor.
No objection. Okay, 36 is no.
Looking, I believe it's going to be 1, 2, 3, 4, page 5. The one thing I did find regarding foot pursuits is there a Seattle officer-involved shooting?
Yes.
There's a Seattle officer-involved shooting, and in your foot pursuit, what it talks about there is allow for a safe distance and have a plan while chasing an armed or potentially armed subject. Treat someone you pull over as potentially armed. Isn't that what it says?
It does, yes.
So that's the one thing we can find on foot pursuits is that somebody could be potentially armed. You don't go chasing after them because they could be armed. It's for officer safety, right?
It says allow a safe distance.
Okay.
Have a plan while chasing armed or potentially armed. So
Going
we're still
hands
chasing.
on or tackling someone who is known to be armed is bad tactics.
I would agree.
That's what's in the training policy.
That's in the training outline, yes.
Training outline, but that's the outline. That's what you're telling your officers. That's what the defendant would have learned back in 2019.
Yeah, this specific training, correct.
One of the things he also talks about is maybe discontinue with a foot chase and set a perimeter.
Potentially, yes.
So officers are perfectly fine in discontinuing, not chasing after, not mandatorily running after them, correct?
Correct.
In terms, staying with this foot pursuit policy, you are familiar with the International Chiefs of Police, correct?
I am, yes.
The International Chiefs of Police, you're a member of it.
I am.
Your chief's a member of it.
He is.
Both deputy chiefs are a member of it.
They are.
And so they have a foot pursuit policy that they've come up with, correct?
They do, yes.
2019, July of 2019, they came up with a foot pursuit policy, a model, if you will.
Yes.
In that model, don't they say that officer individually chasing a suspect is inherently dangerous?
That's what it says. It does.
You
I'm not
read it?
I'm not exactly familiar with the verbiage of it, but I'll take your word for it, sir.
You know, I looked through it. Well, not exhibit this point in time. If he's not familiar with it, let him read it.
No, I would object to that, that's hearsay.
What?
That
I don't even
document
know,
is-
wait, so it's not, he's not moving for its initiative, he's showing a document to the witness. So, I'm not sure, what is that document?
This is a model foot pursuit policy for the International Chiefs of Police. So you're familiar with it, but you've never read it?
We don't have one, so no, I don't. I didn't. I've read it before, but it's been years. It's been out for 5 years, 6 years. So
I guess you've read it. Why haven't you done anything with it? You're the trained. Why hasn't Grand Rapids adopted it?
The direction of the agency, we don't want a foot pursuit policy.
You don't want a foot pursuit policy.
Correct.
But you would agree that the International Chiefs of Police saying they're inherently dangerous, correct?
Yes, they do.
Would you disagree that they're inherently dangerous?
No.
Would you disagree with their recommendation that at least 2 officers be involved in a foot pursuit?
Ideally,
but they say that's what you should do. Of course, you don't know because you haven't fully read it. Are you familiar with Police Magazine?
I am.
Okay, Police Magazine.
I would just object to all this.
Learn treaties, Your Honor. We can impeach with learn treaties under the Michigan Rules of Evidence
The police
707.
magazine is not a learned treatise.
He can, if he understands it, what it is, he says he uses it. It doesn't have to be.
I didn't say I use it. I said I'm familiar with it.
You don't read it?
I don't read the magazine regularly. I'm familiar with it.
So how is this relevant? We're here to talk about Michigan.
Well, if it's impeachment, is that a learned treatise? I don't know that it is.
Police magazine?
It's something that the police, we heard yesterday, police, you were here for the testimony of our experts. They rely on it, correct?
They said they did, yes.
You don't ever read Police Magazine?
I didn't say I don't read it. I said we don't rely on it for policy advisement or direction.
Don't rely on it for direction. So you just do your own thing then. You don't rely on the International Chiefs of Police.
I'm sorry, I need a rule of the objection, I did want to check MRE 707. Which does allow for the use of learned treatises for impeachment, which includes statements contained in published periodicals or pamphlets. It doesn't have to be a textbook, so I will overrule the objection under that rule.
Police Magazine. Foot pursuits by their very nature are emotionally charged and dangerous events that occur frequently in police work. You'd agree with that, wouldn't you?
I would.
Law enforcement officers must balance their obligation to enforce the law and arrest perpetrators with their personal safety. You'd agree with that.
It's fair.
Unfortunately, that rarely happens. Would you agree with that?
Yes.
More often than not, officers become emotionally captivated by the event and have an instinctive reaction rather than a studied and planned response to resistance and chase without considering the inevitability of suspect capture. Would you agree with that?
It's possible. Yes.
Possible. But that's one of the dangers of somebody's running away, they want to get away, and you rush off and tackle them by yourself. All of a sudden, you got your hands full and you're not aware of it. You're not aware of what could happen next.
Potentially.
And that's one of the things that you teach in Grand Rapids Police in terms of the reactionary gap.
Yes.
So a reactionary gap is the further away somebody is, the better off you are in essence, because you have an opportunity to respond. Is that a fair? I'm not.
Sure. At times in a situation, yes.
Situation. But as soon as you chase somebody and tackle them, you close that reactionary gap.
Yes.
And that kind of goes back to the 2019 outline of the foot pursuit thing, that if somebody's potentially armed, all of a sudden you tackle somebody that's potentially armed, you could be in a world of hurt, right?
Correct.
Okay. What we'll do is we'll break for the day, because it's 4:45. And so again, please leave your notes upside down in your chairs. And remember that you're not to discuss the case at all with each other or with anyone else. Also, continue to avoid any news reports in the media and in social media. And what we'll do is return and resume testimony tomorrow morning at 8:30.
That's fine. I'm sorry, I thought you said anything further, I'm sorry. I thought I heard you.
Okay, so what we're gonna do is recess for the evening. Is there anything you need to address before we recess?
Nothing from you. Another question.
I do want to state for the record that there was a question that a juror asked that was not asked. And it really wasn't a question. I did say on the record that it wasn't a question. The juror was simply pointing out that there was an exhibit still on the witness stand. Didn't know if it mattered. So it wasn't really a question, but I did want to place on the record because it was clear on the record that the juror did have a question and it was never addressed on the record. So there's that. And if there's nothing else, thank you very much for this.
Thank you, Your Honor.
And we hope to be in recess until tomorrow morning at 8:30. All right, please.
All rise.
Thank you, you may be seated.
If you're just tuning in, we're wrapping up day 3 of the trial of Christopher Schurr. We saw a lot today, including not only a
Woo! What in the world just happened? He's out on bond. Yeah, he's been out. Someone got us a new cameraman. I know we need something. I'm sick to my tummy with it.
Hello. I thought I would join.
Who are you? Who's this?
I'm the owner of this house.
Of this house.
Of this house.
Well, I have exorcised the demons today.
Have you? Hello, everybody. I'm back. I've been here. I've been doing some investigations because you guys know how I am. This trial is finishing. I'm already on to the next one. I'm trying to find the next one trial. I have one, but I need a feed. So trying to solve that for us. But yeah. The owner is here. Hi, Case One.
Before I get out of here for the day, I promised that I would do one thing.
Oh no, you're staying here with me until the end. We'll ride or die together.
This is the end. So I'm gonna put you. This is the end. I'm going to play a song for us, and then you can talk about what you want. Because 8.5 hours later, girl, we're out of here.
We out of this point.
It's been an awesome day,
One
though.
sec. Hey, guess what? We can hang out with us tomorrow because there's no Karen Reed tomorrow. So you can hang out with us tomorrow. Hopefully, if you want to. I'm not saying you have to, but just saying.
What case are you looking to stream next?
The Alexandra one. I really, really want to find that one. It's really bothering me that I can't find it.
Oh,
so, yeah.
All right. Here we go.
You're always online, chasing the thrill. In the dark corners where nightmares are real. Whispers and shadows, stories unfold. Innocence lost and the secrets they hold. Reach out and touch grass. Leave the screen, step outside. Reach out and touch grass. Feel the earth, feel alive. Sensational headlines, the dramas you'll muse. Capturing moments, the heartbreak you choose. Behind every story, a life to reclaim. Remember the human, not just the name. Reach out and touch grass. Leave the screen, step outside. Reach out and touch grass. Feel the earth, feel alive. Spotlights glow, don't forget to breathe. Disconnect to reconnect, it's okay to leave. Step away, take a break, find some peace of mind. True crime and drama, but balance you'll find. Reach out and touch grass. Leave the screen, step outside. Reach out and touch grass. Feel the earth, feel alive. More than stories that keep you up at night. Ground yourself, find the light, everything's alright. Reach out and touch grass, you'll be just fine. Breathe deep, step away, it's your time to shine. Reach out and touch grass, leave the screen, step outside. Reach out and touch grass.
Wow, that is actually good. You need to send me that. We need to add that on our playlist ASAP. So we definitely, because we do need touch grass and smoke it sometimes. Sorry. swear I haven't been smoking anything.
Is it legal over there?
No, it's illegal.
Oh,
But,
yeah,
you know,
here
I
too.
like living dangerously.
Living on the edge.
Always.
I'm gonna
Always.
rename you to Katya Edge.
But to be fair, I'm always using my VPN to pretend that I'm in the US. So I might as well say, oh, you know, I was using my VPN. So I was pretending that I was in the US and it's legal over there.
Gotta do what you gotta do, I suppose.
Exactly. You got to do what you gotta do. But no, definitely that I think that's gonna be one of the first things when I touch ground to where Paula is. At least I know it is legal there. I'm gonna be smoking.
You're gonna be smoking. Well, okay. I'll keep that in mind.
No, you keep that in mind. No, I'm joking. And this is a very safe place. But no, jokes aside, it's a very important song because the issues that we do cover in this channel and in many other channels across the true world crime community, it is a very heavy subject. So if you ever have to take a step back, touch grass, go outside, go watch something funny or anything, please do. Your mental health comes first, your health comes first, your sanity comes first. We'll always be here, so one way or another you can always come back. So just
Well,
just
with
getting serious up in here.
with that being said, I am going to take my leave and let you say goodbye to your people now that it's the end of the day and you're back. So I really appreciate everybody today. I really appreciate Rubber coming up and helping me
Amen,
out for a
yeah.
couple of hours. Rubber has a feed coming up at 5 o'clock Central, which is about a half an hour from now, I believe.
You know what I'm gonna do? I'm gonna redirect us after this live finishes. I'm gonna redirect us to Rubber. I just need to find I need to find a video. There we go. So after this video finishes, do not go anywhere because you should be automatically redirected to Rubber. When you go there, leave your like, say hello to her. She deserves it. She is a great friend. Subscribe if you haven't, because I'm watching. Zio, thank you very much. Oh, she's already left. I was gonna say thank you very much, Zio. Thank you very much. For hanging out with us. Thank you, Robert. Thank you, Zio. I really, really, really appreciate that. Let's go support our girl, Robert. I'm out for the night. I'll see you on the flip side. I'll see you tomorrow, bright and early. About 9 o'clock ish Eastern. So I'll see you all tomorrow. Have a good night, afternoon, evening, wherever you are. And I'll see you tomorrow, guys. Love you. Bye.
And I'm a real-time crime professional.